सुनावणी सुरू होईल का की स्थगिती कायम राहील या सगळ्यावरचा शिंदे सरकार
Let me just give us a broad framework. Just broad framework. What the issue is the following. Kindly don't refer to any paperwork. I just explained to you about it. But this all started on the 20th of June, when in the course of the MLC elections, a seat that should have come to the Shiv Sena, we lost to the other party. That happened on the 20th of June. So on the 21st of June, the meeting was called of all the legislative members of the party, and many of them did not attend. And
मुद्दे मांडा अशा प्रकारच्या सूचना ज्या आहेत त्या घटनापीठानं दोन्ही बाजूंना दिलेल्या आहेत. शिंदे यांच्या वकिलांना सुद्धा दिलेल्या आहेत आणि शिवसेनेच्या वकिलांना सुद्धा दिलेल्या आहेत. शिवसेनेचे वकील कपिल सिब्बल युक्तिवाद करतात. शिवसेनेकडून कपिल सिब्बल आणि अभिषेक मनु बाजू मांडतात.
So obviously, they're obviously not in tune or in alignment with the party itself. So we said that if you do not attend the meeting, there will be consequences. Now, this continued. They did several things between 21st of June. And ultimately they said that we said, okay, since you have not participated in these proceedings, we remove you. I won't go into the dates. I'm just broadly telling you, Lord Smith. And ultimately, they were removed from the post that they occupied in the Legislative Assembly itself. They in turn said that you are no longer a leader of the party. We have our own whip now. They appointed their own whip later. Those all things happened between 21st of June. And then ultimately, on the 29th of, we filed disqualification applications on the 29th of June, which is a very important day. No, hold on. On the 29th of June, which is a very important date. But on the 29th of June, they came here and they wanted to form a separate government in alignment with the BJP. And so, this court, we challenged all that, and this court passed an order on the 29th of June.
आपण बघतोय सत्ता संघर्षाची सुनावणी सुरू झालेली आहे. लाईव्ह प्रेक्षेपण सुरू आहे या सुनावणीचं. या सगळे अपडेट घेणार आहोत. एक छोटासा ब्रेक घेऊया. पहा फक्त साम टीव्ही.
कारवाल्या काय चाललंय?
अरे देवाला साकडं घातलं, यावर्षी चांगलं दूध मिळू दे.
अरे नुसतं साकडं घालून कसं चालेल? चांगलं चुंगलं खायला दे की त्यांना. आता हे बघ, द कुटे ग्रुपचं तिरुमला ॲग्रो पशु खाद्य मिल्की एक्सेल, यात प्रोटीन आहे, फायबर आहे, योग्य प्रमाणात फॅट्स आहे, पशूंना पौष्टिक आहार मिळतो आणि दुधाचं उत्पन्न बी चांगलं मिळतंय की रे. तिरुमला
नंतर सत्ता संघर्षावरच्या सुनावणी संदर्भातली एक महत्वाची बातमी. कोर्टाला घटनाक्रम कपिल सिब्बल सांगतायत. 20 जूनला बंड सुरू झाला असं सिब्बलांनी कोर्टाला सांगितलं. एकंदरीतच सत्ता संघर्षावर सुनावणी सुरू झालेली आहे. निवडणूक आयोगाला सुनावणी करण्यास परवानगी देणार का कोर्ट हे बघावं लागणार आहे. तर कोर्टाला घटनाक्रम कपिल सिब्बल यांनी सांगितलेला आहे आणि त्या सगळ्यामध्ये आता चिन्ह कुणाचं यावर निर्णय होण्याची शक्यता आहे. त्यामुळे निवडणूक आयोगाकडे सुनावणी वर्ग केली जाते का पक्षासंदर्भातले याचिकेवरची हे बघणं सुद्धा अतिशय महत्त्वाचं ठरणार आहे. काही वेळापूर्वीच या सत्ता संघर्षावर सुनावणी सुरू झाली. शिवसेनेचे वकील कपिल सिब्बल हे युक्तिवाद करतात. एकंदरीतच बंड कधी झालं त्यापासून नेमका घटनाक्रम काय आहे याची माहिती कोर्टाला कपिल सिब्बल देताना आपल्याला पाहायला मिळत आहे. त्यामुळे आता याचिकेवर घटनापीठासमोर आता सुनावणी सुरू झालेली आहे. महाराष्ट्रातल्या सरकारचं भवितव्य, शिवसेनेचं भवितव्य सुप्रीम कोर्टामधून जो निर्णय येणार आहे त्यावर अवलंबून असणार आहे. अनेक कायदे तज्ज्ञांचं असं मत आहे की जी देशाची राज्यघटना आहे, देशाची घटना आहे हे सुदृढ करण्याचं काम सुप्रीम कोर्टाचं आहे. त्यामुळे या महाराष्ट्रातल्या केसवरचा जो निकाल येईल तो सगळ्यांसाठी दिशादर्शक असेल, लोकशाहीसाठी दिशादर्शक असेल. जगभरामध्ये देशाची जी लोकशाही आहे, आदर्श लोकशाही म्हणून भारतीय लोकशाहीकडे बघितलं जाते. त्यामुळे ते अधिक सुदृढ होण्याचं काम आजच्या निकालामुळे होईल असं सुद्धा अनेक घटनातज्ञांचं मत आहे. साम टीव्हीशी बोलताना अनेक कायदे तज्ज्ञांनी अशा प्रकारचे मुद्दे मांडलेले आहेत. कोणत्या मुद्द्यांवर सुनावणी होऊ शकते? स्पीकरच्या विरोधात अविश्वास नोटीस दाखल केली असेल तर उपाध्यक्षांना आमदारांना अपात्र करण्याचे अधिकार आहेत का किंवा ते राहतात का? अपात्रता प्रलंबित असताना विधिमंडळातील कामकाज वैध आहे का यावर सुद्धा सुनावणी होईल. अध्यक्षाला नेता किंवा व्हीप ठरवण्याचा अधिकार आहे का? पक्षाच्या अंतर्गत निर्णयांमध्ये कोर्टानं लक्ष घातलं पाहिजे का? सत्ता स्थापनेबद्दल राज्यपालांना नेमके कुठले अधिकार आहेत? राज्यपालांच्या अधिकारांना कोर्टात आव्हान देता येतं का? निवडणूक आयोगाला पक्षातील फुटीवर निर्णय देण्याचा अधिकार आहे का? निवडणूक आयोगाच्या अधिकार क्षेत्रावर सुप्रीम कोर्ट निर्णय देऊ शकतं का?
एकाला पकडायला 7
आपण पाहतोय महाराष्ट्रातल्या सत्ता संघर्षावर सुनावणीला सुरुवात झाली आहे। कोर्ट नंबर 2 मध्ये सुनावणीला सुरुवात झाली आहे। शिंदे 19 जुलैला पहिल्यांदा आयोगात गेले असा दावा आता सिब्बल यांनी केलेला आहे। सिब्बल यांचा युक्तिवाद सुरू आहे। पहिले 29 दिवस निवडणूक आयोगाकडे गेले नाहीत असाही युक्तिवाद सिब्बल यांच्याकडून करण्यात आलेला आहे. आणि या संदर्भात बोलण्यासाठी आपले प्रतिनिधी शिवाजी काळे आपल्यासोबत जोडले गेलेले आहेत. शिवाजी, आता सुनावणीला सुरुवात झालेली आहे, सिब्बल युक्तिवाद करतायत, काय नेमके मुद्दे मांडले जात आहेत?
निश्चित आता सर्वोच्च न्यायालयामध्ये काय नक्की मुद्दे मांडले जाते या संदर्भात सर्वोच्च न्यायालयातील वकील ॲडव्होकेट विशाल सोबत आहे, त्यांच्याशी आपण जाणून घेणार आहोत. नक्की सध्या सर्वोच्च न्यायालयात काय घडते, कोणत्या मुद्द्यावरती युक्तिवाद सुरू आहे?
सध्याचा युक्तिवाद जो सुरू आहे तो अत्यंत दोन महत्त्वाचे प्रश्न आहेत. त्यामध्ये पहिला प्रश्न आहे की इलेक्शन सिम्बॉल कुणाकडे गेला पाहिजे आणि त्या इलेक्शन कमिशन समोरच्या प्रोसिडिंग ज्या सुरू आहेत त्याच्यामध्ये आणि जे आज सुप्रीम कोर्टामध्ये डिस्क्वालिफिकेशनचं प्रकरण आहे याच्यामध्ये काय साम्य आहे आणि काय विरोधाभास आहे. तर त्याच्यामध्ये कपिल सिब्बलांचं आर्ग्युमेंट असं आहे की त्यांचं म्हणणं आहे की इलेक्शन कमिशन समोरची जी हिअरिंग सुरू आहे त्याचा इलेक्शन सिम्बॉलच्या केसचा आणि डिस्क्वालिफिकेशनचा काही एक संबंध नाही आहे. कारण जरी ते लोक डिस्क्वालिफाय झाले तरी ते इलेक्शन कमिशन समोर जाऊन बोलू शकतात किंवा ते त्यांचं मत मांडू शकतात. त्यामुळं डिस्क्वालिफिकेशनचा जो विषय आहे तो वेगळा विषय आहे आणि पक्षाच्या चिन्हाचा एक वेगळा विषय आहे. ज्यावेळेस इलेक्शन सिम्बॉलचा विषय येतोय त्यावेळेस महत्त्वाची गोष्ट अशी येते की लेजिस्लेटिव्ह पार्टी जी असते, जी पार्टी रजिस्टर्ड आहे आणि पार्टीच्या रजिस्टर्ड लोकांचं जे काही
So therefore, the moment you increase the seats, naturally it gets cushioned, correct? What your submission is that after the effect of the amendment and increase, the seats are reserved, then there will be equality at the level where it was prior to the amendment and post the amendment.
Yes, and they are actually benefited in addition.
But it may have happened in a particular fact situation, so therefore we'll note that. Any other submission, Mr. Biju?
My lords, now come to page 14.
Page 14.
My lords, page 15.
You have already taken 10 minutes.
Yes,
extra.
I finished, my lord.
Therefore, yes.
My lords, page 14 to 16 says that government also decided to increase the seats and appointments are there.
Yes.
And this is what my submission, my lords. Ultimately, my lords, again, I may submit that, my lords, this is not a case of affected their fundamental rights. Writ to jurisdiction 32, I request my lords, with utmost respect, my lords, I filed so many petitions, Devadasi case, Trado case, so many. I was getting a call from the registry that this has not been followed. These guidelines has not been followed. I don't know how these 55 writ petition numbered, what is their prayer, etc.
Mr. Biju, argue on merits, correct? Yes.
No, my lord, no, not followed the guidelines. That's it, my lord. So therefore, my lord, ultimately, my submission is that, my lords, the Sindhu Commission, adequate representation and these poor people. And accordingly, they have to get some kind of accommodation according to the Constitution and fundamental rights. Their rights may be protected. With utmost respect, my lord, I am grateful, my lord.
Thank you. Thank you.
Be patient here.
Thank you.
Grateful.
Can I have only 5 minutes?
Yes.
Some development, there's something which has come to my notice, that
Yes.
I am duty bound, my lord. Lord, I undertake to place this in e-copy format as well as the bound format. It's only one page. Therefore, my lord, right now not in a bound format. Because as my lord, I have indicated that the government as a sovereign is responding to the wishes and aspirations of.
My lord, I am going to another page.
Oh, yes.
Aspirations of several, my lord, and this is what, my lord, we have tried. Para 3, my lord, 1 and 2, your lordships can ignore. It is submitted that contemporaneously with the constitutional amendment, a decision was taken in order to ensure that the seats available to the reserved category and the open category are not impacted in absolute numbers. The Department of Higher Education issued orders on 17 January 2019 to all central educational institutions to increase the intake in all branches of study to provide 10% reservation to economically weaker sections while protecting the proportionate reservations for scheduled caste, scheduled tribe and other backward classes, and also not reducing the seat availability in the general category in absolute numbers in the year 2018-19. It is submitted that as per the calculations done in this regard, in order to provide 10% reservation for the economically weaker sections without adversely impacting the proportionate representation reservations to the SC, ST and OBC categories and not reducing the seat availability for the general category in absolute numbers as compared to admissions made in 2018-19, the total increase in intake has to be increased by approximately 25% over and above the intake in 18-19. It is submitted that a total of 2,14,766 additional seats were approved to be created in the central educational institutions, and an expenditure of rupees 4,315 crore was approved to be incurred to improve the infrastructure in the higher educational institutions. This is proportionate. Not saying.
Solicitor, correspondingly, I would like you, not right now, to give the data over a period, maybe.
Your Lordship's can.
Yes, give the data about the number of scholarships available to all people. Number of scholarships. There is a scholarships portal. What I have been able to get is a very limited. What is the kind of scholarship that you give for medical, engineering, and other professional courses, which are the subject of these central universities? The quantum of these per capita, scholarships, because we are looking at people, whether it's this or that doesn't matter. The poorest of the poor in all categories, ultimately, when they get in, what is the fee that they pay? What is the aid that the government gives? Because that is an important component also of affirmative action.
But since it has fallen from your Lordships, it's my duty to, my Lord, provide that detail. Though I very emphatically would respectfully submit that those figures and statistics would be relevant for the Parliament to take a decision whether to provide for this or not.
No, you are right.
May not have any
No.
impact on the constitutionality.
No, you are right. We want to know. For instance, the National Scholarships Portal says that for a higher education, 82,000 scholarships are given throughout the country on economic basis. And there is a separate one for SC, ST. And well, I will not get a substantial amount is given, which is about 10 or 12,000 a year. Now, similarly for professional colleges or management colleges, what is the figure for even these EWS people to ultimately you're talking of the poorest of the poor or just marginally above that?
Poorest of the poor who are otherwise not getting any reservation benefit.
No,
Number
who are getting scholarships. So I just want to know.
My Lord, it has fallen from your Lordships. It's our duty. We shall place.
Yes.
But that since they are getting benefit, why give them reservation?
No,
Maybe
please.
a policy issue, not a constitutionality issue. That's all.
Mr. Solicitor, we are aware of what we are looking at.
No, your Lordships are aware, more than aware, my Lord. Even, my Lord, this affidavit, my Lord, absent this affidavit, it would not mean that the constitutional amendment fails. And with this affidavit, it would not mean that constitutional amendment is constitutionally valid. This is to satisfy your Lordship's conscience. If, my Lord, there is some my Lord, doubt that this might have an impact on the general candidates who are otherwise meritorious. And if your Lordships have any doubt that these are three silos, three separate zones, and if your Lordships were to take a view that poorest of the poor, even in the first reserved category, should be shifted. Well, the economically weaker section, 10% should go there. It would result in two things. A, double reservation in the first category. And B, it would substantially amount to amending the constitution beyond the intent of the legislature.
Very well. Thank you, sir.
And a scholarship would also be merit-based as well as, my Lord, need-based. I'm, my Lord, subject to the verification.
Sure.
And last request, my Lord, the learned AG wanted to place a note. My learned AG has not placed any note. My Lord, which we will file it by tomorrow. My Lord, he is in the process of preparation. I'm seeking my Lord's leave. It would be your Lordship's question and, Lord, possible answers on behalf of the government on constitutional. Lord, I'm grateful.
Thank you. Yes, Mr. Ravin.
the legislature party. The definition of that. One thing. Legislature party in relation to a member of a house belonging to any political party in accordance with the provisions of paragraph 2. Paragraph 4 means, paragraph 3 is omitted if you notice. Means the group consisting of all the members of that house for the time being belonging to that party in accordance with the said provisions.
Member of the house is also. Member of the house is very important. And it says, it uses the expression member of a house and member of that house on two occasions. So legislature party in relation to a member of a house.
Correct.
Belonging to any political party.
That political.
So it distinguishes it says any political party in the first part.
Yes.
So the definition distinguishes between a member of a house belonging to any political party.
Correct.
With the group consisting of all the members of that house for the time being belonging to that political party.
Correct. So, Malad, if it is Shiv
And
Sena,
group of that house.
if it is Shiv Sena, it is Shiv Sena. If it's BJP, it's BJP. Because they have fought the election on a BJP symbol or a Shiv Sena symbol, and therefore they belong to that political party.
So we'll really have to then look at what is the ambit of the disqualification provisions and then contrast it or see if there's an overlap with the 1968.
That's the exercise. That's why I said that if ultimately we have to decide all this, we are really going into.
So really the ambit in our eye is short. According to you, one does spill over onto the other. You can't decide that as the election commission without having to comment on the disqualification, which is an issue pending before the Supreme Court.
This is the point.
That is the point.
Now, can we see
Now let's see 2-1.
Yeah, no. First see original political party, not 2-1.
1C.
1C. Original political party in relation to a member of a house means the political party to which he belongs for the purposes of 2-1. So he belongs to the Shiv Sena. He is under the discipline of the Shiv Sena, under the control of the Shiv Sena, within the house. He has no other persona. Can't be a faction.
Being a member of the political party,
Yes,
he is a member of the house.
that's good.
So the relationship is with respect to his membership in the house.
With reference to the political party which set him up as a member. That's correct.
But the
So, in fact, brother, this is the first time in the Constitution that the term political party is used. Nowhere else in the Constitution
first time.
you find that expression. Now,
In fact, the classical books on constitutional jurisprudence in India all mention that the expression political party has not been defined anywhere at all.
correct. Luckily, we know something
It's first time it is in the symbols part, which predates 10th schedule.
Now, see Malaz 2-1. Subject to the provisions of 4 and 5. Again, Malaz 3 is missing. a member of a house belonging to any political party, again the word any is used, shall be disqualified for being a member of the house if he has voluntarily given up membership of such political party, not the house. If you're asked an example, I belong to one party, I've been elected on the symbol of that party. I go with a leader of another party to the governor and say, meet him and say, please call the house for the purposes of determining who has the majority. Just give you an example. That act alone will visit me with consequences under 2:1. Plus, your lordship must.
Yes, it will go. Look at it from this angle. If there is a disciplinary proceeding against a member of a political party, if disciplinary proceedings against the member of a political party and the political party expels him, what is the bearing of that so far as his presence in the house? In Amar Singh, they said he sit only as an unattached member.
Yes, unattached.
So therefore, whatever happens in the political party will have no bearing on his position so far as the house is concerned. So he continues to sit as an MLA, but as an unattached member.
Yes.
So therefore, where does the convergence of symbols order and 10th schedule?
Well, that will not impact the symbols order at all.
No, I'm saying where does that will not impact.
Yes.
But political party's decision is not impacting 10th schedule. And his removal from the party.
Removal is not voluntary. This is the problem.
That's right.
Yes.
But still his presence as a MLA continues.
Even if he's disassociated from the party, he doesn't have to follow the whip of the party because he's been thrown out. So he's not subject to any discipline of the party. Because lordship will appreciate that when I am thrown out of the party, it's not my voluntary act. I am thrown out by virtue of the fact that the party does not want me for any reason. But the party can proceed for disqualification against me, but they don't do that. So the speaker then says that because you've been thrown out and I've been informed by the whip of the party that you are thrown out, therefore I'll give you a separate seat and I'll call you an unattached member. Then I am not subject to the whip at all. But then 2:1 he will not come.
Ironically, expulsions are welcome because expulsion doesn't disqualify you. You sit separately, you are expelled. So that is welcome rather than to proceed against disqualification.
No, the question is how it would, Mr. Sibal, the question is how it would, the disqualification would have effect on the symbol order, deciding the dispute with respect to symbol.
No, but I am member of the original political party. I have been elected on that symbol. I continue to be under the discipline of that party, which are otherwise, it has just huge consequences. Any assembly any government can be thrown out. Any government can be thrown out in this fashion. What is the constitution meant? People go to the governor and throw out a government which is duly elected by the House, by the people of the country. Is this how the 10th schedule is to work? I have never heard in the democratic world that an elected government for a period of 5 years through these machinations is toppled. Why? Because we are discussing some academic issue about jurisdiction of the election commission. See the heart of the matter. Where is this democracy going? Any government can be thrown out. And then what happens is that you have your own speaker. He will not decide the petition, the disqualification petition, and you merely.
Now, Mr. Sibal, we have looked at the provisions of the 10th schedule. Could we now go to the powers of the EC? We'll so that we have to see the two sets of.
Just allow me a little.
Yes.
So, therefore, 2:1A deals with giving up voluntary membership of the party. And 2:1B, if he votes or abstains from voting. in such house contrary to any direction issued by the political party. So, brothers, I am the whip. The whip says you have to vote for the speaker, this candidate for the office of the speaker. They vote for a BJP candidate. Now, all this happens after 29th, which is all the subject matter of this court's order. Which he belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party. Person or authority and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So if somebody votes contrary, it can still be condoned by the political party. What it tells you is that the political party is in control. See the expression, condoned by such political party, not by a member of the House or of the Whip. Well, that's kindly appreciate it this way. Legislative members of a political party function within the overall control of the political party. They are representatives of the people. They are not independent of that party. So the political party will then communicate to the chief whip, condone what he did. I mean, he didn't vote for us, doesn't matter. We don't want to take any action against him. Or he didn't come for voting, doesn't matter. It happens many a times. But there's an umbilical cord link between the member of the legislature and the political party. They're not separate issues. There are issues that your lordships will have to decide, which is what I said. Ultimately, those decisions will have to be taken by your lordships in the overall context. It can't possibly be, assuming whether your lordships were to, your lordships were to allow the election commission to go on, proceedings to go on. Some decision is taken. Let's assume that. Right? And in the meantime, these proceedings take place and he is disqualified. What's the consequence? These are issues of great moment for our democracy. Can we see, Madam? Explanation. This is also important. Explanation for the purposes of this subparagraph means an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. He can't say that I am a different faction now. He can't say that. Now, the next point I want to urge before your lordship is this. Any defense of a member of a legislature belonging to a political party for the purposes of protecting himself from disqualification can only be available under the 10th schedule and in no other form. If I move for disqualification, which I moved much earlier, he will have a defense under the 10th schedule. He cannot seek a declaration. And his only defense under the 10th schedule is a murder. There is no other defense available under the 10th schedule. Now, it is the admitted position that there is no budget. So he has no defense. Till the 19th of July, when he went to the Election Commission, he has no defense. Now he wants to, what does he want to do? He wants to go to the Election Commission and say that I am the political party. But much before that, his acts and the legality of his acts as a member of the House and as a member of the political party are in question, which has to be decided in these proceedings. What he does is, he says that I am 40, 39 plus 1, Eknath Shinde plus 39. I am a majority in the legislative wing of the party. Therefore, I don't recognize it. What he's saying. That he can't do under the 10th schedule.
Yes, Mr.
No, it's one point. Now your lordship asked me, what is the relationship between this and the symbols order?
Right.
That's come.
Where is the symbols order?
Yes.
1868. ये compilation भी होगा.
Now see the symbols order. Para 15.
Sure. Have you next it in your
Violation of statutes.
It's in our written submission.
It's in your written submissions? All right. Yes, there's a compilation by the Election Commission. Murari bhai, आपको मिला?
Page आप 493.
हम थोड़ा उठेंगे ना क्या?
Yes.
सुनो.
Compilation.
When we wait.
A compilation of statutes for us, rules and research materials.
Yes.
That has everything.
You got compilation of documents from the Election Commission also.
Sorry?
Yes.
But
Very
सुनो. iPad this.
Two of our convenience compilation. Compilation of documents in 35.
Para 15 can be taken from several compilations.
Para 15 is there. That are in your written submission, para 3.2.
And also para 9, lordship may kindly see. Para 9 at page 5.
It will remain the same. Change. Para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct.
Well, actually, I have the copyright.
All right, we'll read paragraph 15.
Now see, when the commission is satisfied on information in its possession,
Saam, 1 minute.
is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the Commission shall be binding on all such rival sections or groups. So let me, Millers, put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House, they go to the Election Commission and say, we are approved. Election Commission can decide.
1 minute. So.
Now let's see at what point in time does paragraph 15 operate? On the date when he files this application, it is 19th of July. Correct, Mother? Can't be before that. Even if the Election Commission were to decide, it could only decide on 19th of July when he moves the Election Commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and whether he voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the Election Commission? And the Election Commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Mulats, of paragraph 15 operating at all in this case? Therefore, Mulats, to say that paragraph 15 is operative and is independent of all this, Mulats, with the greatest respect, Mulats, is contrary to the very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The Election Commission of India will decide much later. The question
yes. Mr. Zippel, what's the next point now? We've got this part of this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Surely, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it would not be sitting here. 2, what's the balance of convenience today? That so far the Election Commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all. There is no stay of BMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
When they produce the order, there is no stay.
The best of all, hold on. There is no stay today. The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court?
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP?
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Bagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with the learned friends are thoroughly good.
It's totally wrong, Manoj. PMC elections, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appealing in that matter, so he doesn't know.
No, I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, Manoj. That order we have placed, Manoj, in our return submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure. But the matter tomorrow is about the OBC. We'll hear you, Mr. Yadnani, we'll hear you. Let's follow some more. Yes. All right.
lot of enthusiasm, moreover. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordship's brothers, and it will determine all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then the irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. Was to be. Without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that. So, anything else, Mr. Sibal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Well, there are 8 petitions. I am appearing for the
Yes.
parties, but who are on this side versus that side.
And you will be characteristically brief, Mr. Dr. Singhvi.
I'm grateful for the word characteristic.
Correct.
Your Lordship has rendered me speechless before I started. May I be very pointed. Well, your Lordships has 4 points in the 10th schedule. The issue is narrow. Whether your Lordships on a...
Can you just formulate the 4 points?
Before I let me leave that. Today, your Lordship is not hearing the matter.
Right.
Today, your Lordship is deciding the correct balance of convenience to endure till such time after Diwali, your Lordship hears the matter and renders judgment. That's the only issue today. Now, for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I will demonstrate that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Doctor.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your Lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the Election Commission and the matter will not go on. There have been 3 dates in between, from then to now, including one coming up later this week or next week. So it has been adjourned. That was the Lordship understanding. Of course, subject to Lordship certification today, no doubt.
Till the application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements of the 10th schedule, which Mr. Sibal has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving Lordship original political party, and sometimes they say political party in the same context. If your Lordship sees 1C without reading it, it's been read to your Lordship, just keep it open with us. Then 2(1)(a), and these are the operative provisions. then explanation, so 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You have to look at the sub clauses. Then 2 bracket 2, then 4 bracket I, and many times in clause 4. Now, Willis.
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
Yes, yes.
Just as a matter of curiosity, I mean,
Yes.
nothing really would turn on this.
Well, it's when they say.
It's in 4. It's in 4. 4. 4.
4 in the merger.
Where is original political party merges with another?
The political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea, in a minute, I'll come to it. It's the same concept. Now, Willis, this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
I'm sorry. Yes.
because
So
just help us in.
Yes. Number 2, of the 4 elements, the first is political party, the second, split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big bullet's pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet heard, Your Lordship not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3.
Directly?
That is exactly what the election commission is asked to do in the symbols order.
Okay.
I'm just saying, Willis, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November. Let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative. How irreversible. Number 3. And the statement of objects for this, when we come to the final hearing, will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go, that means it's the new group. That group by itself makes no difference to the 10th schedule. Suppose, let me give an extreme case. Out of 100, 90 go, or 75 go. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merger is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be read. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiv Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. a member of a house shall not be disqualified under 2(1) where his original political party, the question Justice Chandra should ask, merges with another political party and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you want 75 are gone, 10 are left, 25 are left. And
so the people who remain after a merger, their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger, I stay back and I continue with my own.
I'm very grateful, Manus. I'm very grateful. Because, Manus, and quite rightly, it is not their fault. The remaining 10 can't be disqualified because 75 have gone, Manus. So that's a very logical. Now you just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to that.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if they proceed, will be disqualified tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? You are deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Now, you go to the next point.
Just note for one thing. Well, if you are, what happens? Well, there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena, so you don't merge. Had you merged and knocked at the doors, it would be a new political party, subject to numbers. You want the best of both the worlds. Who are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving a coach and four through this. And well, the fifth point is, this thing was enacted, well, 15 years, 20 years after, on the Ayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singh, you're right. Dr. Singh, you're right that the 10th schedule does not recognize who is the real who is the real party? Party A, here the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No. The symbols order, who represents or who is the real party is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only difference is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
One answer is that, assuming it is so, I'm not conceding that, I'm just answering my lot two alternative points. That has to logically follow, not precede.
See, let me tell you, what is really troubling is this.
Yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right? The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election. Right? That, so that is an area where, there is a little bit of a constitutional thought to be done.
The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Sajid. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be prevented, interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of.
I were to appear in the Election Commission in symbol order cases. What they
Now compiling.
Just to give you
I just gave one.
there are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. The lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages.
The
there
old
are
one.
Old one.
The one.
Common convenience volume. Old one.
ये क्या मेन पेपर बुक में है सर? हाँ.
Two or 3 things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get, I think, what exactly are you showing?
I am showing, Willis, in that volume, common compilation volume, the Election Commission notice at 698, page number.
1 minute.
Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July 2022.
1853. 22nd
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I tried to take a technical objection, so still that. Our training is still incomplete. That 22nd July. Now, will it?
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Dr. Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
I'll be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents after.
So, let me be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. Mother, I'm sorry, I'm not able to proceed. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the 2 rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That phrase I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be Willis, about 10 pages out here. PDF page, no PDF. My learned opponents, Willis, filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen here.
I have said anything very seriously wrong, but this is very interesting what they have said. Kindly see 684.
684.
Yes. It's para 23, small Roman 23.
Yeah.
It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader to the next. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
That petition can't be filed. So far, there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Well, the filer, the approacher is Mr. Shinde. He's not a member of the Legislative Assembly. Is he not claiming on the basis of the listed assembly status?
Right. Page 687.
Now, 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislative wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC. 1972, volume 4 SCC. 664.
Now, I think that is the
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only status is that of a supposed MLA of the Shiv Sena, or I will say. Now,
you are now reading Sadiq Ali.
Sadiq Ali, para
I think Sadiq Ali is part of the convenience compilation.
Page 14 of their convenience compilation, the other side, but your lordship will get it in so many forms.
Just give us a moment of
Para 26 there is. As your lordship knows, this judgment has stood the test of time, even though it is
Election
communicating on
Comparison of Election Commission. Yeah, it is right.
I'm great. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship is deciding.
Yes,
that's why I'm not concerned about the final merits. Your lordship is told that it's a North Pole, South Pole apart. It's two unrelated issues. That's what I'm objecting to. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says legislative organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the Election Commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, is very valuable and relevant test. Then, well, they go on. Well, this is, of course, 68 is 15 years prior or 20 years prior to the judgment is prior, but I'm at the moment on the judgment's own terms. Well, can you separate? Can you, you are told that this is unrelated issue. Then, also note para 29, the last 4 lines. majority ballots of houses of parliament, and sum total of members of state legislature. Last two lines of para 29 to save time. Last two lines of para 29. In any case. Last two lines of 29.
In any case.
3 lines. Now this third aspect, symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Mills, your lordship uses this phrase, it has become a commonplace. But there is a lot of weight. Not when the Supreme Court uses it all over, even lower courts. What is the meaning of this subject to outcome? We just say it like that. Your lordship will find the IMD as Supreme Court. Your lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singh, thanks. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your lordship fellows will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase which your lordship finds in 2(1)(a), inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of a schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in actual reality of political life, expulsion is welcome sometimes. It is a welcome. But, if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge, you have voluntarily given up membership. But if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the Election Commission, Mr. Eknath Shinde, who's the sole applicant. There is no other application. Today, your worships can always decide, but today, he is under a cloud, under the simple text of 2(1)(a).
All right, Dr. Singh, thank you very much. We'll just take a short break and we'll be back and we'll hear these.
Balance of convenience of lordship does not have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the all those orders. We can just see those for a moment. That's all that we'll share.
That's a different matter. The option is it exists, is what I'm saying.
This will be installed.
All right.
We direct, there are 3 enough. We direct the parties.
All right.
Thank you.
Yes, yes, Mr. Paul.
Because I very briefly, as we see it, what was the background which led to this litigation starting, and then come to the specific points raised by Dr. Singhvi and Mr. Singhvi. Because around the third week of
Mr. Paul, you appear for
Mr. Shinde and some of the legislators.
yes. Yeah.
Because around the third week of June 2022, a hopeless minority of MLAs within the Shiv Sena decided to convene a meeting, appoint a new whip, remove Mr. Shinde, which they had no authority to do because they did not represent the majority at all. The same day, coming to know of it, the majority of the MLAs met and immediately nullified the appointment of the whip they had appointed, the removal of Mr. Shinde. I am overwhelming majority. But simultaneously, what they did was, a day later, they said that we had convened a meeting on 22nd of June 2022 at 5 p.m. And since these MLAs did not attend it, they are all disqualified. And we, on the same day at 5 p.m., are given a notice. In the meantime, this happened on the 22nd. Before that, on the 21st, the majority faction had already issued a notice for the removal of the deputy speaker, which was pending. The deputy speaker, my lords, on 25th immediately gives a notice to our faction and says, give your reply against your disqualification, because the allegation is you did not attend the meeting as convened, and because you have not attended the meeting, you stand disqualified under 10 schedule. And gives us 2 days to file our replies. Now, this comes to be challenged on 27th of June 2022. Wherein this honorable court says that as an interim measure, time is granted till 12th of July 2022 to file our replies. Immediately after that, MLA's leader of the opposition meets the governor and asks for a floor test. It is at that stage, and the governor issues a communication to the then chief minister, directing him to face a floor test on 30th of June 2022. A writ is filed by Mr. Prabhu, who according to us was illegally appointed as the whip by a minority of the members in the Supreme Court. A direct 32 saying that the governor should be directed not to whom?
A writ under Article 32 by Mr. Prabhu.
Yes, not.
Because he was a whip since 2019. So it's
Sorry, Mr. Prabhu.
He was a whip since 2019.
And as I said, we had removed him, I had said.
Mr. Sunil Prabhu.
Yes, we had removed him on 21st of June. I had said so when I was giving my of events. We had removed him and you had removed Mr. Shinde, which we said was a wrongful removal as minority MLAs. That's what I said.
Right.
Now, my lord, so they find a
Number
direct.
32 is by Mr. Prabhu.
That's saying that no floor test should be held.
Yes.
In view of the fact that disqualification of 42 MLAs is pending. Arguments for over 3 hours are held in the matter, and ultimately the court says that, look, in view of the law as laid down, as we cited, the court has said floor test, if at all, should be held at the earliest. And we said, why should you shy away from a floor test? You can't today say because a disqualification is pending, the floor test should not take place, because there are judgments of your lodges to say, even if a disqualification of an MLA is pending, he is allowed to vote in a trust vote, he is allowed to vote on a floor test, he is allowed to vote on the disqualification of a speaker or a deputy speaker. The proceedings and the function of the House cannot be stalled merely because the disqualification is pending. And those are your lordship's judgments on the point, on the issue squarely. And given the fact that floor test is the surest way to determine who actually enjoys the majority in the House, if at all a chief minister is confident enough, he should be more than eager to play the floor test rather than evade and escape and run away from a floor test. So the court said, and directly said, we do not find any ground to stay convening of the special session. Now, my lords, immediately after that order comes, on the very same day, that evening, when the order is pronounced,
What's the date of that order?
29th of June 2022.
Yes.
On the same day, Mr. Thackrey resigns as the chief minister. Mr. Shinde and Mr. Pandase approach the governor, stake a claim to form the government. Mr. Shinde is sworn in as the chief minister. Then after that, the speaker is appointed. The speaker proves it because they ultimately again challenge the speaker's again appointment and Mr. Shinde's appointment. The speaker is overwhelmingly voted and confidence is reposed. And these are the facts which ultimately led to their all-inclusive one petition which comes to be filed where this IA has. I'm running through some of the other facts which may not be so relevant. So that's the broad background in which they now come up with an all-encompassing writ petition, saying that the decision of the governor to call Mr. Shinde to be sworn in, the floor test, of course, had become infructuous by then because the earlier writ petition, the chief minister had resigned. Then they say the speaker's appointment, etc., all illegal, and the Supreme Court should decide all these issues. Even before the speaker decides these issues, all of these proceedings should be transferred to the Supreme Court and they should be decided. There is no mention in the prayer clause or the writ petition about the election commission. In fact, there are categorical pleadings in the writ petition that the issue of who is the Shiv Sena is the exclusive domain of the election commission. This is their writ petition, where they say the decision as to who is the Shiv Sena is the domain of the election commission. Now, after that, my lords, we approached the election commission. The election commission, looking at the nature of representation that we make, say that clearly there are MLAs on this side, there are MLAs on that side, there are representatives on this side, there are representatives on that side. So obviously a dispute has arisen. And issues them notice to come and file a reply, place the relevant documents before the election commission to take a considered decision in the matter.
Mr. Cole, where did they make this categorical argument that decision should be of?
Yes, yes. Page 8 of our convenience compilation, round D. That petition was filed on 8th of July 2022, but I'll come to the specifics later. So At that stage, when the Election Commission says, come and file the relevant documents before us, we have to proceed as a coordinate constitutional authority and exercise our jurisdiction to see who represents, because this is really an intra-party dispute. No one is saying, our case is not that we voluntarily given up the membership or we are splitting from the party. These are two rival factions within the party. So the EC said, we'll decide as to who represents the Shiv Sena. They come to the court and say, the EC should not be allowed to go ahead. The EC says, the Supreme Court says, we are giving you more time to go and seek time from the EC to file the documents. That request is again reiterated later, and the court again extends time to file documents before the EC. There is no order ever injuncted, and there was no notice issued in this IA to EC also. The order is go and seek more time to file documents. No injunction order ever passed. And ultimately, my lords, when your lordship passes the order of reference to a constitution bench, on the same day, an order is passed saying that the issue as raised in this IA will be considered by your lordships. So it is factually incorrect to say that on repeated orders of the Supreme Court an injunction was being granted, or it was an understanding between the parties that the EC will not proceed with the matter.
Just give me the date on which the Election Commission issued the notice.
Yes, ma'am. 2nd of July, 22nd of July, 2022.
And what is the date of the order of the Supreme Court? No injunction, you said, but only time to file a...
Yes. 4th August. It says, grants liberty to the petitioner to apply for extension of time before the Election Commission.
Yes.
Now, this is the background. And our respectful submission, of course, first is that this IA is beyond the writ petition itself. No substantive petition has been filed.
One short question. The letter of 1st of July 2022 issued by Shiv Sena Secretary for removal of R4, R10, R27 was made to the Election Commission. You will get it 360.
Yes.
So they wrote a letter to the Election Commission saying that we have removed them from the political party. Am I right?
Yes. And even earlier, in June, they had written a letter to the Election Commission informing that they had taken the decision there. And
not expelled from the party, removed from the post.
Correct.
Just not
removed from post.
Position, removed from the position of
Thank
leader in the party setup.
my lord, so all that I am saying is, and I'll now summarize what my points in the law is. The law today is laid down by your lordships on a number of these issues as sought to be now canvassed is no longer essential. One is, my lords, the lordships have categorically held that the jurisdiction of the speaker, when examined under the 10th schedule, is to exercise his power to determine disqualification in the House. The Speaker cannot embark upon, those are the words used by the Supreme Court, the Speaker cannot embark upon deciding a split or a merger within a political party. Secondly, what your lordships have held is that,
except with one caveat, Mr. Kaur, that the whole concept of a split now is alien to the 10th schedule. That's one. Therefore, the reason why the speaker can't decide as to whether there was a split is because the 10th schedule now obliterates this concept, effaces the concept of a split. On merger, perhaps you may not be right because merger is expressly a defense under the 10th schedule, under clause 4. Therefore, whether there has been a merger or otherwise may possibly fall within the ambit.
I'll show some of the other provisions also will still be in the context of the legislature party, not the
that point you have made. That is not the concept.
Your lordships were absolutely right in what your lordships are saying. My submission on merger is only that the speaker's jurisdiction is on the legislature part. That part of subclause 4 of 10th schedule was not read out to your lordships. I'll just read that. Secondly, my lords, your lordships have held that even where the symbols order does not predicate a particular situation or deal with a particular situation, the Election Commission of India, exercising its expansive and the words used are plenitude of plenary powers under Article 324 of the Constitution, is well within its rights to deal with any situation that arises. That is not to say for a minute that I am canvassing that under clause 15 or clause 18 of the symbols order, the Election Commission does not have the adequate power to deal with the situation like that. I'm going a step forward. Even in 15 and 18 were inadequate to deal with the situation that we are dealing with. Your lordships have said the plenary powers are enough for the Election Commission to deal with any such situation. But here, categorically, 15 deals with two rival factions within the party. And 18 covers situations which the Supreme Court has interpreted as interim directions or other orders which may be passed in the interest of justice. And your lordships in Sadiq Ali, while in detail dealing with the symbols order, categorically first dealt with the issue that a situation arises of two rival factions within a party. 15 is squarely the provision which sufficiently empowers the Election Commission of India to deal with it. And then Sadiq Ali proceeded to say that while considering it, both the legislative majority and the political majority will be looked at. But that is the Election Commission of India. A constitution bench of this court has already said that while the speaker decides the 10th issue, 10th schedule, jurisdiction of disqualification, he can't get into the political party because the very nature of the dispute is such, as my lords pointed out today at the start of the hearing, 1.5 lakh, 50 lakh representation by us. Zilla Pramukhs, talukas, district officers. Evidence is led. The powers, as your lordship knows, have been vested, or the power, as the Supreme Court has said, powers of the state, powers of the court on the Election Commission of India. That is the alternative adjudicatory machinery created to deal with each of these issues.
Only thing, Mr. Paul, the genesis of the entire dispute, I think that's really the sense of the submission, that the genesis of the entire disputes arises from what happens on the floor of the House. Right? Absent what happens on the floor of the House, everything else wouldn't have taken place. That's their contention. Now, if that is so, then the issue as to what happens, the symbols order predates the 10th schedule. Sadiq Ali predates the 10th schedule, right? Because Sadiq Ali is in fact Justice Hegde Grover and Justice Khanna.
That's
now Sadiq Ali predates the 10th schedule. Therefore, when Sadiq Ali speaks of the powers of the EC to determine both the legislative and the organizational majority, that the former part, namely its authority to decide the legislative majority, was at a time when the 10th schedule was not in operation. Now, does the fact that the determination of whether or not a disqualification has taken place is now exclusively entrusted to the Speaker, does that to that extent dilute the authority of the EC? And if so, then what is the impact of that decision which is entrusted to the Speaker? That is, I think, what they were really driving at.
So, Manoj, firstly, post Sadiq Ali also, and I'll show those judgments if required. There have been judgments.
No, we've seen those judgments. Which just formulate the point.
Post Sadiq Ali also, which have talked about the interplay of 10th schedule, symbols order. There is nothing to suggest. There is nothing to suggest that any way does the 10th schedule dilute the exercise of jurisdiction under the symbols order 1. We, my lords, the constitution bench of this court categorically says that when you embark upon this inquiry, it is restricted to majority in the House. Because the very nature of inquiry that we are talking about, where a political party is completely beyond the machinery provided for the Speaker or the powers vested in the Speaker. And that is why that whole line of judgments, my lord, where your lordship said powers of the state, powers of the court, all vested in the Election Commission of India. Detailed evidence. Now, will the Speaker get into interacting with every taluka pramukh, every district officer, every president of every area, the registered membership of the party? It doesn't get into all that. There is no machinery for it. That's not the intent. And if your lordship sees everywhere in the 10th schedule, political party in a context and then followed by legislature party, as your lordship pointed out, including clause 4 of 10th schedule. And it is interpreting that a constitution bench of this court says that when you embark upon the journey of deciding on disqualification from a house, don't mistake this for a power to decide the larger political issue or division in the political party, which is there. And I tell your lordship, because inherently it can't be done by the Speaker. And there is nothing today in this matter, my lords, nothing at all as far as the pending petitions are concerned, whose outcome in any way will impact what is pending before the Election Commission of India. I take their case at the highest, that we will all be disqualified as members of the House. I take their case. That's the maximum that can happen, my lords, that we are disqualified as members of the House. Does that stop us? Does that stop us from going to the Election Commission as a member of a political party to claim that we represent or we are the Shiv Sena?
But suppose you were to argue on a demurrer, assume for a moment that the person who has moved the EC is disqualified. All right, for a moment on a demurrer. Does that disqualification of the person who has moved the EC impact upon either his locus or the authority of the EC to determine who really represents which of the two factions represents the party?
So Mara, that's a very pertinent question. Let me So, my lords, the question that my lords put to me, let me give your lordships two stages which can answer. One is what is happening here, and the other is what your lordships put. One is that disqualification petitions are pending. The Supreme Court has told the Speaker on their request not to, in the meantime, take any decision on those because the Supreme Court was seized of the matter as far as the Speaker's exercise of jurisdiction is concerned. And pending those petitions for disqualification, can an MLA or an MP be prohibited from approaching the election commission? Your lordships in any number of judgments have said that even when disqualification petitions are pending, an MLA and an MP is well within his rights to participate on the proceedings of the House. Vote, exercise all that is vested in and under the Constitution.
So until he is disqualified, the consequences don't attach at all.
Absolutely,
that's the rationale for it.
One, and including my lords,
yes,
including the line of reasoning that your lordships took.
Yes.
In Nabam Revia, that
yes,
that if a deputy speaker or a speaker of membership, that he can always proceed in a direction where his own disqualification, that was another link, would be accordingly impacted. So till I am disqualified, I continue to be a member to participate all its vigor and robustness in the proceedings of the House.
At page 359, that very question. This is a letter written by Uddhav Thackrey to Eknath Shinde saying that you have been indulging in anti-party activities and have also voluntarily given up your membership in Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So this doesn't affect his primary membership. As if his primary membership is actually affected, then he can't maintain a petition before the election commission. That's perhaps their argument.
Yes.
So therefore, at the threshold, election commission cannot maintain a petition on his behalf. But it is, if it is not affecting the primary membership, it is only a post he continues to be a member of the political party, then he can perhaps file.
And my lord, just to add to what your lordships are saying, this is their contention that I have given up. My whole case is who says I have given up the membership voluntarily. Otherwise,
that is yet to be considered.
That absolutely, that is yet to be considered. My whole case is that a set of 14 MLAs decide that I am removing something and overwhelming majority is on one side. You take a unilateral decision with a hopeless minority and then say, I've disqualified you or you voluntarily given up a membership. We have repeatedly said that we are the Shiv Sena, whether it's in the Lok Sabha or it's at the Legislative Assembly. We represent an overwhelming majority within the party. We've never said we've left the party or we need to merge with someone under 4 to be protected. We have right through said that whatever actions a set of people who are in a hopeless minority took have no sanctity of law, are unsupported by any legal provision at all, and you could not have done, you did it without authority. So with such emphaticness, when it is said that you voluntarily gave up the membership of the party, who will decide this? Because you say I've given up voluntarily the member under 10 schedule, or will the speaker decide it under the 10 schedule? Because your lordships have held that the power of the speaker and the decision of the speaker under clause 6 of the 10th schedule is final on these matters. And that decision is still pending. My lords, was the question that your lordships put to me, that suppose a person, now this is the first case where no decision has been taken, the issue is pending. The other is I am actually disqualified and I incur the wrath of Schedule 10 of the Constitution by whatever action there's a decision of the speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I may.
That you have said, so that you are not removed as a member of
Yes.
the party. You may be removed, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this. That was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi Party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that the very act of going and seeking support from the Samajwadi Party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said, as far as exercise of powers by the speaker is concerned, that this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the House, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the Constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. Correct? And the inquiry under both are different.
Completely different. If at all, my lords, if at all, a finding of the EC may help speaker, if at all, but nothing that the speaker decides will ever impact a member approaching the election commission. So to say that the two petitions are intertwined, thus this must await the decision in the main matter, is completely wrong. Now, my lords, even as far as that one question which is referred to, which is the last question, J, which I just...
Scope of powers of the EC.
My lords, all that is, I'm very clear. What is the scope of powers of the Election Commission of India with respect to determination of a split within a party? No one has questioned the vires of the symbols order has already been upheld by your lordships. No one has ever questioned the power of the Election Commission. All that has been said herein is the scope of the powers of the Election Commission. Now, if I were to accept the argument as sought to be forward by the petitioners, my lords, then till the Constitution bench of this court decides on the scope of powers of the Election Commission. This may be the Shinde versus Thackrey matter, but there could be another matter where there are disqualifications of MLAs and another set of people go to the Election Commission. So the Election Commission is denuded of its powers as a coordinate constitutional authority to continue and do what it is mandated under the Constitution to do, because your lordships are seized of the question of the scope of the Election Commission. This is one matter, my lords. All that has been said, court in its wisdom thought that the scope of the powers needs to be looked into. My respectful submission would be, my lords, even the scope of the powers, the horse the symbols order, in the light of judgment of your lordships, is expansive and plenary. But the symbols order itself under clause 15 and 18 specifically provides for a situation like ours, which is rival factions within a party, interim directions to be given. And my lords, your lordships in any number of judgments again have held that pendency of disputes does not bar the Election Commission from issuing any interim direction which it feels is necessary in the interest of justice in the meantime. Now, another argument raised was, what happens if the Election Commission suddenly freezes the symbol? Who will be able to contest? There will be mayhem, there will be chaos. What will happen? Now, my lords, your lordships have also held that you are entitled, if you represent the overwhelming majority, whatever you think you represent the overwhelming majority within the party, to go and say that we are entitled to represent the party and use the symbol. That's your legal right. Symbol is otherwise not the property of an MLA. It's the decision of the Election Commission. But I have a legal right to claim that I can use it. That's one that I can do in this matter. Presuming, suppose a situation were to arise in the court and the Election Commission was to come to a conclusion, no, we can't decide. There are orders, where freezing orders have been passed by Election Commission, and in the intervening period, temporary symbols have been given. Those are not jurisdictions of Election Commission to decide. You today, in a 32, want the court to be seized of the matter, exercise the jurisdiction of the Speaker as a court of first instance, exercise the powers of an Election Commission under a 32, and none of these constitutional bodies should be.
Yes,
My lords, I have two judgments to show to my lords.
Which are those judgments?
One is, my lords, the Rana judgment. Other is Sadiq Ali. And third is Palanis.
Right. So we give you about 5 minutes after lunch.
Yes. My lords, just.
Yes. On the days, my lord, the Chief Justice indicated on the days when the Constitution bench sits, the Constitution bench runs for the whole day. So we continue.
We'll continue.
Yes. Well, I'll just require 15 minutes from your lord, because I need to show 3 judgments and some provisions.
Indulgence, a brief supplement by me and Mr. Singh. 10 minutes each.
Right after Mr. Paul finishes,
Yes,
maybe 5 or 10 minutes between the two of you, and then we want to hear Mr. Data because he's preparing for a constitution body.
Most important, question number F.
Yes.
Or the referred questions. Question number F is, what is the scope of the election commission?
That's J. We'd like to hear Mr. Data. We do, of course, since we are appearing for party, we've heard on this side as well. But we want to hear Mr. Data.
Yes, I'll finish with it. Very
sincere apologies for being late. Both the constitution benches are running late because Justice Paul and I, we were in a meeting for technology purchases for the Supreme Court and other things with Justice Nazir. That's why we were both the reason for the delay actually.
Be kind enough to have the compilation of case law that we had submitted.
Yes.
Volume 2 of the case law compilation that we had. Correspondent number 4.
Sir, we can't hear you.
Your voice is
Can't hear you.
post lunch should be greater.
That's lack of enough food.
Also with the live streaming, unless your voice goes into the mic, there
Right.
might be a problem for the audio quality.
My Lord, has this volume 2, which is compilation by respondent number 4.
Yes.
Title is compilation of thread.
Compilation of threads. You want to read Sadiq Ali?
So, my Lord, this is the Constitution bench in Rajendra Singh Ram.
Yes, last one.
It starts at 191
Yes, we've got
at page 230, 213.
Whoever has done the bookmarking has done it very well. We must thank the young juniors who have done this exercise.
Some absolutely outstanding youngsters assisting us in this matter.
Otherwise, what happens to us? I know the chavez because when you people conclude arguments in the final hearings and we have to start dictating, then you have to start scrolling down, which is a big headache. I mean, when it's bookmarked, it takes you a second to go to that particular.
Right. Your Lordship, be kind enough to have page 213.
213. Rana is how many judges?
5.
Something seriously wrong.
Mr. Cole, you had mentioned Sadikali is that you'd like to refer to Rana and change the third one.
Banani Swami.
आपको बैकग्राउंड है ना?
Kindly have placitum B on 213, which starts with, it is therefore not possible. That's Para 5. The para 25 starts at page 212.
Yes, we got it.
It is therefore not possible to accede to the argument that under the 10th schedule of the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party, as contemplated by paras 3 and 4 of the 10th.
Sorry, I didn't get this.
I'm also
I'm reading
para 25.
Para 25 starts at page 212.
But it starts as in the context of the introduction.
Yes, that's right.
And you're
like
I'm on page 213, placitum B.
It is therefore not possible.
It is therefore.
Yes.
I don't have that.
Yes.
It is therefore not possible to accede to the argument that under the 10th schedule of the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule of the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of the business of the House, but that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question he was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of 6(1) of the 10th schedule of the Constitution, and that even if it did, the power of judicial review recognized by the court in Tehoto Holohan is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as part of disqualification of a member of the House. The disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10th schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10th schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10th schedule or the rule made under do not contemplate the Speaker embarking upon an independent inquiry as to whether there has been a split in a political party or there has been a move.
Yes.
So, my lord, the Constitution bench of this court squarely says on this point that look at it from the lens of a legislature party, the split, the merger, but political party, what happened? While deciding disqualification under the 10th schedule, don't embark on an inquiry as far as the political party is concerned, which is not your domain or jurisdiction. And it was in this context, my lord, as I respectfully submitted, and on which great emphasis is laid by the other side, that it said that disqualification is ex post facto. Because on the date the Speaker ought to have decided the disqualification, because 13 MLAs had gone with the Samajwadi Party to support another government. Instead of doing that, the Speaker went on to decide on a subsequent event where 24 MLAs had joined the 13 MLAs and said there's a split in the party and supported that decision. Now, if those people had been disqualified earlier on a day, that split would not have occurred. Now, with great respect, how can that ex post facto used in that context be meant to say that if ultimately you're disqualified from that day, you cannot approach the election commission? I put their case at the highest, even if I'm disqualified, with an ex post facto application. My right to go to EC as a primary member of the party is still not taken away.
Yes.
And secondly, in the present matter, as on date, and all the issues are pending, whether I have voluntarily given up my membership, whether I have defied the whip of the party. Now, which whip will be considered? I'll show the Maharashtra Assembly rules. The Maharashtra Assembly rules provide for a leader of the legislature party and a member is the member of the Legislative Assembly. It is the leader of the political party who writes to the Speaker and points out who is the leader, what are the designations of various MLAs, etc. Here, you claim someone to be the whip, we claim someone else to be the whip in the matter. Your whole case is that I have defied the whip, whereas our case is I have not defied the whip. The person that you appointed was appointed by a handful of MLAs. Whereas as we are concerned today, the majority has removed it who was appointed earlier. That is our case. Now, these are all issues, right or wrong, pending before the Speaker, and the Speaker will take a call. And in terms of clause 6 of the 10th schedule, his decision in this respect will be final.
All right.
So, yes, so madam, 2 more judgments. Would you?
What are you citing them on?
Now,
which is the next one?
The second one that I am citing to your lordships is Palaniswamy.
What page?
Page 139 of the same compilation. At page 154.
This is the third last judgment.
Sorry.
Yes, paragraph 25 and 26. Hello, sir, paragraph 25 would be 154?
Yes.
Yes.
The Election Commission in the past has exercised plenary powers under para 18 for issuing interim directions regarding allocation of common symbols to two factions when the dispute under Symbol's order was still pending before it. It was argued that the Election Commission cannot do so once it had finally decided the dispute. There is no difficulty in agreeing with the proposition that once the dispute has been finally decided by ECI, the question of invoking powers of para 18 by ECI would not arise. However, if the dispute is pending inquiry before ECI or the final decision of ECI is sub judice in the proceeding before the Constitutional Court, providing for an equitable arrangement in the interest of free and fair elections and provide equal level playing field to all concerned would be a just and fair arrangement. Assuming that the provisions of the Symbol's order do not predicate the nature of directions that may have to be issued by ECI, nothing prevents ECI to exercise its expansive and plenitude of plenary powers under Article 324 of the Constitution of India to deal with a situation such as the present one for ensuring conduct of free and fair elections. The purpose I am citing it, my lords, is that apart from clause 15 and 18, which adequately deal with the situation at hand, presuming the Symbol's order did not contain a provision, the Supreme Court says that even if a provision of the Symbol's order does not predicate or deals with a particular situation, the expansive powers, the field of powers given, can deal with situation under Article 324 of the Constitution.
Right.
Now, my lords, the third judgment for your lordship's kind consideration is Sadiq Ali. Please have Sadiq Ali. Page 1, my lords. At page 11. Para 20 on page 11.
One minute.
Yes. Which para?
Para 20. That's 4 paras I need to read. Para 20. Starts with a perusal of different paragraphs.
Yes.
Yes.
May I, with your lordship's permission? Perusal of the different paragraphs of the Symbol's order makes it manifest that they provide, as is made clear by its preamble, for specification, reservation, choice, and allotment of symbols at elections in parliamentary and assembly constituencies, as well as for the recognition of political parties in relation thereto, and for matters connected therewith. One such matter is the decision of a dispute when two rival sections of groups of a recognized political party claim to be that party for the purpose of the Symbol's order. Para 15 provides for the machinery as well as the manner of resolving such a dispute. Now kindly have para 22 on the next page. My lord, that para 22?
Yes.
The next page. Let us now go back to paragraph 15. The occasion for making an order under this paragraph arises when the Commission is satisfied on the information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission in such an event decides the matter after taking into account all available facts and circumstances of the case and hearing such representatives of the sections or groups and other persons as desired to be heard. And now kindly have the next paragraph, that is paragraph 23. Somewhere in the middle, my lord, which starts with the Commission in circumstances had to decide the matter.
Yes.
The Commission in the circumstances had to decide the matter under paragraph 15, and we find nothing objectionable in communication dated so and so, sent to two rival parties on its behalf, wherein it was stated that the dispute appears to have arisen in which two of the groups in the recognized political party known as Indian National Congress for the purpose of Symbol's order. Then kindly have para 25 and 26. These are important. Para 25, page 14.
Yes.
Para 25, my lord, somewhere in the middle says for determining as to who are members of AICC. For determining as to who are members of AICC and delegates, the Commission accepted those persons as members of AICC and delegates who held that position in the earlier session of the Congress at Faridabad before the split. In view of the removal and expulsion which followed in the wake of the split in the Congress, the Commission, in our opinion, adopted proper approach for determining as to who should be taken to to be members of the AICC or delegates, more so when in the opinion of the Commission, the validity of those removals and expulsions was open to question. The figures found by the Commission of the members of the two houses of parliament and of the state legislatures, as well as those of AIC members and delegates who supported Congress J, have not been shown to us to be incorrect. In view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported Congress J. As Congress J is a democratic organization, the test of majority and numerical strength, in our opinion, was very valuable and relevant. Yes, whatever might be the position in another system of governments or organization, numbers have a relevance and importance in a democratic setup of government or political setup, and it's neither possible nor permissible to lose sight of them. Indeed, in view of the majority, which in the final analysis proves decisive in a democratic setup. And now kindly have, my lords, paragraph 35 on page 17. Paragraph 35, my lords, and the latter half starts on the right side with the Commission in resolving this dispute.
Yes.
The Commission, in resolving this dispute, does not decide as to which group represents the party, but which group is that party. If it were a question of representation, even a small group, according to the constitution of the organization, may be entitled to represent the party. Where, however, the question arises as to which of the rival groups is the party, the question assumes great competition, and the numerical strength of each group becomes important and relevant factor. It cannot be gainsaid that in deciding which group is the party, Commission has to decide as to which group substantially constitutes the party. And now kindly have paragraph 40, which starts at page 18. Kindly turn to page 19, my lords, because I'm skipping through the other parts since there's time. Please have para 40 on page 18, but kindly come to para 40, which continues on page 19. And about somewhere in the middle on the right hand side, it starts with, if on the other hand, a dispute arises between two rival groups. And my lords have got that. If on the other hand, a dispute arises between two rival groups or allotment of a symbol of a political party on the ground that each group professes to be that party, the machinery and the manner of resolving such a dispute is given in paragraph 15. Paragraph 15 is intended to effectuate and subserve the main purpose and objects of symbols order. The paragraph is designed to ensure that because of a dispute having arisen in a political party between two or more groups, the entire scheme of the symbols order relating to the allotment of a symbol reserved for the political party is not set at naught. The fact that the power for the settlement of such a dispute has been vested in the Commission would not constitute a valid ground for assailing the wiles of and striking down paragraph 15. The Commission is an authority created by the Constitution and according to Article 324, the superintendence, direction and control of electoral rolls for and conduct of elections to Parliament.
Yes, Mr.
Yes. So, my lords, my respectful submission is that Sadiq Ali in detail deals and says any dispute within the party, the entire machinery and jurisdiction is vested in the Election Commission of India. And one more argument flows from paragraph 25 and 26 is this, my lords, that they say that while determining majority, the date before when the dispute arose will be taken as the date, because after that there is a conflict. Now here, barely for you to get up and say you're disqualified, then they stand disqualified, they've given up voluntarily, the membership is of no consequence. Right. Now, my lords, just two more judgments and I'm done. Which will not, I'll just get the citations. I will not trouble your lordships with those judgments. The one is All Party Hill Leaders Conference versus W.A. Sanma, 1977, Volume 4, Volume 4, SCC 161.
That's part of your compilation.
I'm very grateful. Paragraph 37, 41, and 42. And my lords, what they specifically say is that a fraction of the judicial power of the state has been vested in the Election Commission of India. A complete machinery has been provided. And the Election Commission of India has the exclusive jurisdiction to decide all that it has been provided for, taking it away from the courts. That is the purpose. And lastly, my lords, is Kanhaiya Lal Kumar versus R.K. Trivedi, 1985, Volume 4, SCC 628, paragraphs 10 and 13, effectively, my lords, on the point that even after the deletion of clause 3, sorry, even after the introduction of the 10th schedule, my lords, discussion on Sadiq Ali, the other provisions of the 10th schedule, the symbols order was all discussed. And nowhere has ever the Supreme Court ever said or taken a view that with the coming in of the 10th schedule, the symbols order gets diluted in any manner whatsoever, or the jurisdiction of the symbols order gets diluted with the introduction of the 10th schedule. That's a judgment I'm giving for your lordship's kind consideration. Now, lastly, my lords, kindly just have the provisions, just the provisions for a minute of the Constitution. Three provisions I just would request your lordships to see. First, clause 2 of the 10th schedule. My lords have that. Subject to the provisions of 3, paragraph 4 and 5, a member of the House belonging to any political party shall be disqualified from being a member of the House if he has voluntarily gives up his membership of such political party, or if he votes or abstains from voting in such House contrary to any direction issued by the political party to which he belongs, or by any reason or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. Now, kindly have, my lords, has the deleted portion of clause 3 which used to exist. My lords, has that as part of the page 15 of our compilation. Page 115 of our compilation.
Yes.
Volume 1. Where
Yes.
only reason I am citing it is, my lords, that and 4 both are political party and 1/3 of the members of the legislature party was used in 3. And similarly, as my lords pointed out in 4, the latter part of 4(2) has 2/3 of the members of the legislature party. So to pick up political party in isolation in 3 and say that look, it says political party, and that has to be decided, no. A constitution bench says that has to be seen from the lens of a legislature party. That is to be done in this matter. Now, my lord, lastly, the Maharashtra Assembly rules, just have them for a minute, because just for the completion of page 90 of our compilation, page 99, volume 1.
In the same.
(2)(f), leader in relation to a legislature party, the party whose by it, party chosen by it as its leader, and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge the function of the leader of the party for the purposes of these rules. Then kindly have 2G. Member means a member of the Maharashtra legislative. Then rule 3.1 on the next page, 3.1 and 3.4, page 100. The leader of each legislature party, other than the legislature party consisting of only one member, shall within so and so, and kindly have A, statement in writing containing names of members of some legislature party together with other particulars regarding such members as in the form 1, and names of designations of members of such party who have been authorized by it for communicating with speaker for purposes of the rules. And then rule 3 subclause 4, then on page 102. Whenever any change takes place in the information furnished by the leader of the legislature party under subrule 1 or by a member under subrule 2, he shall, as soon as may be thereafter, and in any case within 30 days from the date on which such a change has taken place or within such period as the speaker may, for sufficient cause allowed, furnish in writing information to the speaker with respect to such change. So the speaker always interacts with leader. Leader is the member of the house and he gives all details of who's the whip, who's not the whip. Now, if there's a change of whip, the speaker will ask the leader. He's not going to go to the political party and conduct a vote who's the whip there or not. That is the purpose of this. And all parties understood it to be the same way, because whether we issued our official communications or they issued their official communication, they're all on the letterhead of the legislature party to say that the whip has been appointed. So to say, I'm very grateful, my lord. Your lordship is very kind and thank you.
Yes, Mr.
Implemented very briefly. There are two relevant aspects of lordship may kindly notice. And my lord, since the time is short, I'm not going contention by contention and my lord, prima facie case balance of convenience. We just supplement what my learned friend has largely asked. Two relevant aspects, my lord, that the Shiv Sena had a pre-poll alliance with the political party of pre-poll alliance. I'm only leaving it at that, not making any submission as of today. There is a resignation by the then Chief Minister on the floor of before the test on 29th of June 2020. And that, Lord, in our respectful submission from our side, was a conclusive evidence of losing the confidence of the House in it, and he chose to resign. Extremely relevant facts for even for prima facie case to be kept in mind, a pre-poll alliance and resignation by the then Honorable Chief Minister before the floor test is taken. Third, the no confidence in the Deputy Speaker, which came into existence in writing, expression whereof is came into existence in writing on 21st of June 2022. Is achieved, the test thereof is achieved on the touchstone of Article 179C, because my lord, a speaker can only exercise his function and jurisdiction if there is no lack of confidence in that office. If there is a lack of confidence in that office, he cannot proceed further, because that is the requirement of 179C of continuous existence of confidence in that office. And my lord, the floor test achieves both the purposes. The confidence in the leader of the house and the chief minister and the government, and the confidence in the office of the speaker also simultaneously. So two orders were passed by your lordship, my lord. The first order on 27th of June 2022, giving time of 2 weeks to file reply to the show cause notice issued by the deputy speaker, was nothing but compliance with the principles of natural justice, because 2-day notice was given when the requirement under the rules is at least 7 days notice. Lordship may just make a note. I'm only on the broader submission and prima facie case. What is the nature and scope of the order which your lordship passed? So, my lord, on 21st of June, there is lack of confidence in the deputy speaker. Deputy Speaker has issued a show cause notice giving 2 days when the rules require minimum of 7 days. A writ petition is filed, and in the writ petition, your lordship passed an order on 27th of July by just seeking compliance with the principles of natural justice, not restricting any authority to not to discharge. That's, my lord, utmost respect, my lord. A confusion is sought to be created, as in the order of 27th of July, some kind of a curtailment of jurisdiction of any authority. Kindly have a look. I'm not reading, my lord. Kindly have a look at the second last paragraph of the 27th of June order, my lord. I'm sorry, 27th of June order, which only makes available period of 2 weeks time to respond to the show cause notice given by the deputy speaker. Number 4, my lord, the non-existent assumption on the part of the other side, no matter what reply you could have given, you are to be treated as disqualified on the issuance of notice itself. The lack of confidence in the office of the deputy speaker further gets strengthened by such kind of a contention that no matter what your reply could have been, you were deemed to be disqualified the day when they are representing your lordship should be treated as disqualified. Now, my lord, kindly come to the document in volume 1 at page 82, my lord, which are the 1968 symbol order, only 2 submissions on that. My lord, the political party is not defined in the 10th schedule. Political party defined in the 1968 order, your lordship has seen. But before that, my lord, differences and dissent, which your lordships have observed on so many times, is a part of democracy in every sphere. Differences and dissent is also an essential part of intra-party democracy. The recognition, acknowledgement, and incorporation of that intra-party democracy, my lord, and differences and dissent is, my lord, in clause 15 of the order. Kindly have a look before I go to that. Page 82, my lord, of this document, which is the symbol order. Volume 1, my lord, of the documents on the file by R4. The third paragraph, whereas it is necessary and expedient to provide, and last line, my lord, recognition of political parties in relation thereto and matters connected therewith. So free, a very important, significant aspect of that is recognize political parties and the matters in connection therewith. Now kindly come to the next page. Subclause H, political party. And political party defined here because of the plenary jurisdiction to be conferred upon the Election Commission of India on the recognition and incorporation of the principle of intra-party democracy, clause 15. Now, political party means an association or body of individual citizens of India registered with the Commission as a political party under Section 29A of the Representation of People Act. Now, my lord, various powers have been conferred upon the Election Commission starting from clause 14. Kindly have a look at that, my lord, page 91. Clause 14. Page 91. Clause 14. Please see, my lord, the width and the plenary jurisdiction of the Election Commission, and it is all under 324 for conduct of free and fair election, where dissent differences even within the political party in the hallmark. Kindly have a look at that, clause 14. Power of commission to issue instructions to unrecognized political parties. So that also is the concern of the constitution makers and then culminating into 1968 order, an important feature. Even a non-recognized, unregistered political party. 15, my lord, I would like to read, but before that, kindly have 16. So when, my lord, the split and merger, my lord, there are two different clauses in clause 7, we deal with split, and merger is 4. That split and merger was originally a part of 15. And, my lord, also dealt with in clause 16. Kindly have a look at clause 16. Power of commission in case of amalgamation of two or more political parties. And then 16A. Power of commission to suspend or withdraw recognition of a recognized political party. So, my lord, absolutely plenary jurisdiction. Now, kindly permit me to read 15 once again, my lord, at the cost of repetition. Power of commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied, and kindly see, my lord, it can be its own motor knowledge of the commission itself. It can come on an application because the word used are on information in its possession. It can come from any source. It is only signify the importance of this aspect for the free and fair conduct of election. In possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. I pause here for a moment. As my letter friend pointed out, my lord, in clause 3 we stand withdrawn from the attention schedule. On clause 4 we still continues to remain there. The concern is only with regard to number in the legislative party. It has nothing to do with the political party. Clause 2(1)(a) and 2(1)(b) that you are defining the directions of a political party, or you have voluntarily given up the political party, can apply, my lord, without the involvement of Election Commission if there is no cloud on who the political party is. The moment the question arises, who is the leader or who is the political party, as the surgically says, you travel to 15 of the 68 order, total exclusive jurisdiction of the Election Commission of India. So kindly see 15, Malad, which I just complete and then go straight to the 10th schedule. The Commission may, after taking into account all the available facts and the circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, kindly mark the next word, Malad. Decide. So for the purposes of 21A, political party, there is a question mark, the decision has to come from here, not from the office holder. Decide.
The issue is not so much whether the election commission has the power or not. What they argue is the batting order, which should be decided first. But the question is, would that arise in a context where the channels are completely different and the process and the method and authorities are all different? But are there any cases where the issue relating to anti-defection as well as matters relating to party determination have been commonly taken up, not episodically, but at the same time?
Malad, I'll just check up, I'll confirm it, but I'll come back to your lordship. Malad, please permit me, I have understood, Malad, I'll see you. Malad, I'm coming to your lordships are putting it. I'm sorry.
Yes.
Lord, your lordships are putting it to me that in which order these two issues to be decided, because let us assume that the two issues does arise, that who is the leader of the party and whether that incident of disqualification has taken place or not. If these two issues are to be decided, it must be decided first. That's what your lordships are wanting to know. Lord, my respectful submission is this: I will need go to straight away to 1A and to 1B of the 10th schedule in a moment. But what I was reading here is the decision who is the political party, who is the leadership, who has to give direction on behalf of the party, in the name of the party. That decision can only come from 15. Now I'm not only see the 10 schedule, but before that, kindly come to page 8 and page 10 of this compilation one. Because if this is the position, my lord, taken on oath before this honorable court, where the writ petitions are filed on daily basis on every event taking place, after this position is taken up by the other side before this honorable court, ground D, my lord, I want to read only 4 lines and ground next page, page 10, para 36. Then, my lord, therefore, a contradictory position by filing a writ petition could not have been agitated, and that is the reason why no writ petition quasi election commission jurisdiction or election commission proceeding is not filed.
Ground D where?
Ground D at page 8.
And this is ground
Well, that pages are at the bottom. On the top there is some page 38, but the running page of this compilation is page 8 and page 10.
This ground D, Mr. Maninder saying, this ground
Isn't the writ
is
petition?
part of the writ petition.
Writ petition filed by them. No, my lord, your lordship must know, my lord, that on every event taking place after the floor test, they were filing writ petition. They have taken this position in this writ petition where there is no question of jurisdiction or proceeding further of the election commission. And they have taken this position. Kindly permit me, the last 5 lines in para D. Who is the Shiv Sena? Who is the Shiv Sena? The moment this question comes, my lord, it is also our common case. Exclusive jurisdiction is of the Election Commission of India. And they said so. And once they said so, my lord, there was no occasion for them to file any substantive writ petition questioning that position, because they can't live with the inherent contradiction in their stand. Now, my lord, if that is the position, will your lordship permit an interim application to be filed in some other writ petition? Kindly see who is the Shiv Sena. That is the domain of Election Commission. Admittedly, recognition of Shiv Sena and leadership by so and so has been endorsed by the Election Commission, and there is no dispute. Now, kindly see para 36, page 10, next page. This is a part of the rejoinder, para 36. After our stand was filed to this writ petition, the file is rejoined. So, original position is the moment question arises, who's Shiv Sena? Election Commission. Kindly see 36, third line. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the first place. So what did I came for? I came for extension of time, which is in violation of the rule only 2 days, and I asked for 2 weeks. 2 weeks is granted by your lordship. Compliance of natural justice. That has nothing to do with either the office of the Speaker or the Election Commission of India.
All right, Mr. Mandar. Yes.
Only 2 minutes. Kindly come to 2. Kindly come to 2, but the 10 schedule. 10 schedule. Only about 2 minutes and I am done. All judgments are cited. I have nothing for this hearing. But kindly come to 2-1. There is no political.
Mr. Maninder saying it is read and reread and reread.
Only 1 minute I will take. You are not.
Otherwise, we will have to hear Mr.
I will just clear it in 1 minute. 2-1A. 2-1A and 2-1B. The last word of political party and in the contrast in clause 3.2 which is deleted and clause 4.2 of the merger and the split, it's legislative party. Now in this, who is the political party and who can issue validly in law direction to the political party? Unless that question gets decided, there is no ambiguity in that regard. Speaker has no jurisdiction. And that is why the order is that once such question arises, EC will decide first. And that is their writ petition. Ground D and para 36 in rejoinder. Grateful, my lord, I am deeply obliged.
Yes, we did, Nani.
Very brief. I realize the lordships are very keen to hear a detached voice rather than partisan interest. So I'll just state my proposition. My learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. Now, the question of disqualification, and what incidentally I hope to answer my Lord Narasimha's query. The question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. Although there is no concept of potential or deemed disqualification, it has to be actual, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the Deputy Speaker, in this case, there was no Speaker because the then Speaker had resigned since 5th February 2021. But the Deputy Speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House for his position as Deputy Speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as Deputy Speaker, i.e. the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it. But it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the Speaker of the Deputy Speakers, a majority is itself questioned, he must desist from the adjudication process. Well, it's not just Nabam area, which is one of the questions of law propounded. Nabam area does say so. And we're having a second look at it, but also Article 181. Then we've got two more propositions. Yes. Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner is determinative of this matter. That's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned. Sorry, 29th July. June. Sorry, June. 29th June. I'm so sorry. 29th June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the Chief Minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the House, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us lots of the citation. Rameshwar Prasad. In that judgment, the court said when the governor is setting about the task, and it's paragraph 161 in particular, what you just know, when he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Rameshwar Prasad.
Yes. 2006 to SEC page 1. The legislative assembly of a state shall, as soon as may be, choose 2 members of the assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification, and my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord, I would like. Thank you, Mr. Datar. But just one question of Justice. But there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10th schedule and the Election Commission. It's a division bench of the Kerala High Court. What is the citation? Yes. Okay. It's in the compilation. It's 2021, 4 KLT SN 33, page 51. But it's an I compilation and it's judgment number 7 in our compilation of it. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned, and the impact of each.
Mr. Solicitor, you want? Sir, only 5 minutes because I appear for the governor. Therefore, my role is different. In my role, I have already played and if required, Lord, I may play, but only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background and 5 minutes is broadly outer limit. When 324 was framed, so there is a beautiful discussion which I will not read, I will pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of precedent rule, etc., in a different fact situation which is not arising. The only question, my lord, which needs answer for the today's limited hearing is, can your lordships take a call whether this faction is right or another faction is right? That answer, my lord, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, two factions claim that I am the original party. Somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Kaul and Maninder Singh, would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party. Would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordships are assisted on both spheres. Yes. Here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech and expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party because there is no disqualification from membership. So the Election Commission is merely deciding which group represents the original party. So, right now, for the limited purpose, my respectful submission is that let the Election Commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta?
My submission is already on that the functioning of the Election Commission is completely different and independent from the role of the Speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. We let first go to that. Lordship just takes 10th schedule. This Articles 102.2 and 191.2.
Yes.
And Lord, since we are referring to a state assembly, I will confine myself to Article 191. So, Lordship, Lord, I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note, along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 102.2 and 191.2. And if your Lordship sees 191.2, a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the schedule. Now, please come to 191(1)(a). The Lordship kindly sees, person shall be disqualified from being chosen and for being a member. So, my lord, there are two types of disqualifications. A threshold disqualification, where you can't even become a member.
And during the
Second, during. But in the company law, they use more elegantly. They say disqualification and vacation. You become a director, then you vacate the office. So when we say disqualification for being, it actually means disqualification from continuing as a member of the house. Now, Lordship will just see A, if he holds any office of profit, B, if he's of unsound mind, C, if he's an undischarged insolvent, and D, if he's not a citizen of India and has voluntarily acquired citizenships, etc. And E, if he's so disqualified under any law by or any law made by Parliament. The Lordship will find that there are 4 constitutional disqualifications, which is A, B, C, D. The 5th constitutional disqualification is 191(2). And if your Lordship sees what is 191(1)(e), if he is so disqualified or under any law made by Parliament, Lordship has to look at the Representation of People Act 1951. But I will be basically referring to the Constitution and the Representation of People Act, so Lordship will just keep these bare accents. Great. Now, if Lordship just sees the index, the table of contents of the Act, of the Representation of People Act 1951. My Lord will find that as far as the Representation of People Act is concerned, please see the table of contents, the index will give you also the architecture of the Act. Chapter 1 and 2 talk of qualifications. And my Lord will kindly notice that chapter 3 and 4 deal with disqualification. Yeah, it's a very small act.
I just, in an order yesterday, we said 50. I just told him I had a recollection that I didn't.
Yes.
50.
In fact, the statement of office and reasons say that 50 Act is very short, so we have to expand it further.
Yes.
So, Lordship will kindly come to chapter 3, just the headings. Definition, disqualification for conviction, disqualification ground of corrupt practices, disqualification, etc., etc. And chapter 4 is disqualification for voting, where you are a member but you can't vote. Now, what I'm submitting is,
yes,
the Parliament and the Constitution has consistently made the difference between what are disqualifications under the Constitution and what are disqualifications. As far as the Representative People Act is concerned, the authority to decide is the Election Commission. Actually, I'll come to 191. The President will decide, but he will take the opinion of the Election Commission. If your Lordship now, so the point I'm making is, the disqualification given in the Representation of People Act 1951 is a completely different thing. The role of the Election Commission, being a constitutional body, is clearly demarcated, and it is neither hedged nor restricted by the 10th schedule in any manner. If your Lordship now comes back to 191, the next section 192, Article 192.
Yes.
If any question arises, 192. And Lord, this is equal to 103. Lord, just makes a note. Parallel provision Parliament is 113. If any question arises as to whether a member of a house of a legislature of a state has become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the governor and his decision shall be final. 2. If before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. So disqualifications in clause 1 there are constitutional disqualifications plus under the Act. These are decided by the governor, but he will take the opinion of the Election Commission. Now, yeah, and Lordship will kindly note the governor shall obtain the opinion of the Election Commission. So he has to. So the Act very clearly demarcates the role of the Election Commission as quite distinct, separate, and the parameters are prescribed. Now let's go to the 10th schedule. Lordship will first see para 2C is original political party. Original political party. But if my Lord sees the definition in the Representation of People Act 2F, my learned friend, I think somebody referred to the rule, but if a Lordship goes to the Act itself, the Representation of People Act under 2F,
Political party.
Political party means a political party which is, once again, this opens into the 50 Act.
Mr. Maninder Singh referred to that.
He referred to the rule.
To the rule. Identical.
Identical.
Simple order.
Yes, I think in the simple order it's 2H and here it is 2F. But the point I'm making is the purpose.
2H.
Yeah, 2H in the rules, 2F in the
2F corresponds to 2H.
Now, it talks of political party means an association or body of individual citizens of India registered with the Election Commission as a political party under Section 29 capital A. And just see 29 capital A for a minute. Registration with the Election Commission of associations and bodies as political parties. So Lordship will see, my Lord, it's not necessary to have to be a society or a trust. It can just be what we call an income tax, an AOP, or a body of individuals. The association of body of individual citizens, calling itself a political party and intending to avail itself of the provisions of this part, shall make an application to the Election Commission for its registration as a political party. Now, my Lord, my humble submission is the need to call, when you talk of original political party, that means there is something which is original and something which has come later. That must be because of the provisions of para 3, where a group of people could split and form a separate party. So that would perhaps be the reason why they use the word original political party, which means the political party contemplated and registered under Section 29A. That could be the original political party. And para 3, where they say that if more than 1/3 people split, they could sit as a separate member. And in fact, the 91st Amendment says that this bulk defection is causing harm, and therefore they decided to do away with para 3 completely. So my submission is original political party must be understood to be, my humble opinion, the 2F read with 29A party. That is the party which is registered with the for the purpose of anti-defection. They said that even if more than 1/3 members go, it will not amount to defection. That has been done away with. So now basically original political party will now be relevant only in the context of merger, which I will come to later. But for the purpose of us, that's the meaning of original political party. Now what is legislature party? Legislature party means, Lordship sees the constitution. Legislature party in relation to member of a house belonging to any political party in accordance with provisions of paragraph 2 or paragraph 4 means the group consisting of all the members of that house for the time being belonging to that political party in accordance with provisions. Therefore, if the political party is a larger set, then the legislature party is a subset of members of that political party who are also being elected and now form part of the house. It is quite possible that you can have a political party with no legislature party. It's not that every political party has MLAs and MPs. So, legislature party is a subset of the original party That is, every legislature member, every member of the legislature party will necessarily be a member of the political party. This is the now coming to the role. Now, what is the question here? As Malad just put it, the batting order. Suppose there is a case of a split in the house in this particular case. But I am arguing a case independent of any kind of, as a general principle of law, what is the role of election commission? Suppose there is a defection crisis in any assembly or parliament and the matter is sub judice either before the High Court or the Supreme Court. Does it stymie? Does it stop? Does it interdict the functioning of the election commission? Is a question which the Lordship has to answer. And my humble submission is, when do we avoid parallel proceedings? We generally avoid parallel proceedings
when the jurisdiction is concurrent.
When the jurisdiction is concurrent, and typically there is a higher forum and a lower forum. And as a general rule, the subordinate forum will yield to the higher forum. So if a matter is pending in the High Court, say for example in a tax matter, and Lordship gives a notice, then typically the officer will not proceed because he will await the decision of the High Court. So parallel proceedings come where the jurisdiction is concurrent, and there is a possibility of the possibility of two authorities coming to contradictory conclusions. The second point I would request the Lordship to kindly consider, 10th schedule is legislature or member specific. Regulation 15, para 15 of the symbol order is party specific.
So the issue of disqualification would really relate to the membership of that house.
Of that house, that's what why there are two
A particular state legislature, or if the case may be one parliament.
191(2) says you will be disqualified member of that house. It doesn't say anything about your political affiliation, political party membership.
Para 15 is really agnostic on the legislature because that is irrespective of whether there is or there is not any disqualification.
In fact, I mentioned that political party may not have any member of a particular house also, or it may have members. So what we are concerned is, now if your Lordship sees the what I call the structure of a 10th schedule, first one is definition, 2 is the substantive, what is disqualification, 3 and 4 are exemptions to that disqualification, that is 1/3 member and merger. So 2 is the bar, the disqualification, 3 and 4 are exceptions, 5 is also an exception where it says that if you are a speaker, it's very unique for a speaker if he gives up his membership, then when he comes back, he can get disqualified. 6 is the procedure, which came up for consideration in Kyoto, and 7 are the rules. So if a Lordship kindly sees every para in the 10th schedule refers to the disqualification of a particular member. The Lordship, para 2A, for example. Here is a case where 2A of the 10th schedule. I'm trying to say, Manoj, that the fields are completely different. The territory is completely different, so to speak. Manoj kindly comes to 1A. A person who has voluntarily given up his membership. Now, Manoj, it is absolutely common sense that if a person is given up his sense, he's now going to file an application in clause 15 of the symbols order. People who come for the symbols order are saying, look, we are in this party, the rival group is in this party. Please decide who's the real party. So 2-1A will never apply. What is 2-1B? You violate the whip. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Datar, is that the issue of giving up the membership of a political party within the meaning of 2-1A is not confined to your activities within the house.
Yes. In my submission, Lord, I would submit that will partly depend on, because what I'm submitting is, If a
Because
lordship
voluntarily giving up the membership of a political party is not confined to what you do within the folds of the House. Unlike 2(1)(b), which is votes or abstains from voting in the House.
Yes.
But 2(1)(a) is much broader.
True.
Voluntarily gives up membership of a political
No,
party.
no, I'm sorry. I absolutely no
And
problem with that.
therefore, the Speaker's power to determine that is not therefore confined to what takes place within the fold of the House.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, if a particular member of party X has attended all the meetings of party Y, he has participated in the functions of party Y, then has he given up his party or not? So in some cases they say, yes, it's amounts to giving up membership. But that's really outside the scope of this reference. That's why I didn't. So if you say voluntary, Lordship is right. That's why under clause 6, the speaker is called upon to say that Mr. X, he attended the rallies of this party. Not the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no in the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it a, I mean, it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is.
But one thing is very clear that, 2(1)(a) as well as 2(1)(b) is member specific.
Yeah, member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents.
Yes. Now, Lordship will come. Yes. So, Manoj, what I'm submitting is, paragraph 15 basically refers to the collective right, the collective party. Who is the real party? And if a Lordship now comes to paragraph 15, which a Lordship saw a number of times, I won't go through it again. And if Lordship has seen Sadiq Ali several times, I won't repeat it. But the first 2 paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa came to the Congress so, and Jagjeevan Ram was Congress chief, and we've all gone through that controversy in those days, the Congress so, the Congress, etc. And then the argument was that the Congress who had majority in the Congress Working Committee. Lordship, can you just your broad outline of that case?
Sadiq Ali is of which year actually?
1975.
75.
But this took place in
1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because they were because Justice Khanna remarks in an abnormally prolix order. The prolix itself is abnormal, but his logic says abnormally prolix order of 437 pages. The Election Commission is normal. There, what happened was, Lordship will just keep up just 2 points. Lordship will know. Sadiq Ali deals with 72 Supreme. Sorry, it's Sadiq Ali says 72 4 SCC 664. Sadiq Ali says the Election Commission went by 2 tests, and that Supreme Court approved. One was the test of majority. Test of majority way Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjeevan Ram faction. Y are in the Nijalingappa faction. They go statewide. But you want to see that, I can show that later. That's the way. Then they say, at the All India Congress Committee, Working Committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by a test of majority and this. The point is not what they adopt. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they're doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NRDMK. Hearings took place, they came right up to the Supreme Court. And what the Election Commission they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiry. Now, please see my notice under paragraph 15. I am humbly submitting that this notice has nothing to do with the election. Chapter. Lordship will kindly see out. Yeah, please see the page. Please see my notice page.
No.
the notice, section 15 notice.
Para 44, page 44.
Yeah. Lordship will see para 40, page 44 of R4 compilation, volume 1. 22nd July 22.
Documents.
Yes, yes. Document number 9. My lord is gone.
Document number 9.
What is it? What
It's
is
in the
it?
Sadikali compilation.
No. It is the compilation of respondent number 4. Volume 1, respondent number 4, compilation of documents and rules. And this is document number 9.
Notice
Yes.
of 22nd.
22nd, your my lord is right. 22/7/2022.
Page number?
Page 44. So the pages are coming at the bottom.
Yeah. We have got total 118 page.
Yes. So Lordship will kindly see the notice is sent to both and then subject so and so. After the preamble, kindly come to para 2. The commission is in receipt of communications as delineated below. She is so and so member of parliament and secretary of party on 25/6/22 intimated the commission about the alleged anti-party activities carried out by some of the MLAs under the leadership of so and so and objected to establishing any political party using the names Shiv Sena or Marathi. Ani so and so forwarded 3 letters dated so and so. And so he gives a company. Then Sri Ani so further email it as an affidavit of so and so. Now kindly come to E. Sri Eknath Shinde on 19/7/22 filed a petition before the commission titled as so and so on the para 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, interior mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to para 3 at page 47. Now this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para 3. Para 15 of the election symbols and reservation allotment order 1960 provide that when the commission is satisfied on information, your lordship see para 15, I won't read it again. On due consideration of the totality of information available on record with the commission as summarized above, the commission is of the opinion that there are 2 rival groups in Shiv Sena party, one led by Uddhav Thackrey and the other led by Eknath Shinde. Each group is now claiming to be the party and therefore the matter requires a substantive determination by the commission under para 15 of the election symbols. In order to place both the rival groups on even keel and to protect their rights and interests and going by the past precedents, the commission has directed the documents submitted by the rival group be exchanged and the reply and written submissions be invited from the 2 groups. The steps envisaged under para 15 proceedings prior to the hearing rival groups require both rival groups to submit the respective documentary evidence of the support claimed by them, the organizational and legislative wings of the parties. Accordingly, Commission has directed both the group to furnish written submissions and their respective documents to support their claims by 8th August 2020. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on, meanwhile the matter. But then the court said, please furnish documents you asked for. Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Nothing. Secondly, my lord, by submitting this application by respective sites, none of the provisions of 10th schedule are attracted. Because 10th schedule disqualification is limited to 218, 21D. So my submission is, as somebody mentioned, para 15 is like the inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. I think that Anna DM.
I don't think we need to go into the issue.
No, what I'm saying is because Lordship will see number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
So Data, you have already said so in your paragraph 3, the procedure to be followed by the election commission. You have already stated so.
Thank you, Mr.
So my humble submission is not only in this case, but as a general rule, my humble submission is whatever happens on the floor of any particular house of parliament, that will be completely independent. It will not impact the function of the election commission in any case at all. Two things can happen. Either Lordship may allow the petition or dismiss the petition. The result of the paragraph 15 order will be completely independent of that. Whether a person is disqualified or not disqualified. He doesn't cease to be a member of the political party. And we have to go by the majority of the members of the political party, not of the legislature party. The impact of friends will be on the legislature party, but not on the political.
Yes.
Thank you.
Thank you, Mr. Data. Yes, Mr.
My friend is right. These two, 10th schedule and para 15 operate in different silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up membership of the party doesn't happen in the house. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the house. All this is outside the house. And the speaker will have to consider, for the purposes of coming to the conclusion, whether you are voluntarily giving up membership of the party, not the house. It is because of that you are disqualified. Giving up membership of the party outside the house amounts to disqualification within the house. So you can't say one is different from the other. What happens in the house is unrelated to what happens outside the house. And the election commission can't say, I'm not concerned with any of that. Number two, in paragraph 21B, if you vote against the whip, you will be disqualified not just under 21B, but also under 21A. Once you violate the whip, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, they are completely misled, the decision of this court in Rajendra Singh Rana. Let me just give you a notice briefly what it was. Of the BSC. Joint hands with the Samajwadi. Now, there were 109 members of the House. The Speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the Speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the Speaker. They were at that time not 1/3. the Speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time of the 30 members of the Speaker. That's one part of it. My argument is completely wrong. That is unrelated to the issue of giving up membership of the House. When paragraph 3 was, before it was deleted, very interesting. It is integrally linked with the political party. Kindly see our compilation of statutes. Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. I'm sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes. This footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the 1/3 of the members of such legislature party, he shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the Speaker decides in the paragraph 3, Rajinder Singh Rana says, merely because you make a claim is not enough. The Speaker will have to prima facie decide that there has been a split in the original political party. It's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just read 37 because that's why I wasted time. This is 1074 SCC model I have. In their compilation is 192. Para 37. I'm reading 36 and 37. 192 models probably. So, 219, my lords. Plus 219, they are quoting Jagjeet Singh Miller's paragraph 69. The lords, my lord, just that's in italics, not in italics, but in intention. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the Speaker, so as to take benefit of paragraph 3, the Speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the Speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that a claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajinder Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the other than 37 entities required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come up, and they need not produce any material in support of the split in the original political party, cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part, having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the speaker as the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Para 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to it. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. Now, if it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. But what will happen on the 19th of July thereafter has nothing to do with what's happened before, because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. But the CRA, volume 2. First, we show the letter to the Election Commission. Now let us kindly see the letter we wrote to Shinde on the 30th of June. It is much before 19 July. At page 321. Convenience compilation, volume 2, page 321.
Yes.
Dear Mr. Shiv Sena, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of power vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by your acts given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackrey in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackrey is the president of the party from 1990 to 1923. I still remain the president of the party. Even now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Malas, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, Manas, how is that possible to say that no, these are two different cycles? Now, Manas, and therefore, Manas, I am saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Manas, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where a original political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Manas, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. So he merges with another party, or he has another party merge with him and he forms a new party. the new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off the Shiv Sena. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's found a new political party. And those who are left behind, that is, who are less than one third, because 2/3 makes for us, those belong to the original political. In this case, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that in the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Sibal, you can conclude your argument.
No, you are in rejoinder council. No, that cannot be tit. No, that cannot be tit for tat that he has taken 2 hours.
All right, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction is. What we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it. Now, therefore, now let's come to paragraph D.
Paragraph D of
our my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
Yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that there are 2 other judgments. All right. Read the whole paragraph. Let's read the whole paragraph.
Ground D of ground page 8, right?
Because and children. That's the point, brother.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, brothers. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other. And I'm not saying I'm only saying, Miller. He says these are great repercussions because in this situation, then X number of people of a political party who are in power can be weaned away. Governor will give them votes, and we'll go to the election commission and say, you declare us the simple Millers. And that's the consequence, which is sought to be prevented by taking away the third paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is let's not have any space. Then paragraph 36 minutes. Also read it half of it. I'll just read that minutes. Page 10. On the contents of paragraph 24 to the 24 to 32 are denied. It is submitted that clearly claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of Whip 37 as well as of 47, and having read the writing on the wall as to their imminent disqualification from membership of the Assembly, the splinter group has now rushed to the Election Commission to claim that they are the real Shiv Sena. Well, this is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. Then, my learned friend cited two other judgments. But a Kerala judgment where there was no disqualification.
2021 4 23, he said at page 50.
Well, then,
but he didn't read it out.
Let's see, Palani what does he cited?
Palani Swami.
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Rani Swami had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment my learned friend cited is the Kerala judgment. So that my colleague.
That Mr.
Jetmalani cited. Paragraph 4.
He really just gave us a citation. He has no doubt.
No, he said that this is the first time the court is decided.
Page 51.
Yes, now I just note paragraph 6 of that judgment says, the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 minutes. Para 6.
At page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiyalal Umar. Now, Kanhaiyalal Umar, it is a writ petition challenging the power of the commission under the symbol law. The bodies of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. Then there is all party Hill's leaders conference, that was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let's kindly see what the notice of the commission is to us. Page 701. Compilation of this document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
That is document number 9.
Yeah, on due consideration of the totality of information available on record to the Commission, as summarized above, the Commission is of the opinion that there are two rival groups in Shiv Sena. So he's already assumed that there are rival groups in Shiv Sena, when the whole question is whether he's a part of Shiv Sena or not. One led by Uddhav Thackrey and the other led by Eknath Shinde. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my claim. I am saying he's no longer in the party, he's voluntarily given up. How does he, on what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, but this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas he can't, the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say on even keel? And to protect their rights and interests and going by the past precedent, commission has directed that the documents submitted by the rival group be exchanged and replied. Even then, then was interesting. The steps envisaged under paragraph 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. And they are aware of my letter, at paragraph 2, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, commission can't decide that issue. So now let's go back to the last part, 702 that I was reading. Support claimed by them in organizational and legislative ways. Well, let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment said that has to be considered. So if the legislative wing, according to us, all 40 of them are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shiv Sena when they are voluntarily resigned. I have informed you about it. And you say we'll treat it as an even keel. Now, nobody disputes whether a big argument is made Clause 324. Nobody disputes that power. Who disputes the plenary power of the Election Commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the Election Commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first will be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the Election Commission on the 19th of July and say, I am the party mother. Certainly the Election Commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of defection. And what used to happen, the history of litigation in this area would show that every faction used to throw out membership, members of the other faction. And obviously, Election Commission could not decide those issues. So they say, okay, let both factions come in, we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we have 2-1 at all? It is only a question of the legislature. Argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the Election Commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Can't turn the clock back. Election Commission has decided. So it makes my petition infectious. If our lordship decide against me and say, no, what happened was perfectly legal, in any case, they will get the symbol. So they are not in any case prejudiced. Why is it that you want this to go on today? When your lordships can decide this matter in October. Here the matter decided. What is the great urgency today that this must go before the Election Commission so that he either freezes the symbol or gives it to somebody without having this matter decided, and then they say, look, my speaker is there, my speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. Which they must have glossed over. So how will the speaker decide that issue? And then the larger question is whether when you go to the deputy speaker, that you are disqualified because we have moved a notice of removal against you, Mother. The speaker said this hasn't come from any source at all. It has come from an email that I'm not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And Mother, what's interesting is this court, I'm sorry, Mother, I'm taking time. I didn't want to take too much time to watch it. Well, let's see what the order of the court is on the 27th. Then show me careful. Well, it says, meanwhile, as an intent, sorry. Yeah.
What is the date of the order?
Date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and pleadings is there in page C, Manas.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yes.
page 3.
Meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Malak? Now see to follow. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended. Now let's see the order. See pure to Para 110. Order is in the teeth of 5 the constitutional bench of this court. Then the government was offered. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I read it. No need for Kyoto. In view of the limited scope of judicial review, it is available for Para 6. And also having regard to the constitutional intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interdict the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government offered. And then we came to court and said, we said, in fact, I remember I told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It has no difference. It makes no difference. Inner party democracy is in the context of you are continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it, and this is inner party democracy that's been given up. So this concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister, and then you say that, look, as far as I am concerned, the election commission will now decide. Well, in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. Thank you.
Thank you, Mr. Yes, Mr. Yes, Dr. Sanghi.
I'll give it in point form. What is the crux of the case? Or the nature of the phrase voluntarily giving up membership of the party. Whereas in actual practice, 90 if not 95% of acts or omissions coming under 21A relate to activities outside the house. by the very nature. 3 examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust board, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to only 5 minutes. Ravi Nayak. Before I cited the book, out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordship, kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read that middle practice. Middle of para 11, my lord. The said paragraph provides for disqualification of a member, they are talking of 2 of a house belonging to a political party, if he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party, even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordship's fellas has to consider, and not your lordship's fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. Hey, Manus, what you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. An inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And Melissa, that is what is happening. Point number 2, Melissa, your lordship may kindly read again to save time, I'll not read it. The 4th of August 22 order of this honorable court. The last 4 lines, and we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Datta, it says so. The proceedings may take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is whether the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This point number 4. This ground of IAF Lordships, because I don't think should be catered by the form of an IA versus the substance of what we have. That's the simpler answer. But two more important answers in law. It would be, according to me, quite quaint if your Lordship said that because it's an IA, your Lordship can't decide this matter, it's outside the scope of the main matter. But there is two other answers, factually wrong. Number one, we find several writs, including what your Lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your Lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this Election Commission is initiated. I have filed an IA saying that this is a subsequent development. While your Lordship is hearing the main matter, please defer it. Because is there something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your Lordship cannot touch it? Therefore, that is, well, I hope, not their best answer. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Kaur read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Kaur read the sentence to be very
Para 27 and 48. There's
Yes.
just one more. Let me go to grammar.
27 is the answer to 25, which was read. The context is placed in 27, which follows has to be read.
Just give a moment. Page 192, right?
Yes. So my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para President C. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim, independent of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Kaur read. Now, the sentence which connects this is para 27 page data, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the Speaker. Can you read that? This is para 27 from Precedent D for Delhi. In that context, the Speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal while considering a claim for disqualification of a member or members to decide that, but also in the context of the 3 raised by those who are subject that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the Speaker, who is a persona designata by the Constitution, no less. Now, while your Lordship is on this, just let me finish on 48 of the same judgment. Also, not be great. This is just 2 lines. This is just to connect, as one out of hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involves the very specific case, the act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership to the party or to speak it to said members and party. It is because all over the press and repeated that they went on this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in Paragraph. My fifth point is that your lordship is cited. I want to make a general fifth point and then tell your lordship. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case, I repeat, lordship recorded by submission. It's a rather broad thing, I don't want to make no mistake. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter and a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is Omar, etc. 1985, 4 SCC 628. Just note the citation I have not taken off. Just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules? That's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why, should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also. I'm not saying, but I'm saying that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be briefly decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes the speaker is disqualified. Then the persona designata that you start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps will interview. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 1A, which the speaker to his best ability decides. Today, in effect, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B, what should be decided? Decided first is what your lordship is told. I will let the EC decide it first. B, as the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will decide by the state.
There's just one submission for lordship's kind consideration. Only on Pivoto Holo.
No, it cannot be, Mr. Then there should be a
Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. Pivoto Holo said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and then the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibbal presumes that we are disqualified and the EC today cannot be approached.
All right. First issue. Yes. We have heard Mr. Kapil Sibal and Dr. Abhishek Singhvi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Mr. Tushar Mehta, then Solicitor General, has appeared on behalf of the Governor. Mr. Arvind Dutta, then Senior Counsel, has appeared on behalf of the Election Commission. Next, having heard the. Sorry? Oh, yes, Mr. J.
What's it forgot me?
I'm so sorry.
No. Quite forgettable.
No.
Apologies. Having heard the Learned Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.
अच्छा, करंटली सुप्रीम कोर्ट दिल्ली में लोकेटेड है, पर क्या अगर हम चाहें तो सुप्रीम कोर्ट की बाकी बेंचेस देश के बाकी कोनों में भी ओपन कर सकते हैं? इसका जवाब आपको मिलेगा आर्टिकल इंडिया का हाईएस्ट लेवल ऑफ कोर्ट, एपेक्स कोर्ट है सुप्रीम कोर्ट ऑफ इंडिया, जिसे इस्टेब्लिश किया गया है कॉन्स्टिट्यूशन ऑफ इंडिया के चैप्टर 4 पार्ट 5 के अंदर। और इन्हीं प्रोविजंस के थ्रू सुप्रीम कोर्ट को कॉन्स्टिट्यूशन का एज अ गार्जियन, एज अ प्रोटेक्टर इस्टेब्लिश किया गया है। हे एवरीबॉडी, मैं हूं प्रिया और आप देख रहे हैं फिनोलॉजी लीगल। आज की इस वीडियो में हम सुप्रीम कोर्ट ऑफ इंडिया के बारे में जानेंगे। तो ये तो आप जानते ही होंगे कि ये कितना इंपॉर्टेंट टॉपिक है। तो चलिए इसकी हिस्ट्री समझना शुरू करते हैं और शुरुआत करते हैं कि ब्रिटिशर्स का सुप्रीम कोर्ट के इस्टेब्लिशमेंट के पीछे क्या रोल रहा है। तो अगर मैं आपसे ये क्वेश्चन पूछूं कि वो कौन सा ऐसा इवेंट था जिससे इंडिया में ब्रिटिश रूल इस्टेब्लिश हुआ, तो इसका आंसर होगा 1757 का बैटल ऑफ पलासी, जो ईस्ट इंडिया कंपनी और नवाब ऑफ बंगाल सिराजुद्दौला के बीच में हुआ था, जिसे ईस्ट इंडिया कंपनी ने जीता। बैटल ऑफ प्लासी के बाद इंडिया में से फ्रेंच फोर्सेस रवाना होना शुरू हो गए। अब बैटल ऑफ पलासी जीतने के बाद ईस्ट इंडिया कंपनी के पास दीवानी राइट्स आ गए। दीवानी राइट्स का मतलब कि अब ईस्ट इंडिया कंपनी रेवेन्यू कलेक्ट कर सकती है और सिविल केसेस डिसाइड कर सकती है। और इसी के दौरान ईस्ट इंडिया कंपनी को ये नीड फील हुई कि इंडिया में एक यूनिफॉर्म और एफिशिएंट सिस्टम की जरूरत है। तो अब 1771 में जब वॉरेन हेस्टिंग्स गवर्नर जनरल बने, तो वो लेकर आए जुडिशियल प्लान ऑफ 1772, जिसे फर्स्ट लीगल रिफॉर्मेशन प्लान भी कहते हैं। और इसीलिए एक यूनिफॉर्म जुडिशियल सिस्टम क्रिएट करने का क्रेडिट जाता है वॉरेन हेस्टिंग्स को। अब यहाँ पर हम दो और इवेंट्स देखते हैं। तो रेगुलेटिंग एक्ट ऑफ 1773 से कैलकाटा में बना सुप्रीम कोर्ट। जी हाँ, दिल्ली से पहले कैलकाटा में था सुप्रीम कोर्ट, जिसमें एक चीफ जस्टिस और 3 और जजेस थे। इसके बाद गवर्नमेंट ऑफ इंडिया एक्ट ऑफ 1935 के थ्रू 1937 में दिल्ली में बना फेडरल कोर्ट, जिसमें एक चीफ जस्टिस और 2 और जजेस थे। तो देखिए, ब्रिटिश इंडिया का जब कैपिटल कैलकाटा हुआ करता था तो सुप्रीम कोर्ट को वहां एस्टैब्लिश किया गया था, पर जब कैपिटल बदलकर दिल्ली हुआ तो फेडरल कोर्ट को वहां एस्टैब्लिश किया गया। अब आपने ध्यान दिया कि मैं सुप्रीम कोर्ट, फेडरल कोर्ट ये दोनों टर्म्स यूज कर रही हूँ, तो इनमें डिफरेंस क्या हुआ? तो देखिए, हमारा जो सुप्रीम कोर्ट है, आजादी से पहले उसे फेडरल कोर्ट ऑफ इंडिया के नाम से जाना जाता था, जिसे एस्टैब्लिश किया गया था गवर्नमेंट ऑफ इंडिया एक्ट ऑफ 1935 के अंदर। अब जानते हैं कि इंडिपेंडेंस के बाद क्या हुआ। तो देखिए, हमें इंडिपेंडेंस कब मिली? 15 अगस्त 1947 को। हमारा कॉन्स्टिट्यूशन फोर्स में कब आया? 26 जनवरी 1950 को। इसके ठीक 2 दिन बाद, मतलब 28 जनवरी 1950 को फेडरल कोर्ट की जगह सुप्रीम कोर्ट को एस्टैब्लिश किया गया। तो अब अगर आपसे कोई क्वेश्चन पूछे कि सुप्रीम कोर्ट का इनॉग्रेशन डे कब मनाया जाता है, तो ऐसे याद रखिएगा कि कॉन्स्टिट्यूशन के आने के ठीक 2 दिन बाद, मतलब रिपब्लिक डे के ठीक 2 दिन बाद 28 जनवरी 1950 को मनाया जाता है सुप्रीम कोर्ट का इनॉग्रेशन डे। 1950 में सुप्रीम कोर्ट की स्ट्रेंथ थी 1 चीफ जस्टिस और 7 और जजेस। और आपको पता है इंडिपेंडेंट इंडिया के फर्स्ट चीफ जस्टिस कौन थे? जस्टिस एच.जे. कानिया। करंटली सुप्रीम कोर्ट की जो स्ट्रेंथ है वो है 1 चीफ जस्टिस प्लस 33 अदर जजेस। चलिए अब हम सुप्रीम कोर्ट के 5 इंपॉर्टेंट फंक्शंस के बारे में जानते हैं। तो सबसे पहले, सुप्रीम कोर्ट कॉन्स्टिट्यूशन के गार्जियन की तरह एक्ट करता है और कॉन्स्टिट्यूशन को किसी भी अनडिजायरेबल, अनचाहे चेंजेस से प्रोटेक्ट करता है। दूसरा, सुप्रीम कोर्ट फंडामेंटल राइट्स के लिए भी प्रोटेक्टर और डिफेंडर की तरह एक्ट करता है और फंडामेंटल राइट्स को लेजिस्लेचर या एग्जीक्यूटिव द्वारा पास किए गए कॉन्ट्ररी लॉ से बचाता है। तीसरा, कुछ तरीके के डिस्प्यूट्स को सॉल्व करने की सोल अथॉरिटी सुप्रीम कोर्ट के पास है। तो अगर प्रेसिडेंट या वाइस प्रेसिडेंट के इलेक्शन को लेकर कोई भी डिस्प्यूट होता है तो उस डिस्प्यूट की कार्यवाही सिर्फ और सिर्फ सुप्रीम कोर्ट में होगी। इसी से मिलता जुलता है चौथा पॉइंट, सेंटर स्टेट डिस्प्यूट को लेकर। तो अगर सेंटर और स्टेट्स के बीच में या फिर एक स्टेट और दूसरे स्टेट के बीच में कोई भी डिस्प्यूट होता है तो उस डिस्प्यूट को सॉल्व करने की भी सोल अथॉरिटी सुप्रीम कोर्ट के पास है। 5वां पॉइंट तो आपको पता ही होगा कि सारे सिविल, क्रिमिनल और कॉन्स्टिट्यूशनल केसेस में हाईएस्ट कोर्ट ऑफ अपील है सुप्रीम कोर्ट। चलिए अब हम कुछ इंपॉर्टेंट आर्टिकल्स और उनके प्रोविजंस देखते हैं। तो कॉन्स्टिट्यूशन के पार्ट 5 चैप्टर 4 आर्टिकल 124 से लेकर 147 तक सुप्रीम कोर्ट की ऑर्गेनाइजेशन, जुरिस्डिक्शन, इंडिपेंडेंस, पावर्स, प्रोसीजर्स, इन सारी चीजों की बात की गई है। इनमें से जो इंपॉर्टेंट प्रोविजंस है उन्हें हम एक एक कर देखते हैं। तो सबसे पहले है आर्टिकल 124, जो सुप्रीम कोर्ट में जजेस की अपॉइंटमेंट की एलिजिबिलिटी की बात करते हुए ये कहते हैं कि ऐसा कोई भी इंडियन सिटीजन जिसकी एज 65 ईयर्स से कम हो और जिन्होंने मिनिमम 5 साल के लिए किसी भी हाई कोर्ट में एज अ जज सर्व किया हो, या फिर जिन्होंने मिनिमम 10 साल के लिए किसी भी हाई कोर्ट में एज एन एडवोकेट सर्व किया हो, या फिर जो प्रेसिडेंट ऑफ इंडिया के ओपिनियन में एक डिस्टिंग्विश्ड जूरिस्ट रह चुके हैं, वो सुप्रीम कोर्ट में जज बनने के लिए एलिजिबल रहते हैं। एक और बात बता दूं कि जहां सुप्रीम कोर्ट में जज बनने की मैक्सिमम एज 65 इयर्स प्रिस्क्राइब की गई है, वहीं कोई भी मिनिमम एज नहीं दी गई है। इसके बाद आता है 124(1) जो सुप्रीम कोर्ट की स्ट्रेंथ की कंपोजिशन की बात करता है। तो जैसा कि हमने डिस्कस किया कि 1950 में सुप्रीम कोर्ट की स्ट्रेंथ क्या थी? 1 चीफ जस्टिस और 7 और जजेस। वहीं प्रेजेंटली सुप्रीम कोर्ट की स्ट्रेंथ क्या है? 1 चीफ जस्टिस प्लस 33 अदर जजेस। ये जो नंबर है ये पार्लियामेंट डिपेंडिंग ऑन द सिचुएशन, पेंडेंसी ऑफ केसेस और बाकी चीजों को ध्यान में रखते हुए प्रिस्क्राइब करती रहती है। इसके बाद आता है आर्टिकल 124 क्लॉज 2 जो ये कहता है कि चीफ जस्टिस ऑफ इंडिया का अपॉइंटमेंट प्रेसिडेंट द्वारा किया जाएगा और चीफ जस्टिस ऑफ इंडिया को अपॉइंट करते वक्त प्रेसिडेंट को सुप्रीम कोर्ट और हाई कोर्ट के कुछ और बाकी और ऐसे जजेस से कंसल्ट करना होगा दैट ही डीम्स नेसेसरी। अच्छा, चीफ जस्टिस ऑफ इंडिया को अपॉइंट करते वक्त प्रेसिडेंट को बाकी जजेस से कंसल्ट करना होगा, पर सुप्रीम कोर्ट और हाई कोर्ट के बाकी सारे जजेस को अपॉइंट करते वक्त प्रेसिडेंट को चीफ जस्टिस ऑफ इंडिया से कंसल्ट करना होगा। अभी जो अपॉइंटमेंट का प्रोसीजर है ये थोड़ा कंफ्यूजिंग है, इसलिए इसे हम आराम से अच्छे से समझते हैं। तो देखिए, सुप्रीम कोर्ट के जितने भी अपॉइंटमेंट्स होते हैं उसमें प्रेसिडेंट को चीफ जस्टिस ऑफ इंडिया का ओपिनियन लेना ही होगा। दूसरा, चीफ जस्टिस ऑफ इंडिया अपना ओपिनियन देने से पहले सुप्रीम कोर्ट के 4 और सीनियर मोस्ट जजेस से कंसल्ट करेंगे। तीसरा, कोई भी ओपिनियन जो चीफ जस्टिस ऑफ इंडिया के ओपिनियन से कॉन्ट्ररी हो वो प्रेसिडेंट को कम्युनिकेट नहीं किया जाएगा। चौथा, कंसल्टेशन का पूरा प्रोसेस राइटिंग में होगा। और पांचवा, जजेस को अपॉइंट करते वक्त सीनियरिटी का प्रिंसिपल फॉलो किया जाना चाहिए। अभी जो सीनियरिटी का प्रिंसिपल है ये इयर्स ऑफ सर्विस के हिसाब से होता है। इसके बाद है एक और सुपर इंपॉर्टेंट प्रोविजन, आर्टिकल 124 क्लॉज 4, जो रिमूवल ऑफ सुप्रीम कोर्ट जज की बात करता है। देखिए, जज को रिमूव करना बहुत कॉम्प्लिकेटेड प्रोसेस है, बिल्कुल भी आसान नहीं है। एक जज को सिर्फ प्रेसिडेंट ही रिमूव कर सकते हैं मिसबिहेवियर या इनकैपेसिटी के ग्राउंड पे, ऑन द कंडीशन कि पार्लियामेंट के दोनों हाउसेस से ये मोशन पास हुआ हो। जजेस की रिमूवल का पूरा प्रोसीजर दिया गया है जजेस इंक्वायरी एक्ट 1968 में, जो ये स्टेप्स प्रिस्क्राइब करता है। तो सबसे पहले ये समझ लीजिए कि जज को इम्पीच करने का जो मोशन होता है वो किसी भी हाउस में ओरिजिनेट हो सकता है। अगर लोकसभा में मोशन रेज होता है तो मिनिमम 100 मेंबर्स को स्पीकर को साइन नोटिस देनी होगी, और वहीं अगर ये मोशन राज्यसभा में रेज होता है तो मिनिमम 50 मेंबर्स को साइन नोटिस देनी होगी। इसके बाद अगर ये मोशन एडमिट हो जाता है तो फिर स्पीकर या फिर चेयरमैन एक 3 मेंबर कमिटी कंस्टिट्यूट करेंगे इन्वेस्टिगेशन के लिए, जिसमें एक सुप्रीम कोर्ट जज, एक चीफ जस्टिस ऑफ अ हाई कोर्ट और एक डिस्टिंग्विश्ड ज्यूरिस्ट शामिल होंगे। इसके बाद चार्जेस फ्रेम किए जाएंगे और उसकी एक कॉपी उस जज को प्रेजेंट की जाएगी ताकि वो अपना डिफेंस प्रिपेयर कर सके। इसके बाद इन्वेस्टिगेशन की रिपोर्ट सबमिट की जाएगी, जिसे दोनों हाउसेस को अडॉप्ट करना जरूरी है बाय अ majority of the total membership of that house and a majority of at least 2/3 of the member of the house present and voting। अब अगर ये मोशन दोनों हाउसेस में अडॉप्ट हो जाता है तो फिर इसे प्रेसिडेंट को भेज दिया जाता है, जो जज को रिमूव करने का ऑर्डर इशू करेंगे।
हीरो सीएम, जीरो गवर्नेंस।
बहुत हो गया राजनीति, चुपचाप इस्तीफा दीजिए और नई सरकार बनने में सहयोग कीजिए।
कहीं रानी आपका ही टिकट काट दी तो?
साहिब बन गई आप, साहिब को हराना है तो साहिब बनना ही पड़ेगा।
चलिए अब एक इंटरेस्टिंग किस्सा डिस्कस करते हैं। तो सुप्रीम कोर्ट की ये ट्रेडिशन है कि जो भी सीनियर मोस्ट जज होगा वो ही चीफ जस्टिस ऑफ इंडिया बनेगा, पर पूरी सुप्रीम कोर्ट की हिस्ट्री में सिर्फ 2 बार ऐसा हुआ है कि इस ट्रेडिशन को तोड़ा गया है। 1973 में इंदिरा गांधी की गवर्नमेंट ने 3 सीनियर मोस्ट जजेस को इग्नोर करते हुए जस्टिस A.N. रे को एज चीफ जस्टिस ऑफ इंडिया अपॉइंट किया था, और 1977 में इसी तरह जस्टिस M.H. बेग को भी चीफ जस्टिस ऑफ इंडिया अपॉइंट किया गया था। तो गवर्नमेंट के इस डिस्क्रिशन को, इस पावर प्ले को, इस इंटरफेरेंस को खत्म करने के लिए 1993 में सुप्रीम कोर्ट ने एक जजमेंट पास किया, सुप्रीम कोर्ट एडवोकेट्स ऑन रिकॉर्ड वर्सेस यूनियन ऑफ इंडिया का, जिसमें यह कहा गया कि सिर्फ और सिर्फ सुप्रीम कोर्ट का जो सीनियर मोस्ट जज होगा वो बनेगा चीफ जस्टिस ऑफ इंडिया। अब हमारी ट्रेन पहुंच चुकी है एक नए स्टेशन के ऊपर जिसका नाम है ज्यूरिसडिक्शन। तो शुरुआत करते हैं आर्टिकल 131 से, जो बात करता है ओरिजिनल ज्यूरिसडिक्शन के बारे में। ये कहता है कि वो सारे टाइप ऑफ डिस्प्यूट जो सेंटर और स्टेट के बीच में हो रहे हो, या फिर 2 या 2 से ज्यादा स्टेट्स के बीच में आपस में होने वाले डिस्प्यूट्स, सिर्फ और सिर्फ कहाँ सॉल्व हो सकते हैं? सुप्रीम कोर्ट में। क्यों? क्योंकि सुप्रीम कोर्ट के पास ही ओरिजिनल ज्यूरिसडिक्शन है। तो ओरिजिनल ज्यूरिसडिक्शन का मतलब क्या हुआ कि सेंटर और स्टेट के बीच में होने वाले डिस्प्यूट्स या फिर स्टेट्स के बीच में होने वाले आपस के डिस्प्यूट्स सिर्फ सुप्रीम कोर्ट में ही सॉल्व हो सकते हैं, सिर्फ सुप्रीम कोर्ट के पास ही पावर है। और ये दिया गया है आर्टिकल 131 के अंदर, जो बात करता है ओरिजिनल ज्यूरिसडिक्शन के बारे में। इसके बाद हम बात करते हैं रिट ज्यूरिसडिक्शन की, जो दिया गया है आर्टिकल 32 के अंदर, 132 नहीं 32 के अंदर। रिट ज्यूरिसडिक्शन रिलेट करता है फंडामेंटल राइट के प्रोटेक्शन को लेकर। तो अगर किसी भी इंडिविजुअल के अगर फंडामेंटल राइट्स वायलेट हो रहे हैं तो आर्टिकल 32 के अंदर सुप्रीम कोर्ट और हाई कोर्ट दोनों को ही ये पावर दी गई है कि वो फंडामेंटल राइट्स को प्रोटेक्ट करने के लिए, उनको एनफोर्स करने के लिए जरूरी रिट्स इशू कर सके। अब ये रिट्स क्या होते हैं और कैसे यूज किए जाते हैं, इसके बारे में आप मेरी ये वीडियो जरूर देख सकते हैं। अब बात करते हैं तीसरा टाइप, एपेलेट ज्यूरिसडिक्शन की। तो जैसा कि हमने डिस्कस किया कि इंडिया में हाईएस्ट कोर्ट ऑफ अपील जो है वो है सुप्रीम कोर्ट। तो अगर किसी भी केस में अगर इंटरप्रिटेशन ऑफ लॉ को लेकर कोई क्वेश्चन है तो उस केस की अपील सुप्रीम कोर्ट में लाई करेगी। अभी जो इंटरप्रिटेशन ऑफ लॉ है ये इतना इंपॉर्टेंट क्यों है? क्योंकि अगर एक बार लॉ का इंटरप्रिटेशन हो गया तो आगे आने वाले हर केस पे उस इंटरप्रिटेशन को अप्लाई किया जाएगा। इसलिए ये इतना इंपॉर्टेंट है। तो अगर कभी भी किसी केस में हाई कोर्ट ये सर्टिफाई कर दे कि हाँ इस केस में इंटरप्रिटेशन ऑफ लॉ को लेकर या फिर एक सब्सटैंटिव क्वेश्चन ऑफ लॉ इन्वॉल्व है, तो उस केस की अपील सीधा सुप्रीम कोर्ट पर लाई करेगी। कौन से प्रोविजंस के अंदर? अगर कॉन्स्टिट्यूशनल केस है तो आर्टिकल 132 के अंदर, अगर सिविल केस है तो आर्टिकल 133 के अंदर, और अगर कोई क्रिमिनल केस है तो आर्टिकल 134 के अंदर। इसके बाद आता है स्पेशल लीव टू अपील, आर्टिकल 136। तो ये आर्टिकल ये कहता है कि सुप्रीम कोर्ट के पास ये पावर है, ये डिस्क्रिशन है कि वो देश भर के किसी भी कोर्ट, किसी भी ट्रिब्यूनल सिवाय मिलिट्री कोर्ट के, बाकी किसी भी कोर्ट, किसी भी ट्रिब्यूनल का कोई भी केस, चाहे वो पेंडिंग हो या कंप्लीट हो चुका हो, उसे सुन सकती है। इसके बाद आता है आर्टिकल 142 जो बात करता है एग्जीक्यूशन ऑफ ऑर्डर्स एंड डिक्रीज बाय सुप्रीम कोर्ट। तो अयोध्या डिस्प्यूट को सॉल्व करते वक्त सुप्रीम कोर्ट ने जो जजमेंट दिया था उसमें उन्होंने आर्टिकल 142 का यूज किया था। ये आर्टिकल ये कहता है कि सुप्रीम कोर्ट अपने जुरिस्डिक्शन का यूज करते हुए ऐसे ऑर्डर्स, ऐसे डिक्रीज पास कर सकता है जो उनके सामने आए हुए मैटर्स में कंप्लीट जस्टिस करने के लिए जरूरी होता है। नेक्स्ट है एडवाइजरी जुरिस्डिक्शन जो है आर्टिकल 143। तो ये आर्टिकल सिंपली ये कहता है कि अगर प्रेसिडेंट किसी पब्लिक मैटर पर सुप्रीम कोर्ट से कोई ओपिनियन मांगे तो सुप्रीम कोर्ट उस पर ओपिनियन दे सकता है। सुप्रीम कोर्ट के लिए बाइंडिंग नहीं है कि वो प्रेसिडेंट को ओपिनियन दे ही दे। हाँ, अगर ओपिनियन किसी इंटरनेशनल ट्रीटी को लेकर मांगा गया है तब सुप्रीम कोर्ट के लिए बाइंडिंग होता है कि वो उस पर अपना ओपिनियन दे। अब इसका दूसरा पार्ट ये है कि मानिए कि सुप्रीम कोर्ट ने कोई ओपिनियन दे दिया तो क्या प्रेसिडेंट के लिए बाइंडिंग होगा कि वो उस ओपिनियन को माने? तो ऐसा नहीं है। तो एडवाइजरी जुरिस्डिक्शन ये कहता है कि प्रेसिडेंट सुप्रीम कोर्ट से पब्लिक मैटर्स पर ओपिनियन मांग सकता है। सुप्रीम कोर्ट के लिए जरूरी नहीं है कि वो हर मैटर पे ओपिनियन दे ही दे, पर अगर वो देता है तो प्रेसिडेंट के लिए भी जरूरी नहीं है कि वो उनका हर ओपिनियन माने। अब हम दो टर्म्स डिस्कस कर लेते हैं। पहला है एक्टिंग चीफ जस्टिस और दूसरा है एड हॉक जज। तो प्रेसिडेंट सुप्रीम कोर्ट के किसी भी जज को एज एन एक्टिंग चीफ जस्टिस अपॉइंट कर सकते हैं अगर तीन में से कोई भी कंडीशन फुलफिल हो रही हो। पहला ये कि चीफ जस्टिस का जो ऑफिस है वो वेकेंट है, मतलब उसमें अभी तक कोई अपॉइंटमेंट नहीं हुई हो। दूसरा ये कि चीफ जस्टिस टेम्पररीली एब्सेंट है, या तीसरा किसी कारणवश चीफ जस्टिस अपनी ड्यूटीज परफॉर्म नहीं कर सकते हैं। इन तीन में से कोई भी कंडीशन अगर फुलफिल होती है तो प्रेसिडेंट सुप्रीम कोर्ट के किसी भी जज को एज अ एक्टिंग चीफ जस्टिस अपॉइंट कर सकते हैं। इसके बाद हम डिस्कस करते हैं एड हॉक जज। तो ये है आर्टिकल 127 और 128 जो ये कहता है कि या तो कोई हाई कोर्ट का जज या तो कोई रिटायर्ड सुप्रीम कोर्ट जज सुप्रीम कोर्ट में एज एड हॉक जज सर्व कर सकते हैं। अब ये एड हॉक का मतलब क्या हुआ? टेम्पररी टाइम पीरियड के लिए, कुछ लिमिटेड टाइम पीरियड के लिए इनको एज सुप्रीम कोर्ट जजेस अपॉइंट किया जाता है। इसे कहते हैं एड हॉक जजेस। अब इन्हें अपॉइंट क्यों किया जाता है? अगर सुप्रीम कोर्ट में जो परमानेंट जजेस का कोरम दिया गया है अगर वो किसी कारणवश पूरा नहीं हो रहा हो तो उसे फुलफिल करने के लिए एड हॉक जजेस को अपॉइंट किया जाता है। एक एड हॉक जज के पास सुप्रीम कोर्ट के जज के जैसे ही सारी पावर्स, जुरिस्डिक्शन और प्रिविलेजेस होते हैं। अच्छा, करंटली सुप्रीम कोर्ट दिल्ली में लोकेटेड है, पर क्या अगर हम चाहें तो सुप्रीम कोर्ट की बाकी बेंचेस देश के बाकी कोनों में भी ओपन कर सकते हैं? इसका जवाब आपको मिलेगा आर्टिकल 130 के अंदर जो ये कहता है कि प्रेसिडेंट की प्रायर अप्रूवल के बाद चीफ जस्टिस ऑफ इंडिया देश के बाकी कोनों में भी सुप्रीम कोर्ट की रीजनल बेंचेस ओपन कर सकते हैं। तो ये था आज का वीडियो सुप्रीम कोर्ट के ऊपर। मैं उम्मीद करती हूँ कि आज की इस वीडियो में बताई गई सारी चीजें आपको समझ में आई होगी, आपको पसंद आई होगी और आपके काम की होंगी। अगर हाँ तो टक 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 करके जल्दी से इस वीडियो को लाइक करें, चैनल को सब्सक्राइब करें और इसे शेयर करें। इसके साथ ही इस वीडियो से रिलेटेड या किसी भी लीगल टॉपिक से रिलेटेड अगर आपको कोई भी डाउट हो तो प्लीज मुझसे कमेंट करके जरूर पूछिए। मैं और मेरी टीम आपके क्वेश्चंस का आंसर जरूर करेंगे। प्लस ऐसे और इन्फॉर्मेटिव कंटेंट के लिए आप मुझे मेरे इंस्टाग्राम पेज फिनोलॉजी लीगल पर भी फॉलो कर सकते हैं, जहाँ पे हम हर दिन किसी ना किसी लीगल टॉपिक या करंट अफेयर्स के टॉपिक को कवर करते ही हैं। उम्मीद करती हूँ कि आज का ये वीडियो आपको पसंद आया हो। That's it for now. See you in the next class. Bye bye.
In this video, I'm going to cover the Indian history from 1857 to 1947. This video is the second part of modern history. It is basically a crash course. All the events will be covered in a chronological manner and will be turned into a beautiful timeline. I'll show you how the events are interconnected, and in the end, it's going to be a nice, fun, informative session. By the way, there is a part 1 of this video. In case you haven't watched it, I'll put the link of that video in the description. Alright then, let's begin. The previous part ended till 1857. We're going to pick up from there. So 1857 is regarded as an important year in the history of the Indian subcontinent. The revolt of 1857 saw the end of the East India Company's rule in India. If I have to divide the modern history of India, from 1600 to 1857, the Indian subcontinent was ruled by a trading company called the East India Company. After 1857 till 1947, the Indian subcontinent came under the direct rule of the British Crown. In other words, the British government and its parliament transferred the control of British India and its princely states from the mercantile East India Company to the British Crown. We also refer to this period as the actual British Raj. There is another reason why 1857 is regarded as an important year in the history of the Indian subcontinent. It is because of the revolt of 1857. Now let me give you the summary of what led to the 1857 revolt. I'll briefly give you an overview, otherwise this will be a never-ending video. There were multiple reasons behind it. The British East India Company started interfering with India's political, social, religious and financial systems. If you look at the period 1757 to 1800, the British East India Company gradually increased its political and military activities. They had established themselves as one of the major political and military powers by defeating many Mughal and Maratha rulers. Basically, they snatched authority one by one from Muslim and Maratha rulers. They had gained enough confidence in the Indian subcontinent to establish its authority. That's how by the end of 18th century, the British felt very strong and pursued an aggressive policy of territorial expansion. And then after 1800, the British introduced the idea of paramountcy and created laws and institutions which simply meant that the authority and position of the East India Company was supreme in Indian subcontinent. The company introduced many regulations that made many Indians upset with the company's rule. Many Indians saw it as an exploitation of the Indian culture. Some of the laws that made the Indians upset were abolition of sati in 1829, introduction of English education in 1835, spreading of Christianity through missionaries in many rural areas, then doctrine of lapse 1848. The idea behind this was to annex those states which have no successor. Their ruling rights were lapsed. Even in the case of adoption. Due to this law, many princely states like Jhansi, Satara, Udaipur, Jaipur, Sambhalpur, Nagpur, etc. became the victims of this policy. Apart from it, the doctrine of lapse was also designed by the British to take away the titles and pensions of the rulers of some states. Now this led to great resentment amongst the rulers. The rulers of these kingdoms thus rose in revolt against the company. Then the British also changed the Hindu law of property by passing the Religious Disabilities Act of 1850. As per this law, it allowed Hindus who converted from Hindu religion to another religion to inherit their ancestral property. Now this law caused a lot of chaos because it was seen as an incentive to give up one's own faith. Then Hindu Widow Remarriage Act of 1856 was passed. Then again in 1856, General Service Enlistment Act was passed. As per this law, the Indian soldiers were required to serve in area away from their homes without any extra allowances, which is called bhatta. It was a taboo for Brahmins in those days to cross the seas. It was known as Samudra Alangana. Even this situation became part of the revolt. Then Indian soldiers were paid low salaries as compared to Britishers of the same rank. Although Indian soldiers outnumbered the British soldiers, but they could not rise above the rank of Subedar and were also racially insulted. The British policy of economically exploiting India also became one of the causes of the revolt. This hurt all sections of the society. Peasants suffered due to high revenue demands and district revenue collection policy. And finally, on 26th February 1857, the 19th Bengal Native Infantry Regiment showed resentment over the new Enfield rifles. You all know the story of the Enfield rifle. Indian soldiers were given the Enfield rifle. The cartridge of the rifle was greased with fat of cow and pig, and that was against their religious faith. They were forced to chew the cartridges during training. Hindu as well as Muslim soldiers took it as a great insult to their religion. Mangal Pandey was the central character of this story. He shot the first bullet at the British. And the last point is when the mutiny started, the Indian troops went to the last Mughal emperor for becoming their leader. The British disrespected the last Mughal emperor Bahadur Shah Zafar, and that hurt the sentiments of Indians, especially Muslims who had great respect for him. So together all of this became the main causes for the uprising of 1857 revolt. On 10th May 1857, in the town of Meerut, a mutiny erupted among the Indian troops of the East India Company's army. Next day, that is on 11th May 1857, early morning, the Indian troops reached Delhi and asked Bahadur Shah Zafar to lead them. Here are the names of the Indian leaders who are associated with the revolt of 1857. Although the mutiny began in Meerut, but it spread rapidly to other places like Delhi, Agra, Kanpur, Bareilly, Gwalior, Jhansi and Lucknow, basically all over present-day Haryana, Bihar, the central provinces and the United Provinces, which is Uttar Pradesh. Now this mutiny, or you can say rebellion, was a severe threat to the British power, because nothing of this magnitude ever happened before. But then the British controlled it in Gwalior on 28th June 1858. That means this revolt went on for 1 to 1.5 years. Now I need to give you the reasons also why the British were able to control the revolt and defeat the rebels. The first reason is that the sepoys who revolted did not have one clear leader. As you saw the list, there were many of them. If you have so many leaders, it's difficult to formulate one single plan. They did not have a proper plan. So overall there was a lack of leadership. That's the first reason. And secondly, there were many princely states who supported the British side by providing soldiers as backup. In other words, our own people, many of them, supported the British in fighting and suppressing the rebellions. There were 21 princely states. Here are the names of the princely states that supported the British during the 1857 revolt. Again, the British had told them many stories or gave them many deals to keep them on their side. It is said that many of these princely states were not happy with the fact that the rebels or the Indian troops or sepoys went to Bahadur Shah Zafar for guidance. Many of these princely states saw this revolt from a different lens. They saw it as a restoration attempt of Mughal rule in North India, because they had been persecuted heavily by the Mughal dynasty before the British arrived. Anyhow, the revolt of 1857 continued for 1.5 years, and it forced the British government to rethink and replan its ruling policies in India. That is how on August 2nd, 1858, the British Parliament passed the Government of India Act 1858. Under this act, the East India Company was formally dissolved, and its ruling powers over British territories in India came to an end and were transferred to the British Crown. In other words, from here on, the era of the new British Raj started. During this time, the Governor-General and Viceroy of India was Viscount Canning or Lord Canning. The term Viceroy came from the Government of India Act 1858. So basically it changed the name from the Governor-General of India to Viceroy. The post of Governor-General of India was created by passing the Charter Act of 1833, and that is how Lord William Bentinck became the first Governor-General of India. Before 1833, there was only a Governor of Bengal Presidency. He was also called the Governor-General of Bengal, because the ruling journey of the British in the Indian subcontinent started from the Bengal region. So William Bentinck became the first Governor-General of India after 1833, and after 1858, that is passing of the Government of India Act 1858, Viscount Canning or Lord Canning became the first Viceroy of India. And again, just to be clear, you can call Viceroy or Governor-General, it's the same. Anyhow, if you read the provisions of the Government of India Act 1858, if I have to summarize it in simple words, the 1857 Revolt of Independence shook the British Empire. So the Government of India Act 1858 was a policy designed by the British to basically calm the Indian people and making them believe that forget whatever that happened, East India Company is gone, let's have a fresh start. Indirectly, the British government is saying to the Indian people that they will have their rights and their grievances will be now heard directly by Queen Victoria through this act. It was basically a strategy by the British government to restructure their ruling plans. Again, if you look at the provisions of the act, 1. It ended the doctrine of lapse. 2. It had provisions for creating the Indian civil services for the administration of the country. It also included that Indians will be admitted into the service. Then the act also had a provision that gave independent status to the remaining Indian princes and chiefs. There were more than 560 in number, only if they accept British rule. and the rest provisions were all British administrative orders. So basically, through the Government of India Act 1858, the British made an attempt to do some damage control. Another thing that I have to point out is that in the 1857 revolt, both the Hindus and Muslims jointly fought against the British, and I want you to understand the depth of this point. Because the British government realized it. You know what they realized? They realized that if the Indian society shared a common feeling, then it is going to be the end of their rule. The British knew that they had to keep the Indians busy with their internal problems, so they could rule the country without any distraction. Otherwise, there was a possibility that such a revolt could have occurred again, and that is when the British adopted the policy of divide and rule. So basically, the British wanted to look good in front of the Indian people by partially adopting modern principles of liberty, equality and justice, so that the Indian people support the colonial modernization. But at the same time, the British were also encouraging casteism and communalism by adopting the policy of divide and rule. Now, how did the British achieve Indian people's support for colonial modernization? Well, they started fulfilling the aspiration of associating Indians into the law-making system. On 1st August 1861, the British created the Indian Council Act of 1861. So today what you know as the Parliament, it actually started as the Governor-General's Council in 1861. This whole idea of forming a Governor-General's Council first came into effect through the Regulating Act of 1773. At that time, there was Governor-General of Bengal. He was assisted by additional 4 people. Collectively, they were known as the Governor-General's Executive Council. And then through the Charter Act of 1853, you can see a gradual increase in the membership of the council. What started with 4 people assisting the Governor-General, by 1853, it increased to 10 people assisting the Governor-General. And the reason was obvious, because the British rule was expanding. And then after 1857 revolt, as I said, the British restructured their administration plans. That is how they came up with the new idea of bringing out the Government of India Act 1858. Anyhow, the British created the Indian Council Act of 1861 just to fulfill the aspiration of the Indians and making them believe that they will be part of the country's law-making process and give them a taste of liberty, equality and justice. After 1861, the council was called Imperial Legislative Council or Indian Legislative Council. It was this act that sowed the seed for the future Legislative Council for India after independence. As per the Indian Councils Act of 1861, the Viceroy had the power to nominate minimum 6 and maximum 12 non-official members who would be holding the office for 2 years. So previously, if the Governor-General's Council had 6 members, after 1861, apart from those 6 members, additional 6 to 12 non-official members were invited. And by the way, they were called non-official members. These non-official memberships will include Indian people. That means any of their opinions, decisions meant nothing. It was just for namesake. Now connect this point with what I said. After 1858, the British were trying to connect with the Indian people by opening up the doors for the Indians to be part of the law-making process. But it was just for namesake. Lord Canning nominated 3 Indians to his legislative council, the Raja of Banaras, the Maharaja of Patiala and Sir Dinkar Rao in 1862. Even here you can sense that the British appointed only those people as members who had friendly relations with the British Empire. In other words, who did not participate in the revolt of 1857. If you remember in the beginning I said there were few princely states who were given the gun salute status by the British Empire. Those princely states were in good relations with the British Empire. So Lord Canning nominated members only from those places to his legislative council, because he knew these princely states had some loyalty and they were in friendly terms with the British Empire. By the way, there was a revolt in Bengal in 1859 called the Indigo Revolt of Bengal. Indigo was a commercially profitable plant that had a huge demand in the European market. It was first introduced in the Indian subcontinent by a French trader, Louis Bonnard, in 1777. It was introduced in large parts of today's West Bengal and Bangladesh. The British forced the peasants to plant indigo instead of food crops. On top of that, the farmers were paid very low and they were not able to make any profit growing indigo. Together, the British government officials and the Indian zamindars oppressed the farmers, and that led to the Indigo Revolt in 1859. Compared to the 1857 revolt, this Indigo Revolt was a success. On top of it, it was a non-violent revolt. The revolt had a strong effect on the government, which immediately appointed the Indigo Mission in 1860. And if you read the summary of the Commission's report, although it was acknowledged that indigo cultivation was associated with various kinds of oppression, but the British government did not do anything about it in terms of enacting any law. However, they did appoint honest police force and competent magistrates to ensure justice in the rural areas. The intensity of the movement and the fear of not letting it repeat like the 1857 revolt, the British slowly phased out the indigo cultivation in Bengal. Now this incident again points out to the mindset of the British. After 1857, they totally restructured their idea of ruling. And by the way, this indigo revolt later became a foundation of Gandhiji's non-violent satyagraha. In 1860, the Indian Penal Code was enacted. Although it came into force in 1862, but it was recommended in the First Law Commission of India, which was established in 1834. This is another evidence that points out towards the fact that after 1857 revolt, the British had created this notion of liberty, equality and justice so that the Indian people support the colonial modernization. The Indian Penal Code did not apply to the princely states because they had their own courts and legal systems until the 1940s. As we know, the IPC came into force in Jammu and Kashmir on 31st October 2019, which replaced the state's Ranbir Penal Code. Just remember, the IPC was rolled out during the tenure of Viceroy Lord Canning, but it was prepared and drafted during the tenure of Governor General William Bentinck in 1834. Then in 1861, the Archaeological Survey of India was founded. It was founded by Alexander Cunningham, who also became its first Director General. This also happened under the tenure of Viceroy Lord Canning. The idea behind the establishment of this institution was to conduct research about the Indian subcontinent's history. It is also said that the Colonial Archaeological Survey of India wanted to learn about the history, tradition, culture of the Indian subcontinent in order to strengthen its administration over the subcontinent. As a matter of fact, many violent disagreements between Hindu and Muslim population and the famous Aryan invasion theory, which was debunked, all of it came from the studies and analysis of the monuments, scripts and translation of traditional literature done by the Colonial Archaeological Survey of India. So on one side, we know the importance of ASI, what role it played in research and the conservation and preservation of cultural monuments in the country. And on the other side, the Colonial ASI's primary goal was to learn about the history, tradition, culture of the Indian subcontinent, purely intended to strengthen its administration over the subcontinent. Long before the ASI, the British had founded the Asiatic Society of Bengal in 1784. It was founded by William Jones. Its initial goal was to learn about the importance of Hindu culture and learning about the vital role of Sanskrit in the Aryan languages. Then later on in 1829, the British commissioned Maulanas and Pandits to translate important historical, religious and judicial works into English. Among the first books to be translated was the Bhagavad Gita, the Laws of Gentus, Muslim law and so on. Lord Canning retired on 21st March 1862. By the way, during his tenure, 3 universities in India were established: the University of Calcutta, University of Madras and University of Bombay, all in the same year 1857. So he's regarded as the person who stabilized the situation for the British during its transition from the East India Company to the British Raj. Moreover, after the revolt of 1857, his contribution to the British Empire was to restore and replan the British Empire's ruling strategy in the Indian subcontinent. I'm going to consolidate all the administrative changes that the British brought after the 1857 revolt. Have a look at it so that you can understand what the intention of the British was after the 1857 revolt. By the way, you can also see that the Indian Army was also carefully reorganized after the 1857 revolt. I'm calling it as Indian Army, you can also call it as British Indian Army, it's the same. It was because of the 1857 mutiny, the British introduced caste-based induction in the army. It is a well-documented fact that the British intent was to divide the army into martial and non-martial races, wherein they defined non-martial as a class who did not have the qualities to make good leaders. Since the mutiny started from east and south, it was natural for the British to strike them off from roles in the army. It was the north which got rewarded for its martial heritage, and the tradition of contribution to the military service. In fact, before 1857, the British used to recruit people into the army from the Bengal as well as Madras Presidency. But after the revolt, the British changed the center of recruitment to North India. And this went on till 1867. Even in terms of organizing the tax system and maintaining social order, after the revolt of 1857, the British rulers categorized the Indian society in a rigid way. Since they did not know which social category to use in order to describe and register Indian society, they started from the Varna system. But the British soon realized that these categories did not work. The Indian society is much diverse and complicated in terms of various social groups and how they perceive themselves. People used jatis, not varnas. Proper census began in 1865. By 1872, the British authorities concluded the first All India census. If you look at the 1871 census, it included caste, religion, profession and age. Some 3,208 jatis were counted. Then in 1881 census, British discovered 19,044 jatis, and there were sub-jatis. Now I want you to imagine a situation where you are an Indian ruler who takes over Europe in the 18th to 19th century and attempts to put the population of the Europe into boxes like carpenters from France, nannies from Britain, Catalan grape pickers, Scottish shepherds, Finnish fishermen, etc. It's going to be complicated, right? The British colonial administrators had no idea on how to classify these thousands of local jatis into broad, meaningful categories. So what they did was they used a category which was used in Europe during the 16th to 19th century, the Victorian bourgeois and the working class, or in other parts of the Europe it was known as clergy and nobility. So from 1871 to 1931, in the colonial census, you will see that the British administrators attempt to classify dozens of jatis into one unified category of Brahmins, Kshatriyas and Vaishyas. If you use these definitions, you will find that the weight of Brahmins and Kshatriyas in India from 1871 to 1931 was comparable to the weight of the clergy and nobility in 16th to 19th century Europe. So you see, after 1857, the British government wanted to look good in front of the Indian people by passing acts and laws that reflected modern principles of liberty, equality and justice, so that the Indian people support the colonial modernization. But at the same time, the British were also encouraging casteism and communalism by adopting the policy of divide and rule. Now let me summarize the social atmosphere of the period from 1857 to 1870. If you remember, because of the Government of India Act 1857, the British had opened up the administration positions of the country for Indian people. Now most positions were taken up by the Hindus, and I will tell you why. Initially, when the British came to India as a trading company, they basically snatched the authority from the Mughal rulers. And then after 1800, the British introduced the idea of paramountcy and created many laws and institutions to civilize the Indian society. One of them was introduction of English education through the English Education Act 1835 by Governor General Lord William Bentinck and Thomas Macaulay. Since the British initially took away the authority from the Mughal rulers, they were more inclined towards the Hindu community. That's how they encouraged Hindus and Brahmins to opt for modern education. And you see, even the British needed it, because as the British rule was expanding, it was difficult for them to import enough English men to rule the country. The British needed large number of people in subordinate and lower posts of the administration. At that time, for the British, the Hindus were the advantageous community, and also the fact that the Brahmins were natural learners and pursuers of knowledge. They were quick and far ahead of other communities in terms of grasping information. And then there was also poverty among Brahmins. So overall, it compelled them to opt for lower administrative jobs. So that is how, after passing the Government of India Act 1857, most administrative positions were taken up by the Hindus. Now the British government noticed the Brahmin dominance in the civil service after 1860. And also remember that during the revolt of 1857, both Hindus and Muslims were united in the purpose to defeat the British. And I've told you that the British noticed this unity. So the British had that anger inside them, which translated into oppressing the Muslim community till 1870. Now pay attention to this fact that till 1870, the modern education culture did not spread to the Muslim community. It was only in 1875, Mohammedan Anglo-Oriental College was founded, which was the first modern institution of higher education for Muslims in India at that time. It was founded by Sir Syed Ahmad Khan. So basically, after 1870, the British started favoring the Muslim community. So after 1870, the British started favoring the Muslim community, and after 1857 revolt, the British divided the Hindu community on the basis of rigid caste system, which is evident from the 1871 census, and restructuring of the Indian army on the basis of martial and non-martial races. So all of this together made the Indians aware of the British intentions. The British were clearly exercising control over the resources of India and the lives of its people. As a result of that, the actual political uprising in India during the British rule first began in 1870s and 1880s. Groups like Pune Sarvajanik Sabha, the Indian Association, the Madras Mahajan Sabha, the Bombay Presidency Association, and of course the Indian National Congress started emerging. Always remember this point. In India, social reforms came first before any nationalist movement or any political reform. All these groups that I'm talking about, these are political groups, but they started off with social reforms. That's why they are also called as socio-political organizations. So actual political uprising in India for the first time under the British rule began after 1870s and 1880s. The late 19th and early 20th centuries witnessed the rise of nationalism not just in India, but in many Afro-Asian countries. In India, the most important political group which went on to become the widespread political party of that time was the Indian National Congress. It was formed in 1885. If you look at the names of these early political groups that emerged after 1870, one thing that you will realize is that these groups were made up mainly of people from the Hindu, Parsi and Christian communities because they slowly realized the intention of the British. For British, they viewed these political groups as a rise of nationalism that could threaten the British power in India. The British feared that this would lead to a repeat of 1857 revolt. Now, an important feature of the nationalist movement was that it took longer to spread among the Muslim community. As I've mentioned, it was only in 1875 Mohammedan Anglo-Oriental College was founded, which was the first modern institution of higher education for Muslims in India at that time. It was founded by Sir Syed Ahmad Khan. The British noticed the absence of the Muslims in this movement and quickly began working on ensuring that they did not join the movement. The British then began implementing policies that promoted the activities of communal forces and divided the national struggle, about which we will learn as we move ahead. Anyhow, the Indian National Congress was formed in 1885. At that time, the Governor General and the Viceroy of India was Lord Dufferin. You have to understand this. Under his command, if any nationalist movement is emerging, then obviously we have to assume that the British government were aware of it. If at all they saw it as a threat, they could have easily silenced it. Or there might be another reason behind it. Maybe the British wanted to gain support from all communities in India. That is why they did not bother striking down all these political groups that emerged after 1870. So again, try and relate this to what I said in the beginning. After 1857, the British were trying to do everything to impress the Indians into accepting modern colonialism. So on one hand, the British had the doubts and fear of these social groups turning into a massive political groups that would kickstart any sort of nationalist movement. And on the other hand, the British viewed these social groups as a gateway that would help the British to gain support from all communities in India. At least it would create an illusion among the people of India that their interests are being heard by the British through these social groups. In fact, one of the founding members of the Indian National Congress was a British civil servant named Alan Octavian Hume. A British guy is a founding member of an Indian political party. That means it is right when I said the British government allowed these political groups to emerge simply because they wanted to gain substantial support from all communities in India. The Indian National Congress during its initial phase, that is in its first 20 years, it was dominated by politicians with moderate political views. Initially, their aim was not to demand independence from the British. Since Indians were already given the opportunity to be part of imperial civil services through the Government of India Act 1858, however, being part of the imperial civil services, Indians were only taking orders from the British government, and they were only involved in the implementation process. With the formation of Indian National Congress in 1885, Indians got the opportunity to have political discourse and influence policy making. That means in the initial phase, the members of the Indian National Congress were using methods like petition, prayers, meetings, leaflets and delegations to present their demands in front of the British government. One of the things that they were able to achieve was the expansion of the Legislative Council by the Indian Council Act of 1892. Due to the excessive demand of the Indian National Congress, the additional members were increased. If you remember, as per the Indian Council Act of 1861, the Viceroy had the power to nominate minimum 6 and maximum 12 non-official members in the legislature, who would be holding the office for 2 years. Now through the Indian Council Act of 1892, the minimum members were increased from 6 to 10 and the maximum members were increased from 12 to 16. And by the way, these were the major demands placed by the Indian National Congress in front of the British government during its first session of 1885 to 1889. Most of them were rejected, but if you can see, one of the demands of the Congress was that the non-official members were to be elected in place of nomination. If you can recollect, after the 1861 Indian Council Act, Lord Canning nominated 3 Indians to his Legislative Council, the Raja of Banaras, the Maharaja of Patiala and Sir Dinkar Rao in 1862. Now these were nominated. The purpose behind that was simple. The British appointed only those people as members who had friendly relations with the British Empire. In other words, who did not participate in the revolt of 1857. So keeping this in mind, one of the demands of the Congress was that the non-official members were to be elected in place of nomination. The British were not in favor of this demand. So what the British did was, through the Indian Council Act of 1892, they gave limited provision in filling up some of the non-official seats in the central and provincial legislative councils on the recommendation of certain bodies. In other words, the British saturated the election process and extended it to more bodies in an attempt to hide their direct influence. So the initial members of the Indian National Congress with moderate political view were not able to achieve notable goals other than the expansion of the Legislative Council through the Indian Council Act of 1892. Now this created dissatisfaction among the general public. See, you have to understand this. At that time, the Indian National Congress consisted only of middle-class educated elites. The general public of India did not fully connect with them. In fact, after 1892, many Indians began to raise questions about the political style of the Congress. Even some of the party members started opposing the party's moderate attitude, especially towards the fight for self-government. With time, the Indian National Congress started facing constant opposition from the British government on every policy, plan or proposal that the party had put forward, due to which the members of the Congress party started having opposing views. In other words, from moderate political views, some party members started adopting radical views, which were inclined towards the independence movement. So as I said, the Indian National Congress in its first 20 years had members with moderate political views, and the party was also facing constant opposition from the British government on every policy, plan and proposal that the party had put forward, and this created dissatisfaction among the general public. With time, the Congress party became more radical and in favor of the independence movement. In other words, by the beginning of the 20th century, Congress demands became more radical. Finally, the Indian National Congress split into 2 parts, that is moderates and extremists, in the year 1907 at the Surat session of Congress, which was also popularly known as Surat Split. Here are the names of some of the moderate leaders and the extremist leaders. Although the Congress split in the year 1907, but I will tell you the reason that led to the split. The Governor General and the Viceroy of India from 1899 to 1905 was Lord Curzon. If you can recollect, I said the actual political uprising in India for the first time under the British rule began after 1870s and 1880s, when these early political groups emerged. And these groups were made up mainly of people from the Hindu, Parsi and Christian communities. The number of Muslims were negligible. And we also know that it was only in 1875 Mohammedan Anglo-Oriental College was founded, which was the first modern institution of higher education for Muslims in India at that time. It was founded by Sir Syed Ahmed Khan. That means the modern education culture did not spread to the Muslim community till the 1870s. So basically till 1870, the British oppressed the Muslims greatly because they were part of the 1857 revolt. After 1870, the British started favoring the Muslim community, while the English education was passed on to the Hindu communities much earlier. As a result, by the end of the 19th century, almost 2 to 3 generations of the Hindus got educated, and they dominated the colonial services and many other administrative posts. That also meant that the early nationalist movements was made up mainly of people from the Hindu, Parsi and Christian communities. The British noticed the absence of the Muslims in this movement, and they quickly began working on ensuring that they did not join the movement. The British then began implementing policies that promoted the activities of communal forces and divided the national struggle. So what the British did was, on 16th October 1905, Viceroy Curzon partitioned Bengal by separating the largely Muslim eastern areas from the largely Hindu western areas. Please remember this date, Bengal partition of 1905. Because the Bengal partition is a classic example of British government's divide and rule policy. The main motive of the British was to curtail the influence of Bengali politicians and to split the Bengali people, but in reality it turned out to be a communal split. The partition separated the largely Muslim eastern areas from the largely Hindu western areas. As usual, for the British, the reason for partition was all administrative. Governor-General Curzon had stated that the eastern region was neglected and under-governed, and hence by splitting the province, an improved administration could be established. However, the actual motives behind the partition were different. The British wanted to weaken the position of the Bengali Hindu politicians, since Muslims would now dominate in the east. Now you have to carefully understand two things. First, the Hindus were unhappy with the partition of Bengal, but the Muslims were in favor of it. And the second thing is, in the very same year, in December 1905, the partition of Bengal became the rise of extremism in the Indian National Congress. In other words, there was a split in the Indian National Congress. If you see Congress, which always said that it represents all different communities in India, they failed to attract Muslim leaders to their sessions. And by the way, after partitioning Bengal presidency, on 18th November 1905, Governor-General and Viceroy Lord Curzon retired. After him, Lord Minto became the next Governor-General and Viceroy. Anyhow, the Congress failed to attract Muslim leaders to their sessions. Many Muslim community leaders viewed the Congress negatively because most of the party members were dominated by Hindus. The founding members of the Congress made many efforts to attract Muslims to their sessions. The majority of the Muslim leadership, such as Sir Syed Ahmad Khan and Syed Amir Ali, rejected the notion that India's two distinct communities could be represented by the Congress. And because of the partition of Bengal, the Muslim upper class and many influential Muslim community leaders met Governor-General and Viceroy Lord Minto in Shimla on 1st October 1906, which was called the Shimla Deputation. The aim of the deputation was to win the sympathies of the British Raj on their side concerning matters relating to their interests as a community. And then, within a few months after the Shimla Deputation, on 30th December 1906, the Muslim leaders formed their own national political organization, which came to be known as the Muslim League. The Muslim League was founded on 30th December 1906 in Decca, which is present-day Bangladesh, because majority of the Muslim population at that time lived in that part of the subcontinent, and their aim was to establish a separate Muslim majority state or a nation. Notice, all forms of political uprising during the British rule were initiated and started by rich, upper middle class, elite, educated people, irrespective of their religion. But one thing for sure is that they complicated a lot of things, sometimes out of self-interest and sometimes hiding among the amorphous crowd. Anyhow, since it was the first Muslim political party in the history of India, naturally Muslims of all British Indian provinces found shelter and voice under the mainstream political umbrella of Muslim League. In other words, I want you to remember this point. The partition of Bengal in 1905 was the reason behind the political uprising of the Indian Muslims in securing representation in the government. The main objective behind the creation of Muslim League was to prevent Hindu dominance over Muslims through a parliamentary system by demanding separate electorates. Although the Muslim League was founded in Decca, which is present-day Bangladesh, but the principal organizers and the main supporters of the Muslim League were the Muslims from the Uttar Pradesh region. In fact, the Mohammedan Anglo-Oriental College, which was the first modern institution of higher education for Muslims that was founded by Sir Syed Ahmad Khan in 1875, the place where it was founded is Aligarh, and it is this same college that went on to become the famous Aligarh Muslim University in 1920, where the idea of two-nation theory emerged. Anyhow, after 1906, year after year, the Muslim League in their annual session started preparing agenda, schemes and reforms. One of it was to demand a separate electoral representation in the Imperial Legislative Council of British India. In 1909, the British fulfilled their demand by providing some reserved seats in the Imperial Legislative Council through the Indian Councils Act of 1909. It is also commonly known as the Morley-Minto Reforms. So if you remember, the British created the Indian Council Act of 1861 for fulfilling the aspiration of associating Indians into the law-making system. The Viceroy had the power to nominate minimum 6 and maximum 12 non-official members in the legislature, who would be holding the office for 2 years. And then through the Indian Council Act of 1892, that number increased. And finally, through the Indian Council Act of 1909, the British fulfilled Muslim League's demand by providing some reserved seats in the Imperial Legislative Council. That means the Muslims were given some reserved seats in the Imperial Legislative Council of British India. And this demand kept increasing because the Muslim League wanted more and more seats. The British kept listening and gave more and more representation. So connect this point with what I said earlier, that the British first favored the Hindus and then pleased the Muslims, part of their divide and rule policy. Anyhow, as you can analyze, the Indian Muslims were now in favor of the British. On the other hand, for the British, Muslims were seen as a helpful and possibly loyal counterbalance against the Hindu population. But you also have to understand that the British did not fully trust the Muslim population because of their role in the 1857 revolt and the assassination of Viceroy Lord Mayo in 1872. Lord Mayo was stabbed to death by a Pathan called Sher Ali Afridi. Now, the assassination of a viceroy sent shock waves throughout Britain and British India. Anyhow, while the British saw the Muslims as a loyal counterbalance against the Hindu population, but they did not have full trust in them. One thing I forgot to add is that Muslims were in favor of the Bengal partition, whereas the Hindus were not in favor of it. Now, due to this, the Hindu community showed anger towards the British by launching the Swadeshi movement, by boycotting the British goods. So whenever I say Hindus and Muslims, not all were against each other. When the British created such fault lines between the two communities, there were many from both the communities who were in favor of Hindu-Muslim unity. So please use your sense accordingly and think about the situation. Anyhow, the Swadeshi movement was organized and led by Aurobindo Ghosh, Lokmanya Bal Gangadhar Tilak, Bipin Chandra Pal, Lala Lajpat Rai, V.O. Chidambaram Pillai, and Babu Genu. So basically, the Swadeshi movement was started by the extremist leaders of the Indian National Congress as a response to the Bengal partition decision taken by Lord Curzon. The extremist members of the Congress wanted to take this Swadeshi movement from Bengal to all over India with an objective to get Swaraj. Swaraj means self-rule. The extremist members of the Congress started this political struggle in the name of Swadeshi movement to achieve self-governance. But the moderate members of the Congress were not interested in it. This difference between the moderates and extremists regarding their ideology finally led to the split of the Congress in 1907. And as we know, in 1909, the British gave the Muslims some reserved seats in the Imperial Legislative Council of British India. But if you look at the Swadeshi movement, it started in 1905 and went on till 1911. In the year 1911, during the Delhi Darbar, the partition of Bengal was cancelled by the visiting Royal Majesty George V because of the mounting pressure of the Swadeshi movement caused by the Hindus. At this time, the Governor General and Viceroy was Lord Hardinge. The famous Lady Hardinge Medical College in Delhi is named after his wife. Anyhow, the visiting Royal Majesty George V cancelled the partition of Bengal in 1911. At the same time, the king announced to shift the capital of British India from Calcutta to Delhi. When the British cancelled the partition of Bengal, it came as a shock to the Muslim political elite, because if you remember, the Muslims were in favor of the partition of Bengal. Now this made the Indian Muslims angry and made them realize the importance of standing on their feet and not depend too much on the British. That's when the Muslim community realized that they had to organize themselves politically. The Swadeshi movement ended in 1911. Let me also tell you quickly about Muhammad Ali Jinnah. Now Jinnah joined Congress in 1906. Even though Muslim League had been formed, he could have left Congress and joined Muslim League, but he resigned from Congress in 1920. You see, Jinnah was a member of the moderate group in the Congress, favoring the Hindu-Muslim unity. In fact, in 1906, when the delegation of Muslim leaders met Governor General and Viceroy Lord Minto in Shimla on 1st October 1906, which was called the Shimla Deputation, where the aim of the Muslim delegation was to win the sympathies of the British Raj on their side concerning matters relating to their interest as a community, Jinnah was totally against it. In fact, he even wrote a letter to the editor of the Gujarati newspaper asking what right the members of the delegation had to speak for Indian Muslims, as they were unelected and self-appointed. So this proves that Muhammad Ali Jinnah during the partition of Bengal was not a fan of the Muslim League. However, Jinnah had been regularly invited to Muslim League meetings as early as 1910, but he did not join the Muslim League till October 1913 because he did not trust the Muslim elites who dominated the organization. So he joined the Muslim League in 1913, but he remained a member of the Congress as well. Basically, he was playing the bridge between Muslims and Hindus. The Congress party was happy with it because they saw Jinnah as an important contact into the Muslim League. An interesting fact is that he was elected to the Imperial Legislative Council from Bombay Muslim constituency on January 25th, 1910. Basically, he got the reserved Muslim seat through the Indian Council Act or the Morley-Minto reforms of 1909. As we know, Jinnah joined the Muslim League in 1913, while remained a member of the moderate wing of the Congress party. He then became the president of Muslim League in December 1916 session in Lucknow. Jinnah was the architect of the 1916 Lucknow Pact between the Congress and the Muslim League. When I say Congress, the meeting at Lucknow marked the reunion of the moderate and radical wings of the Congress. So basically, Jinnah brought everyone from the Congress party and the Muslim League on same page. That is why Jinnah is known as the architect of the 1916 Lucknow Pact. Here are the list of reforms that were agreed by the Indian National Congress and the All India Muslim League. Sarojini Naidu gave Jinnah the title the Ambassador of the Hindu-Muslim Unity. So the whole idea behind the Lucknow Pact was to bring both Congress and Muslim League together on most issues regarding self-government and present themselves as a united front against the British Empire. So that was the whole idea of the 1916 Lucknow Pact. However, the Lucknow Pact only gave the impression of Hindu-Muslim unity in the national political scene. But in reality, it made way for communal politics in India and made both the parties believe that India consisted of two different communities with different interests and made them believe that communalism is part of Indian politics. If you see, the British succeeded in dividing both the communities, so much so that communalism had now entered these political groups, which once upon a time started off as social reforms. Connect this point with what I had said before. If you carefully look at the history, all communal riots began only after 1857, artificially engineered by the British authorities. There were no communal problems in India before 1857. Of course, there were differences between Hindu and Muslims, but there was no animosity. All communal riots and animosity began after 1857. The British government created split in the Indian society in 3 stages. First, they favored the Hindus, then was the turn of Muslims, and at last they turned their attention towards the backward classes. I can continue talking about this divide and rule policy, but then we will deviate and this will be a never-ending video. Anyhow, what you need to know is that after 1858, the British government carefully started dissecting the Indian society on communal grounds, and this continued till 1940s. Anyhow, the Lucknow Pact was basically an impression of Hindu-Muslim unity and also marked the reunion of the moderate and radical wings of the Congress. In simple words, all of the Indian National Congress and the Muslim League were together on the same page regarding self-government or home rule. In our entire modern history, you will hear about this Indian Home Rule movement. This is basically an independence movement that lasted for 2 years, between 1916 to 1918, under the leadership of Annie Besant and Bal Gangadhar Tilak. Annie Besant became the president of Indian National Congress in 1917. She played an important role in the unification of moderates and radical wings of the Indian National Congress, as well as unity between Muslim League. So this Home Rule movement or self-government idea was an outcome of the Lucknow Pact of 1916. And as we know, the architect of Lucknow Pact was Muhammad Ali Jinnah. Now before the Lucknow Pact, I want to take you 2 years behind, India in 1914. As we all know that the World War I was declared on 28th July 1914. India played a significant part in World War I. However, India's part in the war is frequently overlooked. It was fought between multiple countries by forming allies. Serbia, Russia, France, Britain, Italy and the United States on one side under the title European Allies. They were fighting against Germany, Austria-Hungary, Bulgaria and Ottoman Empire, who together formed the Central Powers. It ended with the defeat of the Central Powers. Anyhow, when the war broke out in 1914, India was in a state of growing political unrest. If you remember, in 1911, during the Delhi Darbar, the national capital shifted from Calcutta to India, and the Bengal partition was cancelled. The cancellation of Bengal partition made the Muslims angry, and within Congress party, the extremist group were pushing the idea of self-government. Even the Muslim League was politically organizing itself because they realized after 1911 that they cannot fully depend on the British. So that is how when the World War I broke out in 1914, India was in a state of growing political unrest. Now there were many people in India who had the opinion that if Britain got involved in a crisis somewhere, something like a world war, then the Indian extremists would use this as an opportunity to advance the idea of self-government. However, when the war broke out, those educated elites with political influence within India, both from Congress as well as Muslim League, believed that if India supported the British in World War I, then British would reward India with a major move towards independence, or at least self-government. So this was the whole idea. But in reality, nothing of that happened. Anyhow, if you have seen the video of Shashi Tharoor, Does Britain Owes Reparations? In that he has given the quantification of how much India spent. I'll just put it on the screen. Rest, if you want, you can see that video and learn more about it. Here's the list. These financial and military help were made from all over the country. Many wealthy princely states offered great sums of money, and even areas outside of British India like Nepal and Tibet offered help in providing troops. Such was the cost of the war that India's economy was pushed to near bankruptcy. The World War I went on till November 11th, 1918. As usual, India was expecting that the British would reward with major move towards independence or self-government. The mood of the British was obvious. Nothing of that sort happened, and because of that, the mood in India became more militant. Now let me introduce Gandhi. Gandhi returned to India on January 9th, 1915, after staying for 21 years in South Africa. Now before coming to India, he was already running an organization called Natal Indian Congress in South Africa that aimed to fight discrimination against Indians in South Africa. When he finally arrived in Bombay in 1915, he did not participate in any political movement. The first 2 years, he was basically roaming around India. Actually, he was advised by his mentor, Gopal Krishna Gokhale, who belonged to the moderates group within the Indian National Congress. Gopal Krishna Gokhale died in February 1915, that is 1 month after Gandhi's arrival in India. When Gandhi got the news of Gopal Krishna Gokhale's death, Gandhi took a vow not to wear any footwear for a year, With this, you can imagine Gandhi's relationship with Gokhale. Anyhow, the first political movement led by Gandhi in India was called the Champaran Satyagraha on 17th April 1917. It was a farmers' uprising that took place in Champaran district in Bihar against the indigo cultivators. The British had imposed high taxation on peasants to support World War I. You see, the British were already using our own money to fund their war. And on top of it, the Indian political fraternity were thinking, let's help British in the war and maybe we will be rewarded with self-government. Just imagine the situation. Gandhi used the same methods that he had used in South Africa to organize mass uprisings by people to protest against injustice. Now this movement is also called India's first civil disobedience movement, but it was a peaceful movement. It was not a violent uprising. So whenever any movement is peaceful, immediately think that it was the idea of the moderates of the Indian National Congress, because the extremist groups of the Congress were advocates of violent methods to topple the British colonialists in India. So Gandhi's first movement, that is Champaran Satyagraha in India, was a successful movement. Rajendra Prasad, who later went on to become the first president of India, was part of this movement. He was a lawyer too, so he gelled along well with Gandhi. That's when Gandhi's popularity started increasing, and he was also given the title Bapu. On November 11, 1918, the World War I ended, and as we know, the European allies had defeated the Central Power. That also meant that Britain was part of the winning team. India was expecting a reward from the British. The mood of the British was obvious. Nothing of that sort happened, and that made Indians very angry, and the mood in India became more militant. Now, before the World War I ended, Gandhi organized second Satyagraha movement called the Kheda Satyagraha in Gujarat on 18th February 1918. Even this movement was in support of peasants. As you know, India was wrecked by high taxation and high inflation in supporting the war. Sardar Vallabhbhai Patel was part of this movement too. Even he was a lawyer, and two of them gelled well during the Kheda movement. Even this movement was a peaceful agitation. Now, if you can recollect, the Lucknow Pact of 1916 was actually an agreement between the Indian National Congress and the Muslim League towards forming a united front against the British in demand of self-rule, and the architect was Muhammad Ali Jinnah. Now, Jinnah's problem with the Congress began with the rise of Gandhi in 1918, because that's when the Gandhian era had started. Jinnah was against Gandhi's idea of non-violent civil disobedience movements as the means to obtain Swaraj. Jinnah believed that self-government should be secured through constitutional means. In simple words, both Jinnah and Gandhi's aim was Swaraj, but their ways of obtaining it were different. On top of that, Gandhi was also gaining popularity among the Indian people. He did not wear Western-style clothes. He did his best to use an Indian language instead of English, and was deeply spiritual and religious. See, all these political elites who were part of the political groups, both Congress and Muslim League, they all had political ambitions. They were fully aware of the fact that if they achieve Swaraj through constitutional means, then only they can fulfill their political ambitions. Because the country had to be governed even after getting autonomy. And we all know after independence, these all political elites went on to secure constitutional positions. In today's example, if I have to explain, if you remember Anna Andolan, who ultimately benefited from it? Kejriwal and his Mandli. Anna Hazare disappeared after the movement. Similarly, Jinnah and other political elites had their private political ambitions, because they knew that a country has to be governed even after gaining autonomy. And you all know that all the political movements and social reforms in India were started by educated elites from middle and rich class. So naturally, even if a country gains autonomy, they were the voice, so they had to gain something back. And that is what is their political ambition. Gandhi was just roaming around like a fakir, but his personality and movements were turning out to be successful, and he was gaining popularity. Indian people were able to relate with him. That's what bothered Jinnah. In 1918, we know that the World War I came to an end. India was badly let down by the British government, even when India supported them in World War I. Many Indians were angry. The war ended in the month of November. I want you to imagine the year 1918. On one hand, Gandhi's civil disobedience peaceful movements were slowly gaining popularity. And on the other hand, the whole idea of the Congress and the Muslim League supporting the British during the World War so that in return they will get their wishes fulfilled, which did not happen. And one more point is that India was suffering from influenza pandemic. The 1918 Spanish flu was the most devastating in history, and India was the focal point of the pandemic. And not to forget, the regular poverty, disease and suffering all were happening parallelly in the country during these years. When so much was happening, the Indian nationalists did not create any unrest. There were no mutinies against the British. Though political unrest did continue in Punjab and Bengal, but nothing major like a mutiny happened. Now you have to understand this. In the initial phase of the Gandhian era, the British were not that much concerned or scared with Gandhi's non-violent movements because they already were familiar with Gandhi's moves in South Africa. What the British were worried about were the actions of the extremists in India. As I said, India was badly let down by the British government for its part played in World War I. Now the Indian nationalists started demanding Swaraj for their support to the British during World War I. That's when the British government used another clever tactic. They introduced the Government of India Act 1919. It is also called as Montagu-Chelmsford reforms. Try to recollect, a similar strategy was used after 1857 revolt, when the company rule was replaced by the crown rule. To calm Indian people in adopting the new colonial rule, the British introduced Government of India Act 1858 and gave Indians representation in the civil services. Like that, once again a clever tactic was used by introducing Government of India Act 1919. It is also called as Montagu-Chelmsford reforms. You see, every time the British did something, the next thing they would do is damage control by passing reforms and making the Indians believe that their interests are being hurt. Like that, one such reform is the Montagu-Chelmsford reforms. Edwin Montagu was the then Secretary of State for India, and Lord Chelmsford was India's Viceroy between 1916 and 1921. Basically, after the World War I, many Indian leaders believed that Britain would give Swaraj, but the British government had no intention of that. What they did was they introduced some changes in the administrative system. This came to be known as Montagu-Chelmsford reforms or the Government of India Act 1919. World War I ended in November 1918. The Montagu-Chelmsford reforms was a report made by Edwin Montagu, the then Secretary of State for India, and Lord Chelmsford, who was India's Viceroy at that time. Now this report was published on 8th July 1918. This report became the basis for the Government of India Act 1919, which was passed on 23rd December 1919. If you look at this act, the British basically separated the central and provincial subjects. However, the structure of government continued to be centralized and unitary. For the first time, the British government transferred power to provincial governments over subjects like education, agriculture, veterinary service, roads and buildings, social welfare, etc. This act introduced one more thing. It extended the principle of communal representation by providing separate electorates for non-Brahmin groups, Sikhs, Indian Christians, Anglo-Indians and Europeans. If you remember Morley-Minto reforms of 1909, it created separate Muslim electorate. That means the principle of dividing population into communal groups, which had been adopted in the Morley-Minto reforms, had been extended even beyond by Montagu-Chelmsford reforms in 1919. Gandhi and Lal Bahadur Shastri criticized this move because they knew that it would create permanent split in Hindu society and perpetuate casteism. If you remember throughout this video, I'm constantly saying this, that the British government created a split in the Indian society in 3 stages. First, they favored the Hindus, then was the turn of Muslims, and at the last, they turned their attention towards the backward classes. Government of India Act 1919 or the Montagu-Chelmsford reform is the point where the British started focusing on the backward classes. That's how they created a split in the Indian society. So these are the 3 stages of British government's divide and rule policy. As we know, the Indians supported the British in World War I to get Swaraj in return. But we know that did not happen. and the Montagu-Chelmsford report of July 1918 had no mentioning of Swaraj. There was widespread discontent throughout the country. People were angry. The British government adopted new measures to discourage Indians from rising against them by suppressing revolutionary groups and depriving Indians of their right to personal expression and liberty. In March 1919, the Rowlatt Act was passed, which was based on the report of the Rowlatt Commission. It is officially known as the Anarchical and Revolutionary Crimes Act 1919. This law gave the British government the power to arrest any person without any trial. The Imperial Legislative Council passed the infamous Rowlatt Act. Many leaders who were members of the assembly resigned in protest. Gandhi, who had already formed a reputation of forming Satyagraha Sabha by then, called for a countrywide protest. Now throughout the country, 6th April 1919 was observed as a National Humiliation Day. There were demonstrators and hartals all over the country. All business throughout the country came to a standstill. Such a protest of a united people had never been witnessed at any time in India before. The British government resorted to brutal measures to put down the agitation, and there were lathi charges and firings at a number of places. April is also the month of Baisakhi. On 13th April 1919, many villagers gathered in Jallianwala Bagh, which is a public garden in Amritsar, for the celebration of Baisakhi. The gatherers wanted to also peacefully protest the arrest and deportation of two national leaders, Satyapal and Saifuddin Kichliu. They were arrested under the new Rowlatt Act. Anyhow, the villagers were peacefully protesting against the arrest. The situation in Punjab was already alarming, as there were riots and protests against the Rowlatt Act. Punjab was already put under martial law, which meant that it became unlawful for more than 4 people to assemble at a place. The Lieutenant Governor of Punjab at that time was Michael O'Dwyer. Lord Chelmsford was India's Viceroy. Brigadier General Dyer came there with his troops and blocked the only narrow entrance to the garden. Then, without warning, he ordered his troops to fire at the unarmed crowd, which included children as well. Thousands of people were killed. This tragedy came as a shock to Indians, and it totally destroyed Indians' somewhat faith in the British system of justice. So remember this order. World War I ended, then Montagu-Chelmsford report was made. Indians did not like it because we were expecting Swaraj, but the report created more communalism. Because of people's anger, British introduced the Rowlatt Act in 1919. After that, Jallianwala Bagh massacre happened. So remember this pattern. Then on 23rd December 1919, the Government of India Act was passed. The Act embodied the reforms recommended in the Montagu-Chelmsford report. The Indian National Congress rejected the Act. But there were many leaders in the Congress. They accepted the Act and were ready to cooperate with the British government. But these people resigned and formed their own political party. Gandhi, Bal Gangadhar Tilak and Jinnah were not in favor of this Act. For Muhammad Ali Jinnah, it was the right time to leave Congress. As I've said, his idea of gaining Swaraj was through constitutional medium, plus he did not like Gandhi's growing popularity. But the main reason behind his resignation from Congress was that in 1920, the Indian National Congress under the leadership of Gandhi launched a movement of non-cooperation to boycott all aspects of British rule. The aim of this non-cooperation movement was to obtain full independence, as the Indian National Congress withdrew its support for British reforms following the Rowlatt Act and the Jallianwala Bagh massacre. Now within the Congress party, Gandhi started becoming the central figure, because all the influential leaders of the Congress either died or left the party or joined or made other political parties by 1920. Bal Gangadhar Tilak died on 1st August 1920. Gopal Krishna Gokhale died in 1915. Plus, Gandhi's non-violent Satyagraha was in line with the Congress moderate wing. The important leaders of the extremists were Bal Gangadhar Tilak, Bipin Chandrapal and Lala Lajpat Rai. If you remember, the trio were popular as Lal Bal Pal. As I said, Bal Gangadhar Tilak died in 1920. The other two opposed the Gandhian philosophy, but their political career ended by 1920. And if you remember, the Swadeshi movement, which started in 1906 after the Bengal partition, came to an end in 1911 when the Bengal partition was cancelled. And even that Swadeshi movement meant boycotting of British-made goods. And the Home Rule movement started in 1916 after the Lucknow Pact. The architect of Lucknow Pact was Jinnah. But as the decade came to an end, everything shifted towards Gandhian philosophy. That's why the period from 1905 and 1920 is known as the period of the extremists with the Indian National Congress. So that's how by 1920, Gandhi became the central figure of Congress, and Jinnah also started losing his feet in Indian National Congress. Jinnah openly criticized Gandhi, so he resigned after the launch of non-cooperation movement in September 1920. Jinnah was also a member of the Muslim League. After his resignation from Congress in 1920, he was only part of the Muslim League. The non-cooperation movement of 1920 launched by Gandhi was aimed at gaining Swaraj, but it was the Gandhi's version of achieving Swaraj. Gandhi's local style of leadership gained great popularity with the Indian people, and Gandhi became the face of the nation. Now, one more thing that I have to tell you is about the Khilafat movement. It was launched in the month of October-November 1919. The Khilafat movement was launched by the Indian Muslims to express support for the Caliph of Turkey against the Allied powers, particularly Britain. If you remember, World War I was fought between European allies and Central Power. Ottoman Empire were Turkish-speaking Muslim people who were on the side of the Central Powers, and they lost. The territorial boundary of the Ottoman Empire got reduced. After winning the World War I, Great Britain and France went ahead with territorial rearrangements, which dramatically altered the political map of the world, and Europe in particular. The purpose of Khilafat movement in India was to pressure the British government to preserve the authority of the Ottoman Sultan as Caliph of Islam, following the breakup of the Ottoman Empire at the end of the war. From 1876 to 1909, Abdul Hamid II was the Ottoman Emperor. Being a Caliph, the Ottoman Emperor was the supreme religious and political leader of all Sunni Muslims across the world. In India, many Muslim leaders joined hands and created an All India Khilafat Committee at Lucknow in the month of October and November 1919. Many of the Muslim leaders who were part of the Khilafat movement were already active in the Indian nationalist movement since 1914. Many of them were imprisoned during the war because of their pro-Turkish sympathies. Upon their release in 1919, they created the Khilafat movement. As we know, the Indian National Congress, led by Gandhi, started the non-cooperation movement against the British in September 1920. Khilafat movement started a year before. Gandhi also supported the Khilafat movement, as he saw in it the opportunity to rally Muslim support for nationalism. The Indian Muslims in turn supported Gandhi's non-cooperation movement. The combined Khilafat and non-cooperation movement was the first all-India agitation against the British rule. It saw a massive degree of Hindu-Muslim cooperation, which was based on Gandhi's non-violent protest, which is also called Satyagraha. By the end of 1921, the British government suppressed the Khilafat movement. The leaders were arrested and imprisoned, but it still continued till 1924 in small fragments. Gandhi suspended the non-cooperation movement on 12th February 1922. The non-cooperation movement was withdrawn because of the Chauri Chaura incident. It took place at Chauri Chaura in the Gorakhpur district of the United Province in British India on 4th February 1922, when a large group of protesters participating in Gandhi's non-cooperation movement clashed with police, who opened fire. As we know, the non-cooperation movement was supposed to be a peaceful and non-violent movement. However, an incident at Chauri Chaura changed the course of the movement. On 5th February, about 2,500 people marched towards the Chauri Chaura market in order to protest in front of a liquor shop. One of their leaders was arrested. A group of people then marched towards the police station, demanding the release of the arrested leader. The police fired shots in the air, hoping to disperse the crowd. However, the crowd became agitated and started pelting stones at the police. The police station was set on fire by the people, and all the policemen and officials inside were burned to death. That is when Gandhi withdrew the movement on 12th February 1921, because he felt that the people were not ready for a non-violent movement. Now let me introduce Jawaharlal Nehru into the picture. As we know, he studied law in England and he returned to India in 1912. Nehru joined the Indian National Congress in 1919. He was heavily influenced by Gandhi, who was the central figure of the Congress at that time. By the way, in the year 1919, Motilal Nehru, Jawaharlal Nehru's father, was the president of the Indian National Congress. Even his father was influenced by Gandhi's lifestyle, that Motilal Nehru, in spite of being rich, he became one of the first to transform his life to exclude Western clothes and material goods, adopting a more native Indian lifestyle. Anyhow, his son Jawaharlal Nehru joined the Congress in 1919 after the Jallianwala Bagh massacre. During the non-cooperation movement led by Mahatma Gandhi, Nehru was imprisoned for the first time for activities against the British government. Jawaharlal Nehru became the General Secretary of the All India Congress Committee in September 1923. In the mid of 1920s, he went to many foreign countries like Italy, Switzerland, England, Belgium, Germany and Russia to study the idea of socialism. That's how he got inspired by the Soviet Union. And after independence, when Nehru became the first Prime Minister of India, he introduced socialism to independent India. Anyhow, that was a brief introduction of Jawaharlal Nehru. He came into the limelight at the end of 1920s, about which we will learn as we go ahead. In 1924, Gandhi became the president of the Indian National Congress. As we know, the non-cooperation movement failed. Hence, there was no noise and action in political activities. In 1927, the British government wanted a report on political reforms in India and on amending the Government of India Act 1919. This was actually part of the Government of India Act 1919. One of the provisions was that after 10 years, a statutory commission would be set up to study the working of the government. So the UK Parliament appointed a commission. The commission consisted of Sir John Simon and 6 other members. All of them were members of the British Parliament. There was not a single Indian as a member. It was composed solely of white people. The commission was an insult to Indians. These white men were to shape the future of India. Now this commission was supposed to be set up after 10 years from 1919. That means it was supposed to arrive in 1929. But then it came a year before, because the UK government was led by the Conservative Party, and they were scared of being defeated by the Labour Party in the upcoming elections. That is why they were in a hurry in appointing a commission in 1928. It was named after its chairman, Sir John Simon. The commission was composed entirely of British members, with not a single Indian member in it. Indians were outraged at their exclusion from the commission. If you remember, the Congress did not support the Government of India Act 1919. The commission was strongly opposed by many Indians. It was opposed by Nehru, Gandhi, Jinnah, the Muslim League and the Indian National Congress because it contained 7 members of the British Parliament but no Indians. By the way, the Muslim League was split on this issue. Jinnah, along with majority of the Muslim League leaders, boycotted the Simon Commission. A certain section of members in the Muslim League, led by Muhammad Shafi, supported the Simon Commission. When the 7 MPs arrived in Lahore on 38 October 1928, there was a mass protest, hartals and black flag demonstration all over the country. People were chanting the slogan, "Simon, go back." The police resorted to lathi charges to suppress the movement. Even senior leaders like Jawaharlal Nehru were not spared. In Lahore, Lala Lajpat Rai, who was known as the Lion of Punjab, he was leading the demonstration against the Simon Commission. He was brutally lathi charged. He died on 17 November 1928 due to injuries. Before the arrival of Simon Commission, as we know, Indians were angry because there was not even a single Indian in the commission. So the Secretary of State for India, Lord Birkenhead, challenged the Indian leaders to draft a constitution for India. He basically taunted that Indians were not capable of finding a common path and drafting a constitution. The political leaders accepted this challenge and an all-party conference was held and a committee was appointed with the task of drafting a constitution. This committee was headed by Motilal Nehru, with Jawaharlal Nehru as the secretary. Other members were Ali Imam, Tej Bahadur Sapru, Mangal Singh, M.S. Annie, Subhash Chandra Bose, Shoaib Qureshi and Jia Pradhan. This draft constitution prepared by the committee was called the Nehru Committee or Nehru Report. It was drafted on August 28, 1928. Here are the recommendations of the report. Even Jinnah proposed some amendments on the Nehru's report. He proposed 14 points for safeguarding the rights and interests of the Muslims in any further constitution of the country. Here are the 14 points. He proposed these points during the December 1928 all-parties meeting. Now, if you draw a comparison of the Nehru report with Jinnah's 14 points, it had a political gap between the Muslims and the Hindus in India. Jinnah's aim was to get more rights for Muslims. It was basically a constitutional reform plan to safeguard the political rights of Muslims in self-governing India. So it is obvious that Jinnah was part of the Muslim League, so he had to take the side of the Muslims. From here on, you will gradually see that the Hindu-Muslim unity is fading away. So as we know, Lala Lajpat Rai died on 17 November 1928. Next month, that is on December 17, 1928, Bhagat Singh, Rajguru and Sukhdev shot dead J.P. Saunders, who was the Assistant Superintendent of Police outside the Superintendent's office in Lahore. Lala Lajpat Rai was Bhagat Singh's mentor. Many prominent leaders and politicians distanced themselves from Bhagat Singh. They even described it as a terrorist act. The British were looking for Bhagat Singh, so he had to be underground for a while. On April 8, 1929, Bhagat Singh resurfaced. He and Batukeshwar Dutt exploded 2 improvised bombs inside the Central Legislative Assembly in Delhi. They showered leaflets from the gallery on the legislators below, shouted slogans, and then allowed the authorities to arrest them. Their reasoning behind this courageous act was to inspire Indian people. It was an act that would make the deaf hear. Now the year 1929 is very interesting. Pay attention. So Bhagat Singh was arrested for killing a police officer. He was getting a lot of attention from the Indian people for his actions of bombing the assembly and then surrendering himself. And we all know Gandhi represented non-violence. So many historians say that around this time, Bhagat Singh's popularity was competing with the popularity of Gandhi. In the meantime, the Indian National Congress was also experiencing a transition. A new cadre of leadership, led by Jawaharlal Nehru and Subhash Chandra Bose, was emerging. Congress had 2 options in front of them. One option before the Congress was to demand a dominion status, for example like Canada and Australia, under which India would have still remained at least nominally under the British rule. And the second option was to demand for Purna Swaraj, which means full independence. Now, due to the rise of Bhagat Singh's popularity, the Congress started losing its influence over the youth, who were inspired by Bhagat Singh's act. There was a famous slogan used by Bhagat Singh, Inqilab Zindabad. Now this slogan started replacing the slogan of Vande Mataram, which was popularized by the Congress. So you can imagine the weight of Bhagat Singh's action. The older leadership in Congress were not in favor of this new voice. When I say older leadership, I mean Motilal Nehru and Gandhi. Jawaharlal Nehru had to convince the senior leadership of the Congress to change their agenda, otherwise they will risk losing their support to the extremist organizations. Then in the month of September 1929, Jawaharlal Nehru, backed by his father and Gandhi, was chosen as the new Congress president. As I said, the Congress had 2 options, either to choose dominion status or demand full independence. On December 19, 1929, the Indian National Congress declared Purna Swaraj as its goal in its Lahore session. Before 1920, it was just Swaraj, that is self-rule. Now it is about Purna Swaraj, that means complete independence from the British. If you see, somewhere Bhagat Singh's actions boosted the Congress and its newly elected president Jawaharlal Nehru's popularity. In other words, Jawaharlal Nehru capitalized on Bhagat Singh's popularity. If you see, Jawaharlal Nehru's role was secondary before becoming the president of the Indian National Congress in 1929. Now he is the central figure. So the rise of Jawaharlal Nehru started after the Simon Commission of 1928. Purna Swaraj was a document created by the Indian National Congress, which was basically like a constitution only. Nehru hoisted the newly adopted tricolour flag of India on 26 January 1930 on the banks of River Ravi in Lahore. The objective behind this resolution was to get complete freedom from the British, and as we all know, 26 January from there on was celebrated as Republic Day in India. Bhagat Singh, Rajguru and Sukhdev were executed on March 23, 1931, a little more than a year after the Congress called for Purna Swaraj. Many people think how things would have turned out if Bhagat Singh had not surrendered, because he really captured the imagination of the people, and somewhere his popularity helped Jawaharlal Nehru to rise so quickly to the top in the Congress. Now let's introduce Subhash Chandra Bose. As I said, a new cadre of leadership led by Jawaharlal Nehru and Subhash Chandra Bose was emerging in the late 1920s. Bose was a leader of the younger radical wing of the Indian National Congress. He joined the Indian National Congress Youth Wing in 1921. He also started a newspaper called Swaraj. He was the president of the All India Youth Congress and also the secretary of the Bengal State Congress. In 1924, he became the CEO of the Calcutta Municipal Corporation. Bose was sent to prison in Mandalay for nationalist activities in 1925. He was released in 1927 and became the Indian National Congress's General Secretary. He worked with Jawaharlal Nehru and the two became the Congress Party's young leaders, gaining popularity among the people. In 1930, he became the mayor of Calcutta. He was also elected as the president of Congress in 1939, but he resigned due to differences with Gandhi's supporters. He had differences with Gandhi and he was not a believer of non-violence as a tool for independence. So anyhow, he left the Congress in 1939. We will learn more on him as we go ahead with the timeline. So anyhow, let's get back to 1930. Jawaharlal Nehru hoisted the newly adopted tricolour flag of India on 26 January 1930 on the banks of River Ravi in Lahore. The objective behind this event was to get complete freedom from British. It's called Purna Swaraj. The party's agenda is fixed. Now they needed a plan to achieve it. It was decided that civil disobedience movement is the way to achieve Purna Swaraj. As usual, Gandhi was the man who was asked to plan and organize the act. Now to create a movement, you need a problem, a situation. Gandhi chose to break the salt tax that the British government had imposed. In his opinion, tax on salt was the most oppressive form of tax. As you know, salt is a basic necessity for humans. Gandhi started the Dandi March on 12th March 1930 from Sabarmati Ashram in Gujarat towards coastal village of Dandi. This whole march was about 390 km in distance. Gandhi and his followers started the march. They covered the entire length in 25 days. On 6th April 1930, they reached the coast of Dandi, and by picking up a handful of salt, Gandhi broke the salt laws and launched the mass civil disobedience movement. Even Sarojini Naidu was part of the Dandi March. This movement was a non-violent protest. It made way for many other peaceful protests against other kinds of oppressions that were going on all over the country. I want you to understand the weight of this civil disobedience movement. In Bihar, anti-Chaukidar tax campaign was initiated. In Gujarat, a no-tax movement took place against the payment of land revenue. In Maharashtra, Karnataka and central provinces, defiance of forest laws took place on a large scale. In Assam, a powerful agitation led by students was launched against the Cunningham Circular. In United Province, a no revenue, no rent campaign was organized against the government, which soon turned into a no rent campaign against the zamindars. So you see, Gandhi's civil disobedience movement gave a boost to many other movements across the country. And there were many Indians who hated Gandhi because their businesses were ruined due to these protests. I'm talking about the Indian zamindars, businesses and shop owners. Now during this time, the Governor General and Viceroy was Lord Irwin. In July 1930, the Viceroy suggested a roundtable conference. There were three reasons behind it. One, there was a nationwide boycott of British goods due to civil disobedience movement and it was hurting their business. Two, in UK, the Labour government had come to power and there was inadequacy in the Salmon Commission's report. And three, Muhammad Ali Jinnah had personally recommended this roundtable conference to Lord Irwin. The first roundtable conference took place from 12th November 1930 to 19 January 1931. Congress was not part of it because most of their leaders, including Gandhi, were in jail due to the civil disobedience movement. But representatives of all other Indian parties and number of princes participated. There were 58 political leaders from India and 16 delegates from the princely states. In total, 74 delegates from India attended the conference, but Congress was not part of it. Among the British Indians, the following representatives attended the conference: Muslim League, Hindus, Justice Party, Sikhs, Liberals, Parsis, Christians, Anglo-Indians, Europeans, landlords, Labour, women, universities, Sindh, Burma, other provinces, and the representatives from the Government of India. Now here are some of the issues discussed in the first roundtable conference. Although many principles on reforms were agreed upon, not much was implemented, and the Congress Party carried on its civil disobedience movement. The conference was regarded as a failure, and the British government understood the importance and the need for the Congress Party to make any decision on India's political future. So that is where the weight of the Indian National Congress increased in the eyes of the British. As I have told you, many Congress leaders including Gandhi were arrested for carrying out the civil disobedience movement. They all were released from jail on January 25th, 1931. The Congress Working Committee told Gandhi to initiate discussions with the Viceroy Lord Irwin. On 5th March 1931, a pact was signed in Delhi, which came to be known as Delhi Pact or Gandhi-Irwin Pact. So basically, Gandhi-Irwin Pact is the name given to a political agreement between Gandhi and Lord Irwin. In 1930, the Salt Satyagraha was conducted. India and Gandhi received worldwide attention. The British government in India was criticized for its unjust treatment of Indians. Lord Irwin wanted this issue to come to an end. That is why Gandhi was released from prison in January 1931. The Congress President, Sardar Vallabhbhai Patel, asked Gandhi to hold talks with Lord Irwin. The next roundtable conference took place on 7th November 1931. Viceroy Irwin requested Gandhi to attend the conference. He was the sole representative of the Congress. The Sikh, Muslim, Christians representatives wanted to safeguard their interests. Gandhi presented some of his demands. Few of them were passed, but the British government refused to entertain Gandhi's basic question of India's freedom. From the Congress viewpoint, the second roundtable conference ended in failure. Gandhi was disappointed. He came back to India on 29th December 1931 and resumed the civil disobedience movement. He was again arrested along with other Congress leaders. Because the plan of the British government was not to allow Gandhi and the Congress to build up the momentum of the civil disobedience movement, so the movement was effectively crushed within a few months. It is also said that 2 weeks before the second roundtable conference started, the Labour government in the UK had been replaced by the Conservatives. Now, whenever the Conservatives came in power, they were not at all interested in leaving India, because India was their biggest cash cow. So they were against the idea of Purna Swaraj that the Congress rallied on. Anyhow, the third and the last session of the roundtable conference took place between November 17, 1932 and 24 December 1932. Only 46 delegates attended since most of the main political figures of India were not present. The Labour Party from Britain and the Indian National Congress refused to attend. So there was no meaning behind the third roundtable conference. It was just for namesake. Now all the things that were discussed and suggested from 1930 to 1933 in the name of roundtable conferences and the Simon Commission report of 1930 were finally seen in the Government of India Act 1935. Before the beginning of the third roundtable conference, in the month of September 1932, the Pune Pact was signed between the Congress and B.R. Ambedkar. So Madan Mohan Malviya was the president of the Congress Party in 1932. He represented most of the Hindus and the Congress Party. On the other side, B.R. Ambedkar represented the depressed classes. In the second roundtable conference, B.R. Ambedkar demanded separate electorate for depressed classes or untouchables who are called scheduled castes today. Gandhi was against it. That is why he had clashes with Ambedkar. Although the British government fulfilled the demand of Ambedkar by giving separate electorates for depressed classes on August 15, 1932, but after signing the Pune Pact on 24th September 1932, instead of the 80 seats given by the British, the depressed classes got 148 seats. Madan Mohan Malviya signed the Pune Pact on behalf of Hindus and Gandhi, and Ambedkar on behalf of depressed classes. One thing we have to understand is that the civil disobedience movement led by Gandhi saw limited participation of Dalits. Somewhere the depressed classes were not moved by the concept of Swaraj. On the other hand, Gandhi wanted the upper caste to change their hearts towards the Dalits and give up the practice of untouchability. But Ambedkar's point of view was different. He saw the Dalit question as a political issue and not a social issue. That is why he was very adamant in demanding separate electorate for Dalits. But Gandhi said that separate electorate will create division among Hindus so much that it will lead to bloodshed. If you can recollect, the Government of India Act 1919 introduced the principle of communal representation by providing separate electorates for non-Brahmin groups, Sikh, Indian Christians, Anglo-Indians and Europeans. And the Indian Council Act of 1909 provided reserved seats for Muslims in the Imperial Legislative Council. So you see how the British created a split in the Indian society. So anyhow, the Pune Pact of 1932 was signed between Ambedkar and the Indian National Congress, which included Gandhi's consent too. In other words, Gandhi had to compromise with Ambedkar. On 6th March 1934, the Reserve Bank of India Act was passed, under which the Reserve Bank of India was formed. On 24 July 1935, the Government of India Act was passed by the British government. As I've told you, all the things that were discussed and suggested from 1930 to 1933 in the name of roundtable conferences and the Simon Commission report of 1930 were finally seen in the Government of India Act 1935. The Government of India Act 1935 was replaced by the Constitution of India after independence. The Indian leaders were not enthusiastic about this act, since despite granting provincial autonomy, the governors and the viceroy had many special powers. Then separate communal electorates were a measure through which the British continued the divide and rule policy and ensured the Congress party could never rule on its own. After the end of the civil disobedience movement around 1934, Gandhi temporarily withdrew from active politics. There was a small divide within the Congress. That's how in May 1934, Congress Socialist Party was formed. In 1936, majority of the Congress leaders, led by Rajendra Prasad and Vallabhbhai Patel, with blessing of Gandhi, decided to contest the provincial elections under the new Act of 1935. As per the Government of India Act 1935, it introduced direct elections in India for the first time. So provincial elections were held in British India in the winter of 1936. Elections were held in 11 provinces. They were Madras, Central Provinces, Bihar, Orissa, United Provinces, Bombay Presidency, Assam, Northwestern Frontier Province, Bengal, Punjab and Sindh. The 1937 election was the first in which large number of Indians were eligible to participate. Approximately 30 million people voted. Here are the results. And by the way, during this time, the Congress president was Jawaharlal Nehru. So he became the face of the winning party. As we know, elections were held in 11 provinces. Out of these 11 provinces, the Indian National Congress won in 8. The 3 provinces where they could not form the government were Bengal, Punjab and Sindh. On the other hand, the All India Muslim League failed to form the government in any province. And that's when the Congress rule first began in British India from 1937 to 1939. Muslim League started attacking the Congress regarding its insensitivity towards Muslim culture. Viceroy Linlithgow declared India at war with Nazi Germany on 3rd September 1939. As you know, the Second World War started in September 1939. The British government, without consulting the Indian leaders, who were just elected in previous election, declared India at war with Nazi Germany. The British government thought that if India supported in 1914 World War I, it was natural that India would do it again. But if you remember, during 1914, India supported the British in the World War I, but they were expecting Swaraj in return. And you also know the British disappointed the Indians. But this time the Indian National Congress demanded independence before. Only then it would help Britain. On the other hand, the Muslim League under the leadership of Jinnah promised to support the British in the war. Anyhow, Viceroy refused the demands of the Congress. On 22nd October 1939, all Congress ministries were called upon to tender their resignation. Both Viceroy Linlithgow and Muhammad Ali Jinnah were pleased with the resignations. The day when all the Congress ministries in the provinces resigned, the Muslim League were very pleased with it. They even observed December 23rd, 1939 as the Deliverance Day. By 1940, Jinnah and the Muslim League had come to believe that Muslims of the Indian subcontinent should have their own state. On March 21st, 1940, Muslim League ultimately came forward for the formation of independent state of Pakistan, making it the homeland of the Muslims. It was in this year that two-nation theory was introduced and Pakistan Resolution was passed. It is also called Lahore Resolution. It is also said that the idea of two-nation theory emerged in 1920 when the Aligarh Muslim University was formed, but officially it was rolled out in the form of Pakistan Resolution or Lahore Resolution in 1940. So anyhow, on 22nd October 1939, all Congress ministries resigned from the provincial assemblies for not supporting the British in World War II. As we know that the World War II was fought between the Axis powers, which included countries like Germany, Italy and Japan. They were fighting against the Allies, which consisted of France, Great Britain, the United States, the Soviet Union and to a lesser extent China. Initially, the Allies were suffering a lot in the war. Even Britain herself was in danger of being occupied by the Nazis. The British government was desperate to get Indian support for the war. That is when in the year 1940, Viceroy Linlithgow made a set of proposals called the August Offer. Here are the terms of the August Offer. For the first time, the right of Indians to frame their own constitution was acknowledged. But the Indian National Congress rejected this offer and demanded complete freedom from colonial rule. Even the Muslim League rejected the August Offer. They were interested in the partition of the country. So anyhow, it was only after the August Offer, Gandhi initiated the individual satyagraha to affirm the right to free speech. He avoided a mass satyagraha because he did not want violence. The people who participated were called satyagrahis. Many of them were jailed. As I said, the British were desperate to get Indian support for the war. Now, after the failure of the August Offer, the British government sent the Cripps mission to India in late March 1942 to get the Indian support for the war. The mission was headed by a senior minister, Sir Stafford Cripps. Cripps was sent to India to negotiate with the Indian National Congress leaders. Most of these leaders represented the majority Hindu population and the Muslim League, who represented minority Muslim population. Cripps said that the British government is willing to offer India a complete dominion status once the war was over. Dominion status means semi-independence from the British Crown, for example Canada and Australia. Anyhow, that was the whole proposal presented to the Indian leaders by Sir Stafford Cripps. Both the major parties, that is the Indian National Congress and the Muslim League, rejected this proposal because they knew that the ball was in their court and they cannot trust the British anymore. With this, the Cripps mission was a failed attempt by the British government to secure Indian cooperation in World War II. In the same year, on 8th August 1942, Gandhi launched the Quit India movement. It was a non-violent civil disobedience movement launched after the failure of Cripps' mission. If you can recollect, during the World War I in 1914, there were many people in India who had the opinion that if Britain got involved in a crisis somewhere, something like a world war, then the Indian extremists would use this as an opportunity to advance the idea of self-government. Although the opposite happened, the Indian leaders went on to support Britain in World War I and expected a reward from the British government. The British government hugely disappointed the Indian people after World War I. So this time during World War II, the Congress leaders did not repeat the same mistake. They refused to support Britain. Instead, the Quit India movement was launched. However, almost the entire leadership of the Indian National Congress was imprisoned without trial within hours of Gandhi's speech. Most of them spent the rest of the war in prison and out of contact with the masses. The British had the support of the Viceroy's Council, which had a majority of Indians like the All India Muslim League, the Princely States, the Indian Imperial Police, the British Indian Army, the Hindu Mahasabha and the Indian Civil Service. The British were able to take control of India mainly because India was not united. The British signed treaties and made military and trading alliances with many of the independent states. There were many Indian businessmen who were profiting from heavy wartime spending. Naturally, they did not support the Quit India movement. As a ruler of a princely state, you could not grant any political rights or allow the feeling of nationalism get into the minds of the people of your kingdom. That would cause rebellion. So they had to keep their kingdoms unexposed from these nationalist movements. And if you see, it was in the ruler's best interest. So naturally, many of the rulers of princely states did not support the Quit India movement. At that time, there were almost 600 princely states. So even if the British government did not receive any political support from its own controlled provinces, the British had enough support from the subcontinent. And then if you pay attention to Subhash Chandra Bose, he was in Germany. He even met Hitler and asked his help to support the cause of India's liberation from British rule. So what I'm trying to say is, if you look at the Indian political struggle only from the Congress party's point of view, then you also have to put it in right context. They were very much part of the freedom struggle. However, if you think that the British left India simply because of Mahatma Gandhi's non-violent movements and the political smartness of the Indian National Congress, that is also not fully true. As I've told you, many of the Indian people were against India's civil disobedience movement. And then if you look at it from international level, no country in the world was supporting India from outside. I think the only outside support came from the Americans, when President Roosevelt told Prime Minister Winston Churchill during World War II to give in to some of the Indians' demands, which was not even that effective. Even the Quit India movement was crushed by the British. So all the notion that British left India simply because of Gandhi's non-violent movements and the smartness of Indian National Congress is not fully true. And this is where Subhash Chandra Bose played an important role from outside India. But most of his contribution is ignored from our school history books. When Bose met Hitler in May 1942, Bose was in Germany from April 1941 to February 1943. The reason he went to Germany was because he had this concept that your enemy's enemy is your friend. And we know that Britain was fighting with Nazi Germany in World War II from 1939 to 1945. So he looked at Nazi Germany as an ally. Anyhow, there's a long story behind that. What you need to know is that the World War II was fought between the Axis powers, which included countries like Germany, Italy and Japan. They were fighting against the Allies, which consisted of France, Great Britain, the United States, the Soviet Union, and to a lesser extent China. When Bose arrived in Germany, he realized that Germany was busy forming fighting strategies against the Soviet Union. When Japan declared war against Great Britain and the US on December 7, 1941, the Japanese army was advancing towards the Indian frontier from the northeastern side, basically from the Burma side. Bose left from Germany to Japan towards the end of 1942. By then, Imperial Japan had conquered Burma. Tens of thousands of Indian Jawans were held as prisoners of war by the Japanese army. Bose wanted to make an army with the help of these captured Indian Jawans. And that was the reason behind his journey to Japan. You see, Subhash Chandra Bose played an important role in getting India freedom. So if you simply think that British left India because of Mahatma Gandhi's non-violent movement and the political smartness of the Indian National Congress leaders, that is not fully true. In fact, there is a conversation between the former British Prime Minister Clement Attlee and the then Governor of West Bengal, Justice P.V. Chakrabarty. Clement Attlee was the Prime Minister of UK during the time between 1945 to 1951, when India got independence. In that conversation, Attlee said, it was a result of the military activities of Netaji Subhash Chandra Bose that compelled the British to leave India. And he also said that Gandhi's influence upon the British decision to quit India was minimal. I'm not trying to disrespect the Indian National Congress and Mahatma Gandhi for their political efforts, and also their feelings and emotion towards the people of India in every mass movement that they created were genuine. But if you look at most of Indian history textbook about the freedom struggle, they are dominated by the role played by the non-violent movement of Mahatma Gandhi, Ahimsa and Satyagraha. But you have to understand the fact that India's freedom was not gained entirely by the non-violent struggle of Mahatma Gandhi. It also had the contribution of force imposed by Netaji Subhash Chandra Bose. Let's get back to the timeline. In August 1942, the Indian National Army was formed. It is also called Azad Hind Fauj. It consisted of British Indian soldiers who were captured by Japan. Indian National Army was formed with the help of Imperial Japan, and its aim was to secure independence for India from British rule. Although the army was formed under Mohan Singh, it was later on handed over to Netaji Subhash Chandra Bose. In 1943, the Bengal famine killed up to 4 million people. The main reason behind this famine is due to Winston Churchill's policy failure. Winston Churchill was the Prime Minister in UK during the World War II. He belonged to the Conservative Party, and I've already said, whenever the Conservatives come in power, they were not at all interested in leaving India because India was the biggest cash cow for them. If you have watched Shashi Tharoor's video, Does Britain Owes Reparations, in that he has said it was because of Winston Churchill's policy failure that caused the Bengal famine. he diverted the supplies of rice from the coastal areas of Bengal to Europeans as reserve stockpiles. We know that the Quit India movement was started in August 1942. After that, almost entire leadership of the Indian National Congress, including Gandhi, was imprisoned. They were cut off from the rest of the world for over 3 years. Most Congress leaders were kept in prison till 1945. That is when the World War II ended. But Gandhi was released in 1944. In the same year, his wife Kasturba Gandhi died. During this time, the Governor General and Viceroy was Lord Wavell. On 25th June 1945, there was a meeting between the Viceroy Lord Wavell and all major political leaders of British India, including Gandhi and Jinnah, in Shimla, which came to be known as Shimla Conference of 1945. The aim of this conference was to make a plan for Indian self-government. Now, the Muslim League and the Indian National Congress were not coming to an agreement. The conference was a failure because the Muslim League and the Congress could not settle their differences. After this, the World War II ended and a new Labour government was elected in Britain. This new government was keen on giving independence to India without much delay and sent the cabinet mission with that purpose. At this time, Clement Attlee was the Prime Minister of UK. He decided to send a mission to India for the transfer of powers from the British Indian government to Indian leaders. The mission had 3 British cabinet members, Pethick Lawrence, Stafford Cripps, and A.V. Alexander. The main objective of cabinet mission was the transfer of power from the British Indian government to Indian leaders by framing a constitution and set up an interim government. Even the cabinet mission failed because the Muslim League and the Congress could not settle their differences. Both parties had many ideological differences and could not find common ground. Since the plan was not accepted, a new plan was proposed by the mission in June 1946. This plan proposed the division of India into a Hindu-majority India and a Muslim-majority India, later to be renamed Pakistan. A list of princely states was also made that could either join the Union or remain independent. The Congress party under Jawaharlal Nehru did not accept the second plan, but he agreed to be part of the Constituent Assembly. The Viceroy invited 14 men to form the interim government. There were 5 from the Congress, 5 from the League, 1 member each representing the Sikh, Parsi, Indian Christian and scheduled caste communities. Nehru headed the interim government. The new government began the task of framing a constitution for the country. Congress-led governments were formed in most provinces, including the Northwestern Frontier Province. In Bengal and Sindh, the League formed the governments. Jinnah and the League objected to the new central government. Jinnah geared to agitate for Pakistan and urged Muslims to demand Pakistan by any means. He called for a Direct Action Day on 16th August 1946. Direct Action Day was a large-scale rioting in Calcutta. There was a massive communal bloodshed between Hindus and Muslims in Calcutta. This riot had spread till Punjab and in northwestern frontier provinces. Many people died. When all of this was happening, the British government did not do anything to stop this riot. It was as if the British government were laughing, looking at Indian Muslims and Hindus killing each other. All this bloodshed and communal tension ultimately led to the Congress's acceptance of the partition of the country in order to stop the violence and bloodbath. In the middle of all these communal riots, on 21st February 1947, Lord Mountbatten arrived in India as the last Viceroy of India. On 3rd June 1947, Mountbatten proposed the partition plan to divide British India into independent dominions of India and Pakistan. It was also known as the Mountbatten Plan. In the month of August 1947, the leaders of the Muslim League and Indian National Congress formally communicated their acceptance of the plan for the partition of the subcontinent into Pakistan and India. Gandhi was against the partition of India. He was very much distressed and advised people not to accept partition by heart. But things had gone way ahead, so Gandhi had to forcefully accept it. From 11th August 1947 to 13th August 1947, partition violence erupted in Sialkot and drove the surviving Hindus and Sikh to Jammu. All the Hindus and Sikh who lived in Sialkot region fled to Jammu. On 14th August 1947, Pakistan was created with Muhammad Ali Jinnah as their Governor General. And on 15th August 1947, the British government transferred the power of India into the hands of Indian National Congress, with Jawaharlal Nehru as the first Prime Minister. As I've told you in the beginning, partition happened only of the British-controlled provinces. That meant after 15th August 1947, the princely states would be completely independent and they would not receive any form of help or support from the Government of India for defense, finance and other infrastructure. Now these independent princely states had two options, either to join India or to join Pakistan. Many say that there was also an option to remain independent, but then you need to understand that most of these princely states were landlocked entities and were functioning with huge support from the British government. Now that the British government were no longer there, someday they had to merge with India for administration support. And the British knew this. In fact, they wanted to look good while advising these rulers to accede with India or Pakistan, because then they can tell the whole world that they helped India become unified. With this, we have come to an end of this video. There's another part of this video where I have covered the modern history from 1600 to 1857, and in this video from 1857 to 1947. So together it wraps up the entire modern history of India. I hope you found this video informative. Let me know your thoughts in the comment section, and thanks for watching it.
Yes. Namaskar to all of you. Yes. So, yes, namaskar to all of you. This is Byomkas Meher. I welcome all of you in this Unacademy studio. Let's crack UPSC CSC. Okay? So today I'm going to discuss about a very most important topic of the history, and that is the modern history. And आज मैं modern history का summary आप लोगों को बताऊंगा, और मैं कोशिश करूंगा कि summary में ही सारे चीजें मैं बता दूं, सारे topics में बता दूं. I'll cover every topic. Give me 1 second. Okay, fine. So I'll cover the summary of history. जैसे कि हिस्ट्री की मैं अगर बात करूं, हिस्ट्री इज डिवाइडेड इनटू 3 पोर्शन, दैट इज एंशिएंट हिस्ट्री, मेडिवल हिस्ट्री एंड मॉडर्न हिस्ट्री. और एग्जामिनेशन पॉइंट ऑफ व्यू, चाहे वो प्रीलिम्स हो चाहे मेंस हो, एग्जामिनेशन पॉइंट ऑफ व्यू सबसे रेलिवेंट जो है वो मॉडर्न हिस्ट्री है, और उसी का हम लोग आज समरी जो है डिस्कस करेंगे. ठीक है, आवाज़ क्लियर आ रही है मेरी? माई वॉइस इज ऑडिबल? आवाज़ क्लियर है? अगर आवाज़ क्लियर है एंड पीपीटी भी दिख रहा है तो ऑल क्लियर लिख दीजिए. एक बार ऑल क्लियर लिख दीजिए ताकि मैं समझ सकूं कि सब कुछ ठीक है. ठीक है. सो बिफोर स्टार्टिंग द टॉपिक, वन थिंग आई मस्ट से कि किसी भी प्रकार का डाउट है, किसी भी प्रकार का क्वेरीज है, किसी भी प्रकार का कंडक्ट करना चाहते हो, एडमिशन से रिलेटेड हो सकता है, आइकनिक सब्सक्रिप्शन से रिलेटेड हो सकता है, ऑप्शनल से रिलेटेड हो सकता है, हिस्ट्री, पॉलिटी, ज्योग्राफी, इकोनॉमिक्स, करंट अफेयर्स से रिलेटेड हो सकता है, तो आप यहाँ पर ज्वाइन कर सकते हो unacademy@byomkas meher के नाम पे. और यहाँ पर जो है आपको सबसे मेन चीज़ है फ्री पीडीएफ मिलेगा यहाँ पर. ठीक है, फ्री पीडीएफ. बहुत सारे बच्चे जो है पूछते रहते हैं सर पीडीएफ भेज दो, पीडीएफ भेज दो। तो इंडिविजुअली हर एक मैसेज में भेजना थोड़ा सा पॉसिबल नहीं होता, आप समझ सकते हो, बहुत सारे बच्चों का मैसेज आता है। बट यहाँ पे आप ज्वाइन करके आप डायरेक्टली खुद से भी पीडीएफ ले सकते हो। और यहाँ पर सारे टॉपिक के पीडीएफ होंगे, हिस्ट्री के पीडीएफ होंगे, पॉलिटी के होंगे, जियोग्राफी के होंगे, इकोनॉमिक्स के होंगे और करंट अफेयर्स के होंगे। ठीक है, तो ऑलमोस्ट जो चीज़ें चाहिए आपको सिविल सर्विस में, सारे पीडीएफ, सारा यूट्यूब के लिंक्स, सारे जो है प्लस के लिंक यहाँ पर मिल जाएगा। तो यू कैन, और किसी भी प्रकार का क्वेरीज है, ये है, तो आप यहाँ ज्वाइन करने के बाद सब कुछ आपको अवेलेबल कर दिए जाएंगे। क्लियर है पॉइंट? एंड देखो हम लोग जो है इम्पल्स सीरीज ला रहे हैं, और ये जो है इसी चैनल पे नहीं है, लेट्स क्रैक चैनल पे नहीं है, एक और चैनल है यूपीएससी सीएससी के नाम पे। ठीक है, मतलब यूपीएससी के नाम पे अलग चैनल है, उसमें जो है हम लोग सारे जो चैनल के जो हेड हैं, दीज आर द फैकल्टीज, सारे चैनल के अलग अलग फैकल्टीज हैं, और ये सब का अलग अलग क्लासेस होगी। आप देख सकते हो क्लासेस, यू कैन टेक स्क्रीनशॉट ऑफ दिस थिंग, ताकि आप जो है उसके हिसाब से क्लास ले सको। देखिए आप 9:45 AM पे साइंस एंड टेक जो लेंगे सचिन सर लेंगे, 10:30 AM पे करंट अफेयर्स जो लेंगे मनवेंद्र सर लेंगे, एंड 11 AM पे इंडियन ज्योग्राफी दुर्गेश सर, 11:30 AM पे पॉलिटी बाय द पवन सर, 3 बजे जो है इंटरनेशनल रिलेशन बाय द सिद्धार्थ सर, और 6 बजे आशीर्वाद सर लेंगे इकोनॉमिक्स। उसके बाद जो है फिजिकल ज्योग्राफी किंजल सर, एनवायरमेंट एंड इकोलॉजी 8 PM पे अजित सर। उसके बाद जो है मैं आप लोगों का क्लास लूंगा 9 PM पे। आई विल टेक द क्लास ऑफ 9 PM, दैट इज हिस्ट्री। 9 PM पे मैं जो क्लास लूंगा हिस्ट्री, तो एवरीडे ये जो है 9 PM पे ध्यान रखना, आपका जो टॉपिक होगा दैट इज हिस्ट्री। हिस्ट्री में टोटल जो है कवर कर रहा हूं। ठीक है, अब जो है एंशिएंट हिस्ट्री चल रहा है वहां पे। ठीक है, और 10 से 11 बजे जो चीजें हैं आपको ऐप में मिल जाएंगे बेटा। क्विज कंपटीशन डेली बेसिस में करता हूं, उसमें आप ज्वाइन कर सकते हो। ठीक है, आज का सेशन जो है इंपोर्टेंट सेशन है, मजेदार होने वाला है। बहुत कम टाइम में मैं समरी बताऊंगा, तो आज का सेशन को ज्यादा से ज्यादा शेयर कर सकते हो, लाइक कर सकते हो, और ऑल्सो अपने दोस्तों के साथ शेयर कर सकते हो। ठीक है, चैनल को भी सब्सक्राइब कर सकते हो। एंड ये जो पॉलिटी वाला सीरीज जो है मैं ले रहा हूँ यहाँ पे, पॉलिटी वाला सीरीज का जो टाइमिंग नॉर्मली इसी टाइमिंग की होती है, 2:30 PM पे डेली, ध्यान रखना 2:30 PM पे डेली होती है, पॉलिटी का सीरीज होती है। क्लियर है पॉइंट? और देखो प्लस का फायदा क्या है, प्लस का फायदा है आपको डेली बेसिस पे लाइव क्लासेस मिलते हैं, डाउट क्लियरिंग क्लासेस मिलते हैं, एक्सपीरियंस एजुकेटर रहते हैं, प्री रिकॉर्डिंग वीडियोज रहता है, अनलिमिटेड एक्सेस टू द प्लस कोर्सेज, उसके साथ साथ मतलब लर्न एट एनी टाइम एनी प्लेस। ये सबसे बड़ी खासियत है, आप देख सकते हो, जिसमें आपको डेली बेसिस पे लाइव क्लासेस मिलेंगे डेली बेसिस पे। उसके बाद जो है स्ट्रक्चर कोर्स रहेगा, सिस्टमेटिक कोर्स रहेगा। उसके साथ साथ जो है लाइव टेस्ट क्विज भी होंगे। ठीक है, मॉक टेस्ट होगा, उसके साथ साथ टोटल टेस्ट भी होगा, और अनलिमिटेड एक्सेस टू द प्लस कोर्सेस। मतलब हर एक टॉपिक आप देख सकते हो, हिस्ट्री, पॉलिटी, ज्योग्राफी, इकोनॉमिक्स, हर एक टॉपिक आप देख सकते हो। और अगर अनअकैडमी लर्निंग ऐप आपने इंस्टॉल नहीं किया है, तो ये आप इंस्टॉल कर सकते हो, डाउनलोड कर सकते हो। ये गूगल प्ले या ऐप स्टोर पे अवेलेबल होती है, आप इंस्टॉल कर सकते हो, जिसमें आपको बहुत सारी चीजें मिल जाएंगी। दिस आर द टॉप एजुकेटर एंड अबाउट मी, आई एम पास आउट फ्रॉम दिल्ली स्कूल ऑफ इकोनॉमिक्स। दिल्ली स्कूल ऑफ इकोनॉमिक्स से पास आउट हूँ, DSC दिल्ली यूनिवर्सिटी से। उसके साथ साथ जवाहर नवोदय विद्यालय नरला से हूँ, और उत्कल यूनिवर्सिटी वाणी विहार से मैंने अपनी मास्टर डिग्री भी की है, और ऑल्सो मास्टर डिग्री इन दिल्ली स्कूल ऑफ इकोनॉमिक्स पे। ठीक है, 2 बार मैंने की है। ठीक है, चलिए। एंड उसके साथ साथ देखो, अगर मैं प्लस की बात करूं कि ये मेरा रेफरल कोड है, BM लाइव रेफरल कोड है, जिसमें आपको 10% का जो है डिस्काउंट मिलता है बेटा। ठीक है, उसमें 1 साल का आपको पड़ जाएगा बेटा डिस्काउंट के साथ 44,550, और 2 साल का आपको पड़ेगा डिस्काउंट के साथ 64,000। और सबसे बढ़िया चीज मैं रिकमेंडेशन करूंगा आपको आइकनिक वाला, जिसमें आपको एक मेंटर प्रोवाइड होंगे, मेंटर और एक फैकल्टी प्रोवाइड होंगे। ठीक है, जो कि आपको गाइड करेंगे हर एक स्टेज में, क्या पढ़ना है, क्या नहीं पढ़ना है, किस तरह से तैयारी करनी है। प्रीलिम्स की तैयारी किस तरह से करनी है और मेंस की तैयारी किस तरह से करनी है। प्रीलिम्स के लिए कौन कौन सी किताब चाहिए, मेंस के लिए कौन सी किताब चाहिए, उसके साथ साथ मेंस में आंसर राइटिंग प्रैक्टिस आप लिख के भेजोगे, हम लोग रेक्टिफाई करके देंगे। तो हर एक स्पेशल मतलब आप ऑप्शनल क्या रखोगे, किस पे, देखो सबका बैकग्राउंड अलग अलग होती है, कोई आईआईटी से है, कोई मेडिकल से है, कोई +2 के बाद पढ़ रहा है, कोई ग्रेजुएशन में है, कोई 3-4 बार अटेम्प्ट दे चुका है, तो सबकी लेवल अलग अलग होती है, सबका ऑप्शनल भी अलग अलग होती है, सबकी एजुकेशनल बैकग्राउंड भी अलग अलग होती है, सबकी रीजन भी अलग अलग होती है, कोई दिल्ली में है, कोई उड़ीसा से है, कोई छत्तीसगढ़ से है, कोई बिहार से है, कोई नागालैंड से है, समझ रहे हो। तो आपको आपके हिसाब से एक प्रॉपर गाइड मिलेगा। और ये तो जरूरी है, देखो अब दिल्ली में आना बेटा, दिल्ली में आके कोचिंग करना, 2 लाख तो ऐसे ही पड़ेंगे कोचिंग का फीस, और दिल्ली में पर ईयर रहने का खर्च आप मान लो 2 लाख है, 2 साल रहोगे तो 4 लाख हो गया, तो 2 लाख कोचिंग का फीस, 2 साल रहते हो तो आपका ऐसे ही मतलब 4 लाख हो गया, तो 6 लाख हो गया। तो ये आपको कम टाइम में, मतलब 1 साल का यहाँ पर फीस है आपको देखो केवल 62,000 और 2 साल का फीस है आपका 96,000, मतलब 1 लाख के करीब। जो 6 लाख आप खर्च कर रहे थे, 1 लाख में आपको 2 साल का मिल रहा है, और वो भी घर बैठे बैठे घर का खाना खाते हुए। देखो बड़े लेवल का जब हम लोग गेम करते हैं ना, बड़े लेवल का गेम खेलते हैं, यूपीएससी बड़े लेवल का गेम है, एशिया का टफेस्ट एग्जामिनेशन में आता है, तो उसको हम ऐसे ही क्लियर नहीं कर सकते, ऐसे हवाबाजी में 2-3 महीना पढ़ लिया और क्लियर कर लिया, ऐसे में नहीं होता। कंसिस्टेंट चाहिए, मैं तो मानता हूं कि 1-1.5-2 साल चाहिए उसके लिए तैयारी, और 1-2 साल में बहुत सारी चीजें होती हैं, ऑप्शनल क्या रखना है, प्रीलिम्स की तैयारी कैसे करनी है, तो एक मेंटर की सख्त जरूरत होती है। मैं तो मानता हूं कि मेंटर की हमेशा जरूरत होती है, और ये केवल अनअकैडमी प्लेटफॉर्म में ये है कि आप एक स्पेशल मेंटर मिलता है जो आपको हमेशा कभी भी 24/7 गाइड कर सकता है। तो आप चाहते हो कि मैं आपका मेंटर बनूं, तो ये मेरा रेफरल कोड है, BM Live इज माय रेफरल कोड, आप उस कोड का इस्तेमाल कर सकते हो। ध्यान रखना कि अगर चाहते हो कि मैं आपका मेंटर बनूं, तो ये BM Live, ठीक है, एडमिशन करते वक्त BM Live कोड डाल देना। तो BM Live कोड डालने से 2 चीज होगा, एक तो पहला है 10% का आपको डिस्काउंट मिल जाएगा, सेकेंड थिंग है डायरेक्टली मेरे ईमेल पे मैसेज आ जाएगा मेरे प्रोफाइल पे कि आपने मेरे नाम पे एडमिशन किया है। तो उस दिन से मैं आपको गाइड करना स्टार्ट कर दूंगा, हिस्ट्री, पॉलिटी, ज्योग्राफी, इकोनॉमिक्स, करंट अफेयर्स, हर एक चीज में प्रॉपरली गाइड करूंगा, ठीक है। और मेरी कोशिश ये रहेगी कि अच्छे से अच्छा रैंक लाने की मैं कोशिश करूंगा। क्लियर है पॉइंट। तो दिस इज माय रेफरल कोड BM Live, जिसमें और किसी भी प्रकार का क्वेरीज है आप यहाँ पे बात कर सकते हो, unacademy@bmquiz में जुड़ सकते हो, ठीक है। यहाँ पे जुड़ जाओगे तो सारी चीजें पता चल जाएगा आपको, जो भी मन में डाउट है वगैरह सब कुछ, एवरीथिंग, ठीक है। देन उसके साथ ये सब ऑप्शनल है हम लोगों के पास, ठीक है। पब्लिक एडमिनिस्ट्रेशन, PSIR, साइकोलॉजी, सोशियोलॉजी, हर एक ऑप्शनल है, ठीक है। उसके साथ साथ देखो एक हम लोग क्विज कंपटीशन कर रहे हैं जो कि अनअकैडमी कमबैक के नाम पे एक क्विज कंपटीशन चल रहा है। तो जो कंप्लीटली फ्रीली एनरोल कर सकते हो, वही रेफरल कोड सेम रहेगा BM Live, जिसमें हम लोग टॉप 10, टॉप 100 को हम लोग प्राइज देंगे। टॉप 100 के लिए प्राइज है 1000 वाउचर है। उसके साथ साथ फर्स्ट, सेकंड, थर्ड के लिए तो स्पेशल है ही। फर्स्ट वालों के लिए एप्पल मैकबुक है करीब करीब 1 लाख का, सेकंड प्राइज है एप्पल आईपॉड है करीब करीब 50-50,000 वाला, और थर्ड जो है एप्पल आईपैड है करीब करीब 15,000 वाला। तो ये लेकिन टॉप 100 को हम लोग प्राइज करेंगे। ये हर एक अल्टरनेटिव संडे में होगा, ध्यान रखना। ये कब होगा? हर एक अल्टरनेटिव संडे में ये होगा, और ये 60 क्वेश्चन रहेंगे और केवल 45 मिनट्स। और ध्यान रखना हर एक संडे होगा कितना बजे? 11 AM पे, मतलब एक संडे छोड़ के एक संडे में होगा, ठीक है। और उसमें भी आप ज्वाइन कर सकते हो। ये भी देखना फ्री ऑफ कॉस्ट है, ये उसमें कोई पैसा देने की जरूरत नहीं है, फ्री ऑफ कॉस्ट है, ठीक है बेटा। और एक चीज मैं बता दूं, आज से मैं कैलकुलेशन करूं, ठीक है, आज से मैं कैलकुलेशन करूं तो हम लोग का जो प्रीलिम्स एग्जाम होने वाला है करीब करीब 6 मंथ है, 6 मंथ बाकी है। कब होने वाला है? ये जून 27 को होने वाला, तो करीब करीब 6 महीना बाकी है। तो 6 महीने में अनअकैडमी की तरफ से आप देख सकते हो हर एक प्रकार का हम लोग कोर्स लॉन्च कर रहे हैं, हर एक प्रकार का कोर्स हम लोग स्टार्ट कर रहे हैं, ठीक है। तो हर एक प्रकार का कोर्सेस है, जिसमें 6 महीने का कोर्स है, 1 ईयर का कोर्स है, 2 ईयर का कोर्स है, और कोड सेम रहेगा। BM Live विल बी द कोड सेम रहेगा अगर एडमिशन करना चाहते हो। और एक चीज बता दो, ये 31 दिसंबर तक है ये प्राइस, और फिर जो है 1 जनवरी 2021 से ये प्राइस जो है बढ़ने वाला है, ठीक है। आइकनिक प्राइस विल हाइक आफ्टर द 1 जनवरी। तो अगर आज और कल हमारे पास वक्त है, अगर आप लोग सीरियसली तैयारी कर रहे हो, एडमिशन करना चाहते हो तो वक्त है, उसके बाद जो है प्राइस बढ़ने वाला है, ठीक है। जनवरी में भी 1 जनवरी से ही भी बढ़ जाएगा, तो आज और कल का वक्त है, ठीक है। और एक होती है, ध्यान रखना कि यहाँ पर जो है EMI सिस्टम होते हैं, पर महीना भी आप दे सकते हो, बट उसके लिए क्रेडिट कार्ड चाहिए या फिर HDFC बैंक में ATM चाहिए, ठीक है। कोई भी दिक्कत होती है एडमिशन से रिलेटेड, आप ग्रुप में कंडक्ट करिए, मुझे कंडक्ट करिए, ठीक है, आप कंडक्ट कर सकते हो, ठीक है। चलिए, तो आज का जो टॉपिक है आप देख सकते हैं, ठीक है। आज का जो टॉपिक है मॉडर्न हिस्ट्री, ठीक है। जो मॉडर्न हिस्ट्री के बारे में हम लोग बात करेंगे, और ये सारे टॉपिक के बारे में बात करूंगा। आज का जो पहला चीज मैं बता देता हूं, आज का जो टॉपिक है कि आज का टॉपिक में हम लोग केवल जो है समरी पे बात करेंगे। ओनली विल डिस्कस्ड अबाउट द समरी, ठीक है। समरी कि किस प्रकार से हुआ था इंसिडेंट, मतलब टू द पॉइंट पे ही बात करेंगे। तो ज्यादा हर एक टॉपिक, क्योंकि आज के डेट में हम लोग कम से कम करीब मोर देन 30-35 टॉपिक विल डिस्कस। तो हर एक टॉपिक में जब बात करेंगे तो हर एक टॉपिक में थोड़ा सा, मतलब हर एक टॉपिक में डिटेल में हम लोग नहीं जाएंगे। हम लोग क्या करेंगे, हर एक टॉपिक में ब्रीफली हम लोग जाएंगे, ठीक है। तो आज का टॉपिक जो है, बस आप सुनते रहिए, आप देखते रहिए, मजा आता रहेगा, ठीक है, मजा आता रहेगा। और आज का टॉपिक मतलब कम टाइम में मैं कोशिश करूंगा आप लोगों को मॉडर्न हिस्ट्री का पूरा जो है लेक्चर आपको कंप्लीट करके दूं, पूरा टोटल मॉडर्न हिस्ट्री जो है मैं कंप्लीट करके दूं आज, ठीक है। आर यू रेडी फॉर दैट? आज के टॉपिक के लिए रेडी हो आप लोग, तैयार हो? आज थोड़ा सा लंबा टाइम तक चलेगा क्लास, ठीक है, काफी देर तक चलेगा, तो आप लोगों का थोड़ा सा एनर्जी लेवल ज्यादा चाहिए आज के लिए, ठीक है। रेडी हो ना? आज पूरा लंबा टाइम, पूरा आज देश को आजाद करके ही छोड़ेंगे, ठीक है। कोई बच्चा पूछ रहा है कि कितना टाइम तक चलेगा, सर आज देश को आजाद करके ही छोड़ेंगे, पूरा फ्रीडम स्ट्रगल, इंडियन इंडिपेंडेंस। देखिए आप, मैं क्या क्या टॉपिक आज पढ़ाऊंगा मैं बता देता हूँ। बहुत कोशिश करूंगा कि 3-4 घंटे के अंदर, विद इन 3-4 आवर्स के अंदर मैं सारे टॉपिक का मॉडर्न हिस्ट्री का आपको समरी करके दे दूं। ये 2 रीजन में ज्यादा फायदा होगा। अगर आप शुरुआत करना चाहते हो, मॉडर्न हिस्ट्री पढ़ना चाहते हो, तो एक तरफ से ये समरी होगा, या फिर आप कभी कभार चीजों को रिवीजन करना चाहते हो तो उसके लिए बेस्ट होगा। और कभी कभी क्या होता है, पढ़ने का मूड नहीं करता है, ऐसा लगता है कि कोई स्टोरी सुना दे यार, बस हम थोड़ा सा लेटे रहें या फिर एक्सरसाइज करते रहें, वर्कआउट करते रहें या खाना बनाते रहें, कोई स्टोरी सुना दे बस। तो उसके लिए ये वीडियोस है, ठीक है। हर एक टॉपिक में डिटेल, पहले से बता रहा हूं, हर एक टॉपिक में डिटेल में नहीं जाऊंगा, लेकिन हर एक टॉपिक को डिस्कस करूंगा, ठीक है। लेकिन हर एक टॉपिक को डिस्कस करूंगा, बट समरी के हिसाब से डिस्कस करूंगा। तो आज का वीडियो का पर्पस ही अलग है, ठीक है। तो जो टॉपिक ऑफ डिस्कशन टुडे आई विल डिस्कस द टॉपिक पार्टीशन ऑफ बंगाल, स्वदेशी मूवमेंट जो कि 1905 में हुआ था। देन आई विल डिस्कस अबाउट द मुस्लिम लीग, कलकत्ता सेशन 1906 में हुआ था। देन आई विल डिस्कस अबाउट द सूरत स्प्लिट जो 1907 में हुआ था। देन आई विल डिस्कस अबाउट द पार्लियामेंट्री रिफॉर्म जो 1909 में हुआ था। देन आई विल डिस्कस अबाउट द होम रूल मूवमेंट 1916 और लखनऊ पैक्ट भी 1916 में हुआ था। उसके बाद भी है, उसके बाद जो है रोलत एक्ट जो 1919 में हुआ था, जलियांवाला बाग हत्याकांड जो 1919 में हुआ था। उसके साथ साथ जो है नॉन कोऑपरेशन मूवमेंट 1920 से 22 तक हुआ था। उसके साथ साथ खिलाफत मूवमेंट, आप देख सकते हो खिलाफत मूवमेंट सेम ईयर है, 20 से 22 है। उसके बाद जो है स्वराज पार्टी का गठन हुआ था 1923 में। देन उसके बाद साइमन कमीशन, देखो साइमन कमीशन आया था 27 में, बट मतलब गठन हुआ था 27 में, इंडिया आया था 28 में। उसके बाद नेहरू जी का रिपोर्ट 1928 में, ठीक है। उसके बाद फिर हम लोग डिस्कस करेंगे 14 पॉइंट ऑफ जिन्ना के 14 विंदियां और लाहौर सेशन जो कि 1929 में हुआ था। उसके बाद जो है दांडी मार्च जिसको कहा जाता है सिविल डिसोबीडियंट मूवमेंट भी कहा जाता है, क्लियर है, सॉल्ट सत्याग्रह भी कहा जाता है। और ये कब हुआ था? 1930 में। उसके बाद जो है फर्स्ट राउंड टेबल कॉन्फ्रेंस, सेकंड राउंड टेबल कॉन्फ्रेंस एंड थर्ड राउंड टेबल कॉन्फ्रेंस विल डिस्कस। देन उसके बाद कांग्रेस मिनिस्टर रेजिग्नेशन 1939 में, ठीक है। देन उसके बाद जो है क्रिप्स मिशन, INA एंड क्विट इंडिया मूवमेंट जो 1942 में हुआ था। देन आई विल डिस्कस अबाउट द सारे प्लान, CR प्लान, शिमला कॉन्फ्रेंस, कैबिनेट, दैट इज कैबिनेट मिशन प्लान, माउंटबेटन प्लान, एंड फाइनली we'll discuss about the Indian Independent Act, that is 1947, ठीक है। फिर से बता देता हूँ टॉपिक स्टार्ट करने से पहले, आज का जो टॉपिक है, किसी भी टॉपिक में हम लोग डिटेल में नहीं जाएंगे, हर एक टॉपिक को ब्रीफली जाएंगे। थोड़ा सा आज ज़्यादा एनर्जी चाहिए आप लोगों को, ठीक है, और थोड़ा सा ये वीडियो जो है लंबा सेशन होगा। तो एक स्टोरी टेलिंग मेथड में, स्टोरी के हिसाब से इतिहास को जिंदा करने की कोशिश करूंगा, इतिहास को आप लोगों के सामने प्रेजेंट करने की कोशिश करूंगा एक स्टोरी वे में। समझ रहे हो चीजें? चलिए, तो सबसे पहले ये वाला पोर्शन देखते हैं हम लोग कि पार्टीशन ऑफ बंगाल, स्वदेशी मूवमेंट 1905, मुस्लिम लीग कलकत्ता सेशन 1906, सूरत स्प्लिट 1907, मॉर्लेम इंटू रिफॉर्म 1909, होम रूल मूवमेंट 1916 एंड लखनऊ पैक 1916। ठीक है, चलिए पहले ये टॉपिक को देखते हैं हम। चलिए, कौन सा कलर आपको ज्यादा प्रोमिनेंट लग रहा है? कौन सा कलर अच्छा दिख रहा है बताओ? रेड कलर, वाइट, रेड, पर्पल और येलो, कौन सा ज़्यादा अच्छा लग रहा है बताइए फटाफट, उसके हिसाब से हम लोग चलेंगे। प्रोमिनेंट आपको कौन सा दिख रहा है कलर? थोड़ा सा आप आज के आपके डिमांड के हिसाब से पढ़ाते हैं आज, और जैसे क्लासरूम में पढ़ाई होती है ना उस तरीके से पढ़ाऊंगा आज, बिल्कुल। रेड, वाइट, वाइट, रेड, वाइट, वाइट। ठीक है, थैंक यू। चलिए, व्हाइट कलर का डिमांड ज़्यादा आ रहा है तो व्हाइट कलर से कर लेते हैं, ठीक है, ओके फाइन। आप जैसे बोलोगे वैसे करेंगे सरकार, आपके लिए ही कर रहे हैं, ठीक है। चलिए, तो सबसे पहला चीज है दैट इज वेल डिस्कस अबाउट, दैट इज पार्टीशन ऑफ बंगाल। पार्टीशन ऑफ बंगाल, फर्स्ट है पार्टीशन ऑफ बंगाल, बंगाल का विभाजन कब हुआ था? 1905 में हुआ था। आज जो है आप साथ में पेन पेपर लेके चलिए, आज का पढ़ाई थोड़ा सा अलग होगा, PDF नहीं है आज का। आज पेन पेपर साथ में लेके चलिए और आपको आज फील होगा कि आप डायरेक्टली क्लासरूम में बैठे हो और उस तरह से पढ़ा रहे हो। तो आज का मेरा पढ़ाने का तरीका वैसा होगा कि आप लोग सामने में बैठे हो, पेन पेपर लेके, और मैं पढ़ा रहा हूँ। तो उस तरीके जैसे क्लासरूम में आप फील करते हो ना, लाइव क्लासरूम में, तो आज का जो क्लास होगा वैसा फीलिंग होगा, ठीक है। आपको आज फील ही नहीं होगा कि आप ऑनलाइन में पढ़ रहे हो या फिर यूट्यूब में पढ़ रहे हो। क्लास में जैसे होती है ना, एग्जैक्टली क्लास में जैसे होती है उस तरीके से पढ़ाया जाएगा, ठीक है। पेन पेपर साथ में लेके चलो, पूरा आज आज़ादी करके छोड़ेंगे। 1905 से 1947 तक देश को आज़ादी करके छोड़ेंगे, ठीक है। बोलो भारत माता की जय। चलिए, तो पार्टीशन ऑफ बंगाल, बंगाल का विभाजन, ठीक है। तो पार्टीशन ऑफ बंगाल किसके टाइम पे हुआ था? उस टाइम पे जो वाइसरॉय थे, वाइसरॉय जो थे वो है लॉर्ड कर्जन, लॉर्ड कर्जन, ठीक है। तो बंगाल को जो डिवाइड किया गया था, देखो अगर रफली में मैप अगर बनाता हूं, ठीक है, अगर रफली देखो, दिस इज द मैप ऑफ इंडिया। तो ये जो रीजन है, दिस इज नोन एज, आज के डेट में ये रीजन क्या है, बांग्लादेश है। और उस टाइम पे बांग्लादेश को कहा जाता था ईस्ट पाकिस्तान, ईस्ट पाकिस्तान। और ये जो पोर्शन है आज के डेट में पाकिस्तान है, ये पोर्शन, दिस इज नोन एज पाकिस्तान, ये नोन एज पाकिस्तान, ठीक है। तो बांग्लादेश को उस टाइम पे कहा जाता था ईस्ट पाकिस्तान, मतलब हालांकि उस टाइम पे तो मतलब ईस्ट बंगाल के नाम पे था। देखो आज के डेट में ये जो है दिस एरिया इज नोन एज वेस्ट बंगाल, पश्चिम बंगाल। और ये जो ईस्ट पाकिस्तान है, दिस वाज आल्सो नोन एज ईस्ट बंगाल, ईस्ट बंगाल, ईस्ट बंगाल, ठीक है। तो ये जो टोटल रीजन वाज नोन एज बंगाल। तो आज के डेट में ये बन गया है ईस्ट बंगाल, मतलब ईस्ट बंगाल जो है आज के डेट में पहले था ईस्ट पाकिस्तान, देन आज के डेट में बांग्लादेश, और आज के डेट में ये तो वेस्ट बंगाल ही है, ठीक है। तो ब्रिटिशर जब आए थे उस टाइम पे हम लोग का राजधानी कौन सा था, कोलकाता वाज द कैपिटल, जाहिर सी बात है। अगर राजधानी जहां पे है तो डोमिनेशन वहां पे ज्यादा रहेगा। अब जैसे कि सबसे पावरफुल एरिया कौन सा है इंडिया का, दिल्ली है, दिल्ली में प्रधानमंत्री हैं, दिल्ली में सारे मंत्री हैं, दिल्ली इज वन कंसिडर्ड पार्लियामेंट है, सुप्रीम कोर्ट है, वन ऑफ द मोस्ट पावरफुल। तो जाहिर सी बात है कोलकाता वाज द कैपिटल ऑफ इंडिया। तो उस टाइम पे कोलकाता जो है मतलब वेस्ट बंगाल रीजन जो है ज्यादा पावरफुल था। तो ब्रिटिशर्स जो है हमेशा कोशिश करते थे इंडिया को तोड़ने की कोशिश करते थे, जिस पॉलिसी को हम लोग कहते हैं डिवाइड एंड रूल पॉलिसी, जिसको कहा जाता है फुट डालो एवं शासन करो। तो हमेशा से उनका जो पॉलिसीज रहा है, ब्रिटिशर्स का हमेशा से पॉलिसीज रहा है फुट डालो एवं शासन करो, ठीक है, जिस पॉलिसी को हम लोग कहते हैं डिवाइड एंड रूल पॉलिसी, डिवाइड एंड रूल पॉलिसी, फुट डालो एवं शासन करो। देखिए अगर ऐसा नहीं था कि भारत में केवल जो है ब्रिटिशर्स आए थे, भारत में तो बेटा डच भी आए थे, पुर्तगीज भी आए थे, फ्रेंच भी आए थे, डेनमार्क वाले भी आए थे, समझ रहे हो चीजें। तो भारत में कई सारे यूरोपियन कंपनी का आगमन हुआ था। ऐसा नहीं था कि ब्रिटिशर जो है पहली बार भारत को आए थे और भारत को लूटे थे, उससे पहले पुर्तगीज, डच, फ्रेंच, डेनमार्क ये सब आके भारत के ऊपर मतलब कोशिश कर रहे थे एक्सप्लॉइट करने का। और ब्रिटिशर्स भी आए थे, बट डच, अगर मैं बात करूं, इफ आई कंपेयर विद द डच, इफ आई कंपेयर विद द पोर्तुगीज, इफ आई कंपेयर विद द फ्रेंच, वो इतना ज्यादा देर तक भारत पे लूट नहीं कर पाए जितना देर तक ब्रिटिशर्स ने हम लोगों के ऊपर लूट मार किया था। ब्रिटिशर ने हम लोग को एक्सप्लॉइट किया था। करीब करीब वो अगर आए थे, ईस्ट इंडिया कंपनी का गठन हुआ था इंग्लैंड में 1600 में, 1600 में, और वो आए थे 1609 में ड्यूरिंग द टाइम ऑफ जहांगीर। अकबर ने परमिशन नहीं दिए तो 1609 में जहांगीर के टाइम पे आए थे। स्टीफन हॉकिंस फॉर द फर्स्ट पर्सन हु केम इन द कोर्ट ऑफ अकबर, मतलब जहांगीर फॉर द ट्रेडिंग पर्पस। इनिशियली वो ट्रेड के लिए आए थे, व्यवसाय के लिए आए थे, बट उन्होंने जब देखा भारत का कंडीशन कि सोशली, पॉलिटिकली, कल्चरली, इकोनॉमिकली इंडिया जो है बैकवर्ड है, उसके ऊपर इजिली रूल किया जा सकता है, तब उन्होंने क्या किया कि दे स्टार्टेड एक्सप्लॉइटिंग, चाहे वो सोशली हो, फिजिकली हो, मतलब सोशली, इकोनॉमिकली, पॉलिटिकली, फाइनेंशियली, हर एक मामले में हम लोग जो है ब्रिटिशर से कमजोर थे। तो धीरे धीरे दे स्टार्टेड एक्सप्लॉइटिंग इंडिया। क्लियर है। और हमेशा भारत को डिवाइड करने की बात की थी, जैसे कि हिंदू मुस्लिम को तोड़ने की बात की थी, जाति के नाम पे, धर्म के नाम पे, भाषा के नाम पे, देखो जैसे कि राष्ट्र मतलब भाषा के नाम पे तोड़ने की बात की, जाति के नाम पे तोड़ने की बात की, हिंदू, ब्राह्मण, क्षत्रिय, वैश्य, ये सब के नाम पे, धर्म के नाम पे हिंदू मुस्लिम, धर्म के नाम में तोड़ने की बात की, समझ रहे हो चीजें। तो दिस पॉलिसी इज नोन एज डिवाइड एंड रूल पॉलिसी। तो यहां पर भी डिवाइड एंड रूल पॉलिसी का उन्होंने इस्तेमाल किया था। कैसे, देखिए कि ये जो पोर्शन है, दिस पोर्शन इज नोन एज बांग्लादेश। आज के डेट में जो हम लोग कह रहे हैं, दिस पोर्शन इज नोन एज ईस्ट बंगाल, ठीक है। ईस्ट बंगाल था, और आज के डेट में भी ये जो है वेस्ट बंगाल है। ये जो पोर्शन जो है दिस इज नोन एज वेस्ट बंगाल का पोर्शन है। क्लियर है पॉइंट? तो उन्होंने जानबूझकर पार्टीशन ऑफ बंगाल, बंगाल का विभाजन कर दिया था। यहां पे कैसे कर दिया था कि एक रहेगा वेस्ट बंगाल और एक रहेगा ईस्ट बंगाल, सो दैट कि वेस्ट बंगाल और ईस्ट बंगाल में डिवीजन हो जाएगा तो सोशली, पॉलिटिकली, कल्चरली, इकोनॉमिकली दोनों जो है अलग अलग हो जाएंगे। और दोनों अलग अलग होने का रीजन क्या है? देखो, वेस्ट बंगाल में ज्यादातर जो है हिंदू थे, वेस्ट बंगाल में ज्यादातर जो है हिंदू पॉपुलेशन वाज देयर, एंड ईस्ट बंगाल मोस्टली डोमिनेटेड बाय द मुस्लिम पॉपुलेशन। ईस्ट बंगाल मोस्टली डोमिनेटेड बाय द मुस्लिम पॉपुलेशन। तो ध्यान रखना, तो ईस्ट बंगाल में ज्यादातर कौन थे? मुसलमान थे, और वेस्ट बंगाल में ज्यादातर कौन थे? हिंदू थे। तो हिंदू पॉपुलेशन एरिया और मुस्लिम पॉपुलेशन एरिया के बीच में अगर विभाजित कर दिया जाएगा तो जाहिर सी बात है सोशली, पॉलिटिकली, कल्चरली, इकोनॉमिकली हिंदू एंड मुस्लिम विल बी डिवाइडेड। अगर हिंदू एंड मुस्लिम आपस में लड़ते रहेंगे, आपस में डिवीजन होगा, तो ब्रिटिशर्स को रूल करने में आसानी होगी। और यही पॉलिसीज को कहा जाता है डिवाइड एंड रूल पॉलिसीज। फुट डालो एवं शासन करो। अब देखो, हिंदू मुस्लिम में आज के डेट में हिंदुस्तान और पाकिस्तान अलग अलग देश में बट गया था। ठीक है, आई वॉन्ट टू कंटेक्ट यू बेटा। पीडीएफ क्या नाम है उनका? सरकार जी, सत्या की सरकार जी। ठीक है, मैंने आपका मैसेज देख लिया है बेटा। आप टेलीग्राम ऐप में जुड़ जाइए, ठीक है, वहां पे कांटेक्ट कर लेना, ठीक है, कोई दिक्कत नहीं। और मतलब एक ही मैसेज 100 बार मत करो बेटा, मैंने देख लिया आपका मैसेज, ठीक है, उसमें कांटेक्ट कर लेना, ठीक है। चलिए, ओके, या फिर मेरे पुराने इस वीडियो सब देख लो, उसमें नंबर भी है, कांटेक्ट कर सकते हो उससे भी। चलिए, अब आते हैं टॉपिक पे आते हैं, ठीक है। अब मैं बात कर रहा हूं कि हाँ, तो डिवाइड एंड रूल पॉलिसी की मैं बात कर रहा था, क्योंकि देखो आज के डेट में हिंदुस्तान और पाकिस्तान दो अलग अलग मुल्क में बैठा हुआ है। आज में हिंदू और मुस्लिम में जो एनिमिसिटीज है, हम कभी उस चीज के लिए मोहम्मद अली जिन्ना को ब्लेम करते हैं, कभी उस चीज के लिए जवाहरलाल नेहरू को ब्लेम करते हैं, बट जो रियल कल्प्रीट है हिंदुस्तान और पाकिस्तान को अलग अलग करने में, हिंदू और मुस्लिम में एनिमिसिटी लाने में, दे आर द ब्रिटिशर्स। कभी पार्टीशन ऑफ बंगाल के नाम पे, तो कभी पार्लियामेंट्री रिफॉर्म के नाम पे, तो कभी सेकंड राउंड टेबल कॉन्फ्रेंस के नाम पे हमेशा उन्होंने कोशिश की, तो कभी पार्लियामेंट्री रिफॉर्म्स के नाम पे हमेशा उन्होंने कोशिश की कि किस तरह से मुस्लिम, हिंदू और मुस्लिम में आपस में लड़ते रहेंगे, क्योंकि हिंदू मुस्लिम आपस में लड़ते रहेंगे, हिंदू मुस्लिम करते रहेंगे, तो उनको रूल करने में आसानी होगी। दैट वाज देयर स्ट्रेटेजी, और उस स्ट्रेटेजी को हम लोग कहते हैं डिवाइड एंड रूल पॉलिसी। क्लियर है? तो पहला इंटेंशन क्या था कि हिंदू और मुस्लिम को अलग अलग करना था, ठीक है, मेन मकसद। उसके साथ साथ कि यहां पर जाहिर सी बात है बेटा, कैपिटल देखो, दिल्ली जो है राजधानी बना था बेटा, दिल्ली एज ए कैपिटल, दिल्ली जो है कैपिटल बना था 1911 में, 1911 में, बट उससे पहले हम लोग बात करें 1905 की बात कर रहे हैं, ठीक है। दिल्ली कैपिटल बना था 1911 में बना था, बट उससे पहले क्या था? कैपिटल क्या था? कलकत्ता वाज द कैपिटल। तो कलकत्ता कैपिटल है तो जाहिर सी बात है, तो वहां पर ज्यादा इंटेलेक्चुअल, जहां पर अमीर लोग ज्यादा, पॉलिटिकल इन्फ्लुएंस लोग ज्यादा वहां पे थे। तो ब्रिटिशर्स को लगा ये जो बंगाल रीजन है, जो ज्यादा पावरफुल है, ज्यादा इंटेलेक्चुअल लोग हैं, उनके बीच में अगर डिवीजन कर दिया जाता है तो इंडिया को रूल करने में आसानी होगी, ठीक है। जो जहां पर ज्यादा इंटेलेक्चुअल लोग हैं, ज्यादा पावरफुल लोग हैं, ज्यादा पॉलिटिकली एक्टिव लोग हैं, ज्यादा लीडर्स हैं, उनमें विभाजित कर दिया जाएगा तो इंडिया को रूल करने में आसानी होगी। तो यही मूल मकसद था। अगर पूछा जाए कि बंगाल को विभाजित करने का दो मुख्य कारण क्या है, व्हाट वाज द टू मेन रीजन ऑफ डिवीजन ऑफ बंगाल, अगर पूछा जाए तो पहला रीजन होगा डिवाइड एंड रूल। दे वांटेड टू डिवाइड द हिंदू एंड मुस्लिम, हिंदू और मुस्लिम को विभाजित करना चाहते थे, अलग अलग करना चाहते थे, पहला पॉइंट होगा। दूसरा पॉइंट होगा कि जो इंटेलेक्चुअल बंगाली है यहां पर थे, जो ज्यादा पावरफुल थे, ज्यादा डोमिनेंट थे, जो लीडर थे, अमीर थे, उन लोगों के बीच में विभाजन, डिवीजन अमंग द मिडिल क्लास, पावरफुल एंड डोमिनेंट बंगाली ओवर दैट रीजन। दिस इज द सेकंड रीजन। तो ये तो बेटा कहने के लिए मतलब ये असल रीजन ये था, असल रीजन ये था डिवीजन का, बट उनको तो लोगों को बताना है कि क्यों विभाजन कर रहे हैं। तो लोगों को बताने के लिए रीजन उन्होंने ये बताया था कि ये रीजन जो है, बंगाल रीजन में जो है पॉपुलेशन बहुत ज्यादा हो रहा है, पहला रीजन। और दूसरा रीजन कि ज्यादा एरिया हो रहा है, ज्यादा एरिया और पॉपुलेशन ज्यादा होने की वजह से जो एडमिनिस्ट्रेशन है कंट्रोल होना मुश्किल हो रहा है, इसलिए उसको हम लोग विभाजित करना चाहते हैं। तो ये जो है उन्होंने रीजन जो है लॉर्ड कर्जन ने पेश किया था कि इसकी वजह से हम लोग जो है विभाजित कर रहे हैं। ठीक है, वन सेकेंड सेइंग। तो यहां पर याद रखने वाला चीज इतना ही है बेटा कि बंगाल का विभाजन कब हुआ था, 1905 में। ये मैं देखो, ये जो क्वेश्चन वगैरह मैं पुट अप करता रहूंगा, आप देखो आज का जो सेशन होगा इंटरेक्शन सेशन होगा, वन साइडेड सेशन नहीं होगा। मैं टॉपिक पढ़ाऊंगा और फिर पूछता जाऊंगा, पढ़ाऊंगा पूछता जाऊंगा, आप भी बताते चलना, तब जाके मजा आएगा। मैंने पहले ही बताया था ये जो टॉपिक है यूट्यूब वीडियोस वाला टॉपिक या ऐसे वाला टॉपिक नहीं होगा, आपको फिल होना चाहिए। आप पेन पेपर लेके रखिए, लाइव वाला फिल होगा। ठीक है, तो यहां पर याद करने वाला पॉइंट क्या क्या है। बंगाल का विभाजन कौन सा ईयर में हुआ था, 1905 में हुआ था। बंगाल को विभाजन को किसने डिवीजन किया था, बंगाल को किसने डिवाइड किए थे, वो है वाइसरॉय लॉर्ड कर्जन। और दो मुख्य कारण, व्हाट वर द मेन पर्पस ऑफ द पार्टीशन ऑफ बंगाल, पहला है डिवाइड एंड रूल और दूसरा है जो है मध्य वर्गीय बंगाली लोगों के बीच में विभाजन। उसके साथ साथ एक्चुअली रीजन क्या है, मतलब उन्होंने लोगों को दिखाने के लिए क्या बताया था कि पॉपुलेशन ज्यादा है और ज्यादा एरिया है। क्लियर है, दिस इज ऑल अबाउट द पार्टीशन ऑफ बंगाल। आई होप इट्स क्लियर टू यू। ठीक है, तो वी आर रेडी, बिल्कुल सही बात। चलिए, तो ये था पार्टीशन ऑफ बंगाल। देन उसके बाद अगला पॉइंट जो आते हैं, दैट इज अगला टॉपिक जो है स्वदेशी मूवमेंट। नेक्स्ट टॉपिक जो है स्वदेशी मूवमेंट। स्वदेशी मूवमेंट ये सेम ईयर 1905 में हुआ था, सेम ईयर स्वदेशी मूवमेंट। और उसका जो मेन लीडर थे, मेन लीडर गोपाल कृष्ण गोखले, main leader of Swadeshi movement was Gopal Krishna Gokhale. और उसका जो मेन पर्पस था, मेन मोटो ऑफ दिस मूवमेंट, यूजिंग द इंडियन गुड्स एंड बॉयकटिंग द फॉरेन गुड्स, यूजिंग the Indian goods and boycotting the foreign goods. देखिए यहां पर समझने की कोशिश करते हैं। ठीक है, तो बंगाल का विभाजन जब हुआ था तो बंगाल के विभाजन में लीडर, पर्टिकुलरली आईएनसी के लीडर सपोर्ट नहीं कर रहे थे। और उस टाइम पे आईएनसी क्या है, दिस इज नोन एज इंडियन नेशनल कांग्रेस। आईएनसी इज नोन एज इंडियन नेशनल कांग्रेस। तो इंडियन नेशनल कांग्रेस के लीडर जो है सपोर्ट नहीं कर रहे थे। ठीक है, और इसीलिए बंगाल का जो विभाजन हुआ था उसको रोकना चाहते थे। आईएनसी डजंट वांट द पार्टीशन ऑफ बंगाल। तो बंगाल का विभाजन को रोकने के लिए स्वदेशी मूवमेंट किसने, आईएनसी की तरफ से किया गया था, लीडेड बाय गोपाल कृष्ण गोखले। गोपाल कृष्ण गोखले उनके लीडर थे। तो अब हालांकि उनको यहां पर लाल बाल पाल ने भी सपोर्ट किया था। लाल बाल पाल का मतलब क्या है, देखो आप लोगों को पता होगा, दिस वाज आल्सो सपोर्टेड बाय लाल बाल और पाल। कौन बता सकता है, फटाफट बताइए मैसेज में, लाल बाल पाल का फुल फॉर्म क्या है बताइए फटाफट मैसेज में। तो यहां पर लाल फॉर लाला लाजपत राय, बाल फॉर बाल गंगाधर तिलक और पाल फॉर बिपिन चंद्र पाल। ठीक है, लाल फॉर लाला लाजपत राय, लाल फॉर लाला लाजपत राय, बाल फॉर बाल गंगाधर तिलक एंड पाल फॉर बिपिन चंद्र पाल। तो ये तीनों ऐसे लीडर थे, थोड़ा सा एक्सट्रीमिस्ट के लीडर थे, ये गरम दल के नेता कहा जाता है उनको। ये लड़ने के लिए हमेशा तैयार थे ब्रिटिशर के खिलाफ। उनको ब्रिटिशर के, देखो यहां पर दो प्रकार के लोग थे। कुछ लोग जो है ब्रिटिशर के साथ अच्छा रिलेशनशिप करके हमें आजादी चाहते थे, कुछ लोग चाहते थे नहीं उनसे लड़ना है, उनको खदेड़ना है, उनको भगाना है। तो ये वो कैटेगरी के लीडर थे, लाल बाल पाल। ठीक है, हालांकि गोपाल कृष्ण गोखले इतना एग्रेसिव नहीं थे, वो चाहते थे मतलब महात्मा गांधी की तरह। गोपाल कृष्ण वाज आल्सो कंसिडर्ड टू बी द पॉलिटिकल गुरु ऑफ महात्मा गांधी। ठीक है, मैं बताऊंगा क्यों कहा जाता है, पहले ये हम सुन लेते हैं। तो जब बंगाल का विभाजन किया गया था, बंगाल को विभाजित किया गया था, टू स्टॉप द पार्टीशन ऑफ बंगाल स्वदेशी मूवमेंट आईएनसी की तरफ से शुरुआत की थी। अगर पूछा जाए कि स्वदेशी मूवमेंट शुरुआत करने का मुख्य कारण क्या है, तो मुख्य कारण होगा टू स्टॉप द पार्टीशन ऑफ बंगाल, बंगाल के विभाजन को रोकना जो है स्वदेशी मूवमेंट का मुख्य कारण है। अब देखो नाम से ही पता चल रहा है बेटा स्वदेशी, स्वदेशी का मतलब क्या है, स्वदेश, अपना देश, मतलब यूजिंग द इंडियन गुड्स एंड बॉयकटिंग द फॉरेन गुड्स, स्वदेशी चीजों का इस्तेमाल एवं विदेशी चीजों का बहिष्कार। यूजिंग द इंडियन गुड्स एंड बॉयकटिंग द फॉरेन गुड्स का मतलब है स्वदेशी चीजों का इस्तेमाल एवं विदेशी चीजों का बहिष्कार। उसका मतलब क्या है, उसका मतलब हर एक एंगल में स्वदेशी चीजों का इस्तेमाल करना है और विदेशी चीजों का बहिष्कार करना है। फॉर एग्जाम्पल, अगर जैसे कि कोई टीचर है, कोई प्रोफेसर है, ठीक है, कोई स्कूल में या कॉलेजेस में पढ़ा रहे हैं, मतलब जो ब्रिटिश स्कूल एंड कॉलेजेस है, तो वहां पर उनको नहीं पढ़ाना है, मतलब दे वहां से उनको बॉयकट करना है, ठीक है, दे बॉयकट, जितने भी टीचर्स एंड प्रोफेसर, दे बॉयकट द स्कूल एंड कॉलेजेस ऑफ द ब्रिटिशर। उसके साथ साथ ब्रिटिश सामान का जितना भी इस्तेमाल हो रहा था, ब्रिटिश चीजों का जितना भी इस्तेमाल हो रहा था, वो सबको भी उन्होंने बहिष्कार किया था। मतलब सब कुछ, खाना से लेकर, कपड़ा से लेकर, एजुकेशन से लेकर, सब कुछ, मतलब इन शॉर्ट स्वदेशी चीजों का इस्तेमाल एवं विदेशी चीजों का बहिष्कार, ठीक है। तो ये देखो जाहिर सी बात है, जब ये मूवमेंट की शुरुआत हुई थी, दिस गेव पॉजिटिव इंपैक्ट टू द स्वदेशी मूवमेंट, गेव पॉजिटिव इंपैक्ट टू द इंडियन सोसाइटी, व्हिच लीड्स टू द डेवलपमेंट ऑफ स्मॉल स्केल इंडस्ट्री, डेवलपमेंट ऑफ कॉटेज इंडस्ट्री, डेवलपमेंट ऑफ एग्रो बेस्ड इंडस्ट्री एंड डेवलपमेंट ऑफ एजुकेशन। तो जाहिर सी बात है, सभी बंगाल के लोग अगर स्वदेशी चीजों का इस्तेमाल करेंगे और विदेशी चीजों का बहिष्कार करेंगे, तो जाहिर सी बात है हम लोगों का इकोनॉमी के ऊपर एक अच्छा इंपैक्ट होगा। दिस गेव पॉजिटिव इंपैक्ट टू द इंडियन सोसाइटी, इंडियन सोसाइटी के प्रति बहुत अच्छा इंपैक्ट हुआ था, और विच लीड्स टू द ग्रोथ ऑफ स्मॉल स्केल इंडस्ट्री, कॉटेज इंडस्ट्री एंड एग्रो बेस्ड इंडस्ट्री एंड ऑल्सो इंपैक्ट ऑन द एजुकेशन। तो ये एक अच्छी बात है, देखो कि उसका रिजल्ट, परिणाम क्या हुआ था, रिजल्ट ऑफ द स्वदेशी मूवमेंट। तो यहां पर अगर पूछा गया, लास्ट टाइम यूपीएससी का सवाल था कि रिजल्ट ऑफ द स्वदेशी मूवमेंट, मतलब प्रीलिम्स का क्वेश्चन थे, तो उसमें से ऑप्शन था, तो रिजल्ट ऑफ द स्वदेशी मूवमेंट में पहला चीज है कि इंक्रीज ऑफ द एग्रो बेस्ड इंडस्ट्री, और सबसे पहला स्मॉल स्केल इंडस्ट्री, स्मॉल स्केल, increase of the small scale industry. Second है increase of the cottage industry, cottage industries. Third है increase of the agro based industry, agro based मतलब जो agriculture based industry जो है, that is known as agro based industry. Then education, देन लोगों में जो है अवेयरनेस, देन उसके बाद जो है लोगों में यूनिटी। तो ये सब चीजों का डेवलपमेंट हुआ था, रिजल्ट ऑफ द स्वदेशी मूवमेंट। सभी लोग अगर स्वदेशी चीजों का इस्तेमाल करेंगे और विदेशी चीजों का बहिष्कार करेंगे, तो जाहिर सी बात है हम लोग का ही डेवलपमेंट होगा। तो सबसे पहले क्या हुआ था, जो लघु इंडस्ट्री, स्मॉल स्केल इंडस्ट्री, छोटे छोटे उद्योग जो है उसकी विकास हुआ था, कुटीर उद्योग का विकास हुआ था, कॉटेज इंडस्ट्री का, एग्रीकल्चर से संबंधित जितने भी इंडस्ट्री है उसका विकास हुआ था, डेवलपमेंट ऑफ द एग्रीकल्चरल एग्रो बेस्ड इंडस्ट्री, ठीक है। उसके साथ साथ एजुकेशन, लोगों के मन में यह धारणा हुआ कि नहीं ब्रिटिश दुश्मन है, हमें एजुकेटेड होना है। लोगों में एक अवेयरनेस आया था कि उनको फील हुआ था कि नहीं ब्रिटिशर तो दुश्मन है, हम लोग के खिलाफ काम कर रहे हैं, हमें एकजुट होना पड़ेगा। लोगों में सचेतन का भावना आया था, और जो लोगों में जो हिंदू मुस्लिम को डिवाइड करने की कोशिश की थी, एक तरफ से लोगों में यूनिटी आया था, लोग जो है साथ में एक तरफ से होने लगे थे। तो ये उसका एक अच्छा इंपैक्ट है स्वदेशी मूवमेंट का। तो स्वदेशी मूवमेंट में जो चीजें याद रखना है, आपको रखना है कि स्वदेशी मूवमेंट कब हुआ था, 1905 में। बंगाल का विभाजन भी सेम ईयर में हुआ था। सेकंड चीजें याद रखना है, स्वदेशी मूवमेंट क्यों हुआ था, व्हाट आर द रीजन में, टू स्टॉप द पार्टीशन ऑफ बंगाल, बंगाल का विभाजन को रोकने के लिए। और पूछा जाएंगे स्वदेशी मूवमेंट में मेन लीडर कौन थे, गोपाल कृष्ण गोखले, उनको सपोर्ट कौन किए थे, लाल बाल पाल, और उसका मोटो क्या था, यूजिंग द इंडियन गुड्स एंड बॉयकटिंग द फॉरेन गुड्स। उसके साथ साथ उसको इंपैक्ट क्या हुआ था, स्मॉल स्केल कॉटेज एग्रो बेस्ड एजुकेशन अवेयरनेस एंड यूनिटी। ये चीजें जो है स्वदेशी मूवमेंट में आपको याद रखना है। क्लियर है पॉइंट? तो अब हम लोग बात करते हैं, ठीक है, मुस्लिम लीग की बात करता हूं। नेक्स्ट जो है दैट इज अबाउट द मुस्लिम लीग। मुस्लिम लीग, ठीक है, मुस्लिम लीग का जो गठन हुआ था 1906 में हुआ था। ठीक है, तो मुस्लिम लीग का जो गठन हुआ है दैट इज इन द ईयर 1906 में हुआ है। ठीक है, अब देखो मुस्लिम लीग का जो फाउंडर हैं वो है आगा खान है, नवाब सलीमुल्लाह है और नवाब मोहसिन उल मुल्क है। ठीक है, ये तीनों जो है मुस्लिम लीग के फाउंडर हैं। उसके साथ साथ मुस्लिम लीग का दो मांगे थी, पहले मैं उनका फाउंडर लिख देता हूं, तीनों फाउंडर जरूरी है। ठीक है, तो मुस्लिम लीग के जो फाउंडर हैं, फाउंडर मतलब संस्थापक, फाउंडर का मतलब है मुस्लिम लीग के संस्थापक कौन है, तो पहला चीज है वो है आगा खान, आगा खान, देन नवाब सलीमुल्लाह, नवाब सलीमुल्लाह, देन नवाब मोहसिन उल मुल्क, नवाब ठीक है, ये तीनों जो है फाउंडर थे। अगर पूछा जाए यहां पर कि फर्स्ट प्रेसिडेंट कौन थे, फर्स्ट प्रेसिडेंट ऑफ द मुस्लिम लीग, तो वो होंगे आगा खान होंगे। आगा खान इज द फर्स्ट प्रेसिडेंट ऑफ द मुस्लिम लीग। अगर पूछा जाए कि प्रथम अधिवेशन कब हुआ था, कौन बता सकता है प्रथम अधिवेशन कब हुआ था? मैं ब्लैंक छोड़ रहा हूं, आप लोग बताइए। फर्स्ट सेशन ऑफ द मुस्लिम लीग बताइए आप लोग, फर्स्ट सेशन ऑफ द मुस्लिम लीग कहां पर हुआ था? ये क्वेश्चन है, आप लोग बताइए फर्स्ट सेशन ऑफ द मुस्लिम लीग कहां पर हुआ था। मैं बाद में बताता हूं, आप लोग बताइए पहले। ठीक है, चलिए। हाँ, तो मैं अभी बात कर रहा था कि मुस्लिम लीग का जो गठन हुआ था 1906 में, और मुस्लिम लीग के तीनों फाउंडर थे, एक फाउंडर नहीं थे, तीनों थे। वो है आगा खान है, नवाब सलीमुल्लाह है, नवाब मोहसिन उल मुल्क है। ठीक है, और आगा खान वॉज द फर्स्ट प्रेसिडेंट ऑफ द मुस्लिम लीग। और मुस्लिम लीग का पहला अधिवेशन जो हुआ था 1906 में हुआ था। फर्स्ट अधिवेशन जब गठन हुआ था उस टाइम पे ही 1906 में पहला अधिवेशन हुआ था। और पहला अधिवेशन कहां पर हुआ था? दैट इज इन ढाका। ढाका कहां पे है? दैट इज इन बांग्लादेश। ढाका दैट इज इन बांग्लादेश में हुआ था। समझ रहे हो चीजें? अब बात आती है कि मुस्लिम लीग, यस बिल्कुल, काफी लोगों ने सही आंसर दिया है, ढाका में। वेरी गुड, फैंटास्टिक। तो अब देखो मुस्लिम लीग का दो डिमांड क्या था? व्हाट आर द टू डिमांड्स ऑफ द मुस्लिम लीग? ठीक है, कौन बता सकता है दो डिमांड मुस्लिम लीग का? मुस्लिम लीग का दो डिमांड में पहला डिमांड ये था, पहले सुन लो उसके बाद मैं बताता हूं। फर्स्ट डिमांड ये था कि दे सेपरेट इलेक्टोरेट्स फॉर द मुस्लिम कम्युनिटी। मुस्लिम संप्रदाय के लिए अलग से निर्वाचन होगा। मतलब मुस्लिम का जो कैंडिडेट, मुस्लिम का जो इलेक्शन होगा वो केवल मुस्लिम ही वोट करेंगे, वोट जो है मुस्लिम ही करेंगे, और जो कैंडिडेट होंगे वो ही केवल मुस्लिम ही होंगे। ठीक है, तो मुस्लिम का लीडर केवल मुस्लिम होगा, मुस्लिम का जो लीडर केवल मुस्लिम होगा, और मुस्लिम को उसको कौन चयन करेंगे? केवल मुस्लिम ही चयन करेंगे, उसमें हिंदू जो है पार्टिसिपेट नहीं कर सकते। ये पहला डिमांड, जिसको हम लोग कहते हैं सेपरेट इलेक्टोरेट्स फॉर द मुस्लिम कम्युनिटी, पहला डिमांड है। सेकंड डिमांड क्या था? स्पेशल सेफगार्ड फॉर द मुस्लिम कम्युनिटी और स्पेशल प्रोविजन फॉर द मुस्लिम कम्युनिटी। मतलब एक तरफ से मान सकते हो कि सम काइंड ऑफ स्पेशल रिजर्वेशन अबाउट द मुस्लिम, सोशल पॉलिटिकल इकोनॉमिक रिजर्वेशन अबाउट द मुस्लिम्स। ठीक है, ध्यान रखना। तो ये जो चीजें हुई थी, आप देख सकते हो कि यहां पर कि टू डिमांड्स ऑफ द मुस्लिम, ये दो डिमांड से बहुत सारे स्टोरी आते हैं। ठीक है, ये डिमांड आपको याद रखना है, टू डिमांड्स ऑफ मुस्लिम लीग। लिख लो, ये डिमांड लिख लो, टू डिमांड्स ऑफ द मुस्लिम लीग। ये सबसे जरूरी चीज है, क्योंकि यही चीज से रिलेटेड है आने वाला 3 टॉपिक, दैट इज पार्लियामेंट्री रिफॉर्म्स, होम रूल लीग एंड लखनऊ पैक्ट। यही दो डिमांड से रिलेटेड है आने वाला जो 3 टॉपिक है, पार्लियामेंट्री रिफॉर्म्स, होम रूल लीग एंड लखनऊ पैक्ट। तो ये मुस्लिम लीग का 2 डिमांड हमें जानना जरूरी है। अभी मैंने समझाया था आप लोगों को, फिर से मैं लिख देता हूं। फर्स्ट डिमांड क्या था? सेपरेट इलेक्टोरेट्स फॉर द मुस्लिम कम्युनिटी। सेपरेट इलेक्टोरेट्स। ध्यान रखना, इलेक्टोरेट्स का स्पेलिंग बहुत लोग गलत करते हैं, ठीक है? इलेक्टोरेट्स का स्पेलिंग बहुत लोग गलत करते हैं, ये स्पेलिंग ध्यान लेना, ELECTROTRATES, दिस इज द राइट करेक्ट स्पेलिंग है, ठीक है? ये बहुत लोग गलत करते हैं इसलिए बता रहा हूं। तो सेपरेट इलेक्टोरेट्स फॉर द मुस्लिम्स, पहला डिमांड, मुस्लिम्स के लिए सेपरेट इलेक्टोरेट्स। दूसरा जो है स्पेशल सेफगार्ड और स्पेशल प्रोविजन फॉर द मुस्लिम्स, स्पेशल सेफगार्ड और स्पेशल प्रोविजन, स्पेशल प्रोविजन प्रोविजन फॉर द मुस्लिम्स, ठीक है? स्पेशल सेफगार्ड और स्पेशल प्रोविजन। तो ये दोनों पॉइंट आपको लिख के रख लो, ये दोनों पॉइंट जो है आने वाले 3 टॉपिक में काम करेगा, पार्लियामेंट्री रिफॉर्म्स, होम रूल लीग और लखनऊ पैक्ट में, ठीक है? फिर से मैं समझा देता हूं ये दो डिमांड का मतलब क्या था। पहला डिमांड जो है सेपरेट इलेक्टोरेट्स फॉर द मुस्लिम कम्युनिटी और मुस्लिम्स, मतलब मुस्लिम का इलेक्शन अलग होगा, इलेक्शन में केवल लीडर जो होगा वो मुसलमान ही होंगे और जो मतदाता होंगे वो भी मुसलमान होंगे। समझ में आ चीजें? तो मुस्लिम के लिए अलग से निर्वाचन, यू कैन से सेपरेट इलेक्टोरेट्स मतलब सेपरेट इलेक्शन, यहां पर ब्रैकेट में लिख सकते हो आप, सेपरेट इलेक्शन होगा, ठीक है? जिसका लीडर मुसलमान ही होंगे और जिसका मतदाता वोट देने वाले भी मुस्लिम होंगे। पहला डिमांड ये था। और दूसरा डिमांड क्या था? स्पेशल सेफगार्ड और स्पेशल प्रोविजन फॉर द मुस्लिम कम्युनिटी, मतलब स्पेशल मतलब दिस इज रिलेटेड टू द सोशल, पॉलिटिकल और इकोनॉमिक रिजर्वेशन फॉर द मुस्लिम। सिंपली याद कर लो, रिजर्वेशन फॉर द मुस्लिम। तो सिंपली एक एक वर्ड में याद कर लो, एक है इलेक्शन उनको अलग चाहिए, दूसरा रिजर्वेशन चाहिए। एक है इलेक्शन चाहिए और दूसरा रिजर्वेशन चाहिए। क्लियर है पॉइंट? तो मुस्लिम लीग में इतना चीज याद करना है बेटा, जो चीजें याद करनी है कि मुस्लिम लीग का गठन कब हुआ था? 1906 में हुआ था। मुस्लिम लीग के फाउंडर कौन है बेटा? आगा खान है, नवाब सलीमुल्लाह है, मोहसिन उल मुल्क है। क्लियर है पॉइंट? मुस्लिम लीग का पहला अधिवेशन कहां पर हुआ था बेटा? ढाका में हुआ था। पहला अधिवेशन में प्रेसिडेंट कौन थे? आगा खान थे। पहला अधिवेशन जो है कब हुआ था? 1906 में हुआ था। मुस्लिम लीग का 2 डिमांड क्या था? एक है इलेक्शन वाला डिमांड, दूसरा क्या है जो है रिजर्वेशन वाला डिमांड। क्लियर है? समझ में आ रहा है? चलिए, अब जो है मैंने 3 टॉपिक किया है, ज्यादा टॉपिक नहीं, बट 3 टॉपिक से मैं क्वेश्चन पुटअप कर रहा हूं, तब जाके मैं आगे बढ़ूंगा, ठीक है? चलिए, समरी है, क्वेश्चन का मतलब समरी है, ठीक है? चलिए, तो पहला बताइए, पहला चीज बताइए, फर्स्ट थिंग मुझे बताइए, ठीक है? पहला चीज की पार्टीशन ऑफ बंगाल कब हुआ था? फटाफट बताइए, आंसर जो है आई वांट फटाफट। पहला चीज बताइए कि पार्टीशन ऑफ बंगाल कब हुआ था, बंगाल का विभाजन कब हुआ था? बताइए फटाफट, आई वांट अर्ली रिप्लाई, जल्दी। पार्टीशन ऑफ बंगाल कब हुआ था? ठीक है, हाँ, यस, लॉर्ड कर्जन जिसने लिखा है उसका राइट आंसर है लॉर्ड कर्जन वाज द, ठीक है, लॉर्ड कर्जन, ठीक है, ओके। व्हाट आर द 2 मेन रीजन ऑफ द पार्टीशन ऑफ बंगाल? बंगाल का विभाजन करने का 2 मुख्य कारण क्या था? बंगाल को विभाजित करने का 2 मुख्य कारण क्या था? व्हाट वाज द 2 मेन रीजन ऑफ द पार्टीशन ऑफ बंगाल? 2 रीजन क्या थे? यस, पहला रीजन था कि हिंदू और मुस्लिम को अलग करना और दूसरा रीजन था मिडिल क्लास बंगाली को अलग करना। बट नॉर्मल पब्लिक को क्या रीजन बताया था उन्होंने? नॉर्मल पब्लिक को क्या मतलब झूठ बोला था, क्यों विभाजित कर रहे हैं, क्या बोला था उन्होंने? यस, कि पॉपुलेशन ज्यादा है और एरिया ज्यादा है। अच्छा, पार्टीशन ऑफ बंगाल के खिलाफ कौन सा मूवमेंट हुआ था? फटाफट बताओ। कौन सा मूवमेंट हुआ था पार्टीशन ऑफ बंगाल के खिलाफ? और वो मूवमेंट कौन सा ईयर में हुआ था? बताओ, कौन सा ईयर में हुआ था और उस मूवमेंट के लीडर कौन थे? बताओ। बिल्कुल सही बात है। पार्टीशन ऑफ बंगाल के खिलाफ जो है जो मूवमेंट हुआ था वो है स्वदेशी मूवमेंट। यस, उसके लीडर जो है गोपाल कृष्ण गोखले। यस, कौन सा ईयर में? सेम ईयर में 1905 विद द सेम ईयर। वेरी गुड। फिर गोपाल कृष्ण गोखले को कौन कौन से लीडर ने पार्टी मतलब सपोर्ट किए थे बड़े लेवल पे? कौन कौन से लीडर ने सपोर्ट किए थे उनको? उसके बाद बताइए उसका मोटो क्या था, स्वदेशी मूवमेंट का मोटो क्या था बताइए। दो चीज बताना है, कौन कौन से लीडर ने सपोर्ट किए थे। शॉर्टकट में भी बताओगे तो चलेगा, मैंने शॉर्टकट ही बताया था उसका लीडर का नाम। यस, लाल बाल पाल इज द राइट आंसर, बिल्कुल सही बात है। और यस, लाल बाल पाल इज द राइट आंसर। और मोटो क्या था? यूजिंग द इंडियन गुड्स एंड बाइकटिंग द फॉरेन गुड्स। यस, स्वदेशी चीजों का इस्तेमाल एवं विदेशी चीजों का बहिष्कार, बिल्कुल बिल्कुल सही बात है। अच्छा, और एक पॉइंट बताओ कि व्हाट वाज द रिजल्ट ऑफ द स्वदेशी मूवमेंट और व्हाट वाज द इंपैक्ट ऑफ द स्वदेशी मूवमेंट। स्वदेशी मूवमेंट का रिजल्ट क्या था और इंपैक्ट क्या था बताइए। स्वदेशी मूवमेंट का रिजल्ट क्या था और इंपैक्ट क्या था बताइए। व्हाट वाज द इंपैक्ट और रिजल्ट ऑफ द स्वदेशी मूवमेंट। स्वदेशी मूवमेंट का नतीजा क्या था, क्या क्या पॉइंट थे मैंने जो बताया था आप लोगों को। यस, बिल्कुल बिल्कुल सही बात है। पॉइंट में पहला पॉइंट है कि स्मॉल स्केल इंडस्ट्रीज का डेवलपमेंट। एक और पॉइंट है एग्रो बेस्ड इंडस्ट्री का डेवलपमेंट, बिल्कुल सही, एग्रो बेस्ड इंडस्ट्री का डेवलपमेंट। कॉटेज इंडस्ट्री का डेवलपमेंट, बिल्कुल सही बात है, कॉटेज इंडस्ट्री का डेवलपमेंट। और एजुकेशन का डेवलपमेंट, बिल्कुल सही बात है, एजुकेशन अवेयरनेस हुआ था लोगों के मन में, ये भी सही बात है। एंड लोगों में यूनिटी हुआ था, बिल्कुल फैंटास्टिक फैंटास्टिक फैंटास्टिक, वेरी गुड, बहुत अच्छा आंसर दे रहे हो। ऐसे आंसर देते हो तो मजा आता है पढ़ाने में। फिर अब बताइए कि मुस्लिम लीग का गठन कब हुआ था। मुस्लिम लीग का गठन कब हुआ था? मुस्लिम लीग का गठन कब हुआ था? ठीक है। और मुस्लिम लीग के फाउंडर कौन कौन थे बताइए। मुस्लिम लीग के फाउंडर कौन कौन थे बताइए। फाउंडर कौन कौन थे? यस, बिल्कुल, मुस्लिम लीग का गठन 1906 में हुआ था, सही बात है। फाउंडर हैं आगा खान। आगा खान तो बेटा याद रहेगा, आगा खान। और दोनों का नाम नवाब है, प्रीलिम्स पॉइंट ऑफ व्यू याद रहेगा। देखो, नवाब सलीमुल्लाह, नवाब मोहसिनुल मुल्क, नवाब सलीमुल्लाह, नवाब मोहसिनुल मुल्क, है ना। यस, बिल्कुल फंटास्टिक। पहला अधिवेशन कहां पर हुआ था? ये तो हम लोग 3 बार हो चुका है, जिंदगी में कभी नहीं भूलोगे अभी। पहला अधिवेशन कहां पर हुआ था? यस, ढाका में हुआ था, ये तो जिंदगी में कभी नहीं भूलोगे। पहला प्रेसिडेंट कौन थे? लिख दो पहले, पहला प्रेसिडेंट कौन थे। जितना ज्यादा आंसर लिखोगे उतना ज्यादा रिवीजन होता रहेगा। रिवीजन इज द मेन सोर्स ऑफ, रिवीजन वाज द मेन थिंग दैट यू मेमोराइज द थिंग्स। ठीक है, हमेशा खाली पढ़ना नहीं है, रिवीजन करते रहना है। तो हर एक 3-4 टॉपिक में आज का सेशन में मैं रिवीजन करता रहूंगा, पुटअप करता रहूंगा, ताकि मैं भले ही थोड़ा सा कम पढ़ाऊं लेकिन जो भी पढ़ाऊं आपके दिमाग में फीड करके जाऊंगा आज। ठीक है, थोड़ा सा कम ही पढ़ा हूं, मतलब मेन मतलब आज जो है रस केवल जूस है ये। ठीक है, मॉडर्न हिस्ट्री का आज मैं जूस दे रहा हूं आप लोगों को, पूरा हर एक टॉपिक में डिटेल नहीं जा रहा हूं, कम जाऊंगा बट आपको पूरा दिमाग में फीड करके जाऊंगा। ये मेरी कोशिश है। ठीक है, आज का जो सेशन अलग तरीके से हो रहा है। ठीक है, चलिए, हाँ बिल्कुल। तो पहला सेशन जो है मतलब ढाका में हुआ था सेम ईयर 1906 में ही। अब बताइए 2 कारण, 2 डिमांड्स ऑफ द मुस्लिम लीग, ये सबसे जरूरी है। 2 डिमांड्स ऑफ द मुस्लिम लीग, ये सबसे जरूरी है। 2 डिमांड्स ऑफ द मुस्लिम लीग बताइए। बिल्कुल 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 बिल्कुल। देखो, इलेक्शन शॉर्टकट में एक है इलेक्शन, निर्वाचन अलग होगा मुस्लिम्स का, और एक है आरक्षण, रिजर्वेशन। ठीक है, तो 2 डिमांड को हमेशा याद रखना, सेपरेट इलेक्टोरेट फॉर द मुस्लिम्स जो कि इलेक्शन है, और स्पेशल सेफगार्ड फॉर द सेफगार्ड और स्पेशल प्रोविजन फॉर द मुस्लिम। तो एक है इलेक्शन, एक है रिजर्वेशन, एक है इलेक्शन, एक है रिजर्वेशन। सिंपल सी बात है बेटा। तो अब तक जो मैंने पढ़ा है इतना ही पढ़ा है, ज्यादा नहीं पढ़ा है, ठीक है ना। तो हमने जो बात की है अब तक इतना ही पढ़े हैं। देखो, आप देख सकते हो यहाँ पे पार्टीशन ऑफ बंगाल, वाइस रॉय 1905, डिवाइड एंड रूल। उसके बाद हमने पढ़ा है स्वदेशी मूवमेंट, गोपाल कृष्ण गोखले, लाल बाल पाल, यूजिंग द इंडियन गुड्स, बॉयकॉटिंग द फॉरेन गुड्स, और ये सब उसका रिजल्ट है। स्मॉल स्केल इंडस्ट्री, एग्रो बेस्ड इंडस्ट्री, कॉटेज इंडस्ट्री, एजुकेशन, अवेयरनेस, यूनिटी। उसके बाद जो है मुस्लिम लीग, ये सब लीडर हैं, फाउंडर। देन उसके बाद जो है इतना ही पढ़े अब तक। क्लियर है पॉइंट? तो ये दोनों पॉइंट को मैं इसलिए फोकस कर रहा हूं क्योंकि आने वाला जो चीजें है ये दोनों पॉइंट से ही रिलेटेड होगा। ठीक है, अगर आप लोगों को क्लास पसंद आ रहा है तो लाइक कर दीजिए और शेयर कर दीजिए ताकि ज्यादा से ज्यादा बच्चों को ये क्लास दे सकूं। और ये पूरा आजादी तक चलेगा। अब तो शुरुआत हुआ है बेटा, थोड़ा सा लंबा 3-4 घंटे का सेशन चलेगा, 4-5 घंटा भी हो सकता है, लेकिन आजादी करके ही भारत को आज आजाद करके ही जाएंगे। ठीक है, अब तो 1906 में, भारत कब आजाद हुआ था? 1947 में। समझ लो चीजें, बहुत सारे टॉपिक है यहाँ पर, तो आजाद करके ही जाएंगे। देखो आज का मकसद, आज का पढ़ाने का स्टाइल अलग होगा, याद करवाना मेरा मकसद है, समरी के हिसाब से याद करवाना मेरा मकसद है। अगर आपको इंडिविजुअल लेवल पे वीडियो चाहिए तो हर एक वीडियोस में बना चुका हूं, ऑलरेडी यूट्यूब में अवेलेबल है, उसको देखिए। आज केवल समरी है और आप लोगों का रिवीजन है। ठीक है, चलिए अब मैं शुरू करता हूं मुस्लिम लीग के बाद मॉर्लिमिंटो रिफॉर्म। सूरत एक सूरत स्प्लिट है, उसके बाद आते हैं मॉर्लिमिंटो रिफॉर्म। ठीक है, हाँ एक कलकत्ता सेशन भी है, पहले वो डिस्कस कर लेते हैं कि कैलकाटा सेशन एक छोटा सा टॉपिक है, दैट इज कैलकाटा सेशन सेम ईयर 1906 में हुआ था। कलकत्ता, देखो सेशन का मतलब क्या है, अब देखो आईएनसी जो है, आईएनसी जो है इंडियन नेशनल कांग्रेस है। देखो आईएनसी के बारे में थोड़ा सा मैं बता देता हूं, व्हाट डू यू अंडरस्टैंड बाय द आईएनसी? आईएनसी का मतलब होता है इंडियन नेशनल कांग्रेस, भारतीय राष्ट्रीय कांग्रेस, इंडियन नेशनल एंड कांग्रेस। देखो आईएनसी का गठन कब हुआ था? 1885 में हुआ था। तो आईएनसी का जो एस्टैब्लिशमेंट है 1885 में हुआ था, है ना? और उसके फाउंडर कौन जो थे? फाउंडर वाज ए.ओ. ह्यूम, ये तो सबको पता होगा, ए.ओ. ह्यूम, जो कि ब्रिटिशर्स थे, ये तो सबको पता है। ए.ओ. ह्यूम वाज द फाउंडर। और अगर पूछा जाए यहां पर कि हु वाज द फर्स्ट प्रेसिडेंट ऑफ आईएनसी, फर्स्ट प्रेसिडेंट, बताइए। ये तो बहुत सिंपल सवाल है, बहुत सिंपल सवाल है, ये तो सबको पता होगा। फर्स्ट प्रेसिडेंट ऑफ आईएनसी जो है, आईएनसी के फर्स्ट प्रेसिडेंट उमेश चंद्र बनर्जी। तो ये चीजें तो सबको पता होगा, सिंपल सी बात है कि आईएनसी का गठन जो है 1885 में, फाउंडर वाज ए.ओ. ह्यूम और फर्स्ट प्रेसिडेंट वाज उमेश चंद्र बनर्जी। देखिए, तो कलकत्ता सेशन का मेरा मतलब ये था जो 1906 में हुआ था कि आईएनसी जो है हर एक साल उसका मीटिंग होता है। आईएनसी का, इंडियन नेशनल कांग्रेस जो है, हर एक साल उसका अपना अपना मीटिंग होती है। कभी लखनऊ में, कभी कलकत्ता में, कभी सूरत में, तो कभी बॉम्बे में, कभी दिल्ली में, तो हर एक साल उसका अलग अलग मीटिंग होती है। तो ये जो है कलकत्ता में हुआ था, इसलिए उसको कलकत्ता सेशन कहा जाता है। और वही सेशन का मैं जिक्र करूंगा जिस सेशन का कुछ ना कुछ इंपोर्टेंस रहा है। ठीक है, देखो ये कलकत्ता सेशन जो 1906 में हुआ था, उस टाइम पे जो प्रेसिडेंट जो थे दादा भाई नारोजी, तो लिख लो कलकत्ता सेशन। यहां पर जो कलकत्ता सेशन, देखो मैंने यहां पर बताया था जो उमेश चंद्र बनर्जी है आईएनसी के फर्स्ट प्रेसिडेंट थे। बट अगर पूछा जाए कि कलकत्ता सेशन में अगर पूछा जाए कि कलकत्ता सेशन में प्रेसिडेंट कौन थे, देन होगा दादा भाई नारोजी। He was the president of the कलकत्ता सेशन। और कलकत्ता सेशन में एक चीज का डिमांड किया गया था, वो पहली बार जो है स्वराज का डिमांड किया था, जो कि सेल्फ गवर्नमेंट कहा जाता है, स्वराज का डिमांड किया गया था। अगर यहां पर पूछे जाते हैं कि व्हाट वाज द डिमांड ऑफ कलकत्ता सेशन, डिमांड किया था, देन दैट इज स्वराज। तो पहली बार जो है यहां पर स्वराज का मांग किया गया था। फर्स्ट डिमांड वाज द स्वराज। स्वराज को क्या कहते हैं? स्वराज, और यू कैन से सेल्फ गवर्नमेंट, तो यहां पर कभी कभी क्वेश्चन आता है कि स्वराज का डिमांड कौन सा अधिवेशन में पहली बार किया गया था, तो कलकत्ता सेशन होगा। या फिर सेल्फ गवर्नमेंट का डिमांड पहली बार कौन सा अधिवेशन में किया गया था, तो होगा दैट इज कलकत्ता सेशन। कौन सा ईयर में? 1906 में। हु वाज द प्रेसिडेंट एट द टाइम? दादा भाई नारोजी। अब स्वराज का मतलब क्या है? देखो एक चीज मैं बता दूं, जवाहरलाल नेहरू जब प्रेसिडेंट थे 1929 में वो क्या डिमांड था, पूर्ण स्वराज का डिमांड था, कंप्लीट इंडिपेंडेंट वाला डिमांड था। पूर्ण स्वराज क्या है, मतलब कंप्लीटली ब्रिटिशर भाग जाएंगे और हमें पूर्ण स्वराज मिलेगा। वो तो समझ में आ रहा है, पूर्ण स्वराज, कंप्लीट इंडिपेंडेंट। तो यहां पर पूर्ण स्वराज नहीं था, यहां पर मकसद क्या था, स्वराज, सेल्फ गवर्नमेंट, मतलब हमें भी कुछ पावर दीजिए। यू कैन से आमतौर पर बताऊं तो 50%, मतलब आप लोग भी रूल करिए बट हमें भी कुछ पावर दीजिए। दैट इज द मीनिंग ऑफ स्वराज हियर, दैट इज द मीनिंग ऑफ स्वराज हियर। क्लियर है पॉइंट? तो स्वराज का मतलब यहां पर ये है, ठीक है, कि 50% गवर्नमेंट मान सकते हो यहां पे। क्लियर है पॉइंट? अब आता है वन ऑफ द मोस्ट इंटरेस्टिंग टॉपिक, दैट इज द सूरत स्प्लिट। अगला टॉपिक पे आता हूं, ठीक है। अगला टॉपिक जो है वो है सूरत विभाजन, सूरत स्प्लिट। और सूरत स्प्लिट जो है बेटा कब हुआ था, 1907 में हुआ था। सूरत स्प्लिट को, उसको स्प्लिट ऑफ आईएनसी भी कहा जाता है। सूरत स्प्लिट इज ऑल्सो नोन एज स्प्लिट ऑफ आईएनसी, स्प्लिट ऑफ आईएनसी, इंडियन नेशनल कांग्रेस का स्प्लिट भी उसको कहा जाता है, स्प्लिट ऑफ आईएनसी भी कहा जाता है, सूरत स्प्लिट। अब सूरत स्प्लिट में क्या हुआ था, देखिए सूरत स्प्लिट में जो है दो पार्टी में बट गए थे। कौन सा दो पार्टी, एक है गरम दल और एक है नरम दल, ठीक है। सूरत स्प्लिट में दो पार्टी में बट गए थे, एक है गरम दल एक्सट्रीमिस्ट और एक है मॉडरेट। एक है एक्सट्रीमिस्ट एक्सट्रीमिस्ट को क्या कहा जाता है, गरम दल कहा जाता है। एक्सट्रीमिस्ट ऑल्सो नोन एज गरम दल, गरम दल, एक्सट्रीमिस्ट को गरम दल कहा जाता है। और एक है मॉडरेट्स, मॉडरेट्स, और मॉडरेट्स को क्या कहा जाता है, नरम दल, नरम दल। मॉडरेट्स इज नोन एज नरम दल, ठीक है। तो सूरत अधिवेशन में दो पार्टी में बट गया था, ध्यान रखना ये दिस इज कंसिडर्ड टू बी वन ऑफ द मोस्ट इंपोर्टेंट टॉपिक इन द इंडियन हिस्ट्री, दैट इज सूरत स्प्लिट। सूरत का विभाजन क्यों हुआ था, व्हाट वाज द मेन पर्पस ऑफ द सूरत स्प्लिट, ठीक है। बहुत सारे रीजन है सूरत स्प्लिट का। तो सूरत विभाजन में आईएनसी का दो भाग में डिवाइड हुआ गया था, ठीक है। इंडियन नेशनल कांग्रेस, तो स्प्लिट ऑफ आईएनसी भी कहा जाता है उसको। तो आईएनसी दो भाग में बट गया था, एक है एक्सट्रीमिस्ट में और एक है मॉडरेट में। एक्सट्रीमिस्ट इज नोन एज गरम दल और मॉडरेट इज नोन एज नरम दल। अब पहले सुन लीजिए स्टोरी। तो दोनों बटने का सबसे पहला रीजन तो ये था कि दोनों के लीडर्स अलग अलग थे, दोनों के लीडर्स टोटली अलग अलग थे। उनका चिंता, उनका जो मेंटल थॉट अलग था, उनका प्रोसेस अलग था, उनका तरीका अलग था। कैसे? एक्सट्रीमिस्ट के जो लीडर थे लड़ाकू वाले थे, गरम खून वाले थे। वो लीडर तो आपको पता होगा, लाल बाल पाल, लाला लाजपत राय, बाल गंगाधर तिलक एंड बिपिन चंद्र पाल। और उनको सहयोग दिए थे जो है अरविंद घोष। तो दीज वर द लीडर ऑफ द एक्सट्रीमिस्ट, जो गरम दल लड़ाकू वाले थे। मॉडरेट्स के जो लीडर थे थोड़ा सा मैच्योर थे, थोड़ा सा सहनशील वाले थे, थोड़ा सा पैसेंस वाले थे, थोड़े से नॉन एग्रेशन वाले थे, ठीक है, पैसेंस के साथ काम करना। तो उसमें से दादा भाई नारोजी थे, रास बिहारी बोस थे, गोपाल कृष्ण गोखले थे। तो ये सब जो लीडर थे वो है मॉडरेट के लीडर थे। उसके बाद दोनों में डिफरेंस ये था, गरम दल वाले चाहते थे दे वांट कंप्लीट इंडिपेंडेंट, एक्सट्रीमिस्ट दे वांट कंप्लीट इंडिपेंडेंट, किसी भी हाल में पूर्ण स्वराज के साथ समझौता नहीं करना है, दे वांट कंप्लीट इंडिपेंडेंट। उनका मानना है कि स्वराज जो है, पूर्ण स्वराज जो है हम लोगों का जन्मसिद्ध अधिकार है और हमें किसी भी हाल में चाहिए। हमें ब्रिटिशर के सामने अपने स्वराज के लिए भीख नहीं मांगेंगे, कंप्रोमाइज नहीं करेंगे, हमें पूर्ण स्वराज चाहिए। बट नरम दल क्या चाहते थे, हमें जो है स्वराज तो चाहिए, उनको भी पूर्ण स्वराज चाहिए, बट अभी जो है केवल स्वराज दे दो, धीरे धीरे डोमिनियन स्टेटस देना, धीरे धीरे आजादी देना, मतलब धीरे धीरे, मतलब ब्रिटिशर के साथ अच्छा रिलेशनशिप बना के ट्रांसफर ऑफ द पावर वो चाहते थे। मतलब पहले स्वराज, देन डोमिनियन स्टेटस, देन धीरे 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 धीरे, मतलब एक साथ पूर्ण स्वराज नहीं चाहते थे। उनको लगता था कि पूर्ण स्वराज की बात करेंगे ब्रिटिशर और भी ज्यादा एक्सप्लॉइट करेंगे, और भी ज्यादा खराब हम लोगों के ऊपर जुल्म करेंगे, इसलिए रिलेशन अच्छा बना के धीरे 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 पावर चाहते थे। क्लियर है पॉइंट? और एक डिफरेंस था कि गरम दल का जो तरीका था, लड़ने का जो तरीका था वो है वायलेंस था, हिंसात्मक था। वो लड़ना चाहते थे, मतलब किसी भी हाल में ब्रिटिशर को भगाना चाहते थे। से दे डजंट वांट टू कंप्रोमाइज विद द ब्रिटिशर्स, दे वांट टू फाइट अगेंस्ट द ब्रिटिशर्स। बट मॉडरेट का जो कंसेप्ट था वो ब्रिटिशर के साथ लड़ना नहीं चाहते थे। दे डजंट वांट द वायलेंस मेथड ऑफ स्ट्रगल, स्ट्रगल का मेथड वायलेंस नहीं चाहते थे, वो नॉन वायलेंस चाहते, अहिंसा चाहते थे और ब्रिटिशर के साथ अच्छे रिलेशनशिप मेंटेन करना चाहते थे। क्लियर है? और एक चीजों में डिफरेंस हुई थी कि गरम दल, जो आईएनसी का जो लीडर बनेगा वो गरम दल से ही बनेगा। समझ रहे हो? ये क्या किसका डिमांड था? गरम दल का डिमांड था। और स्वाभाविक चीज है, मॉडरेट का क्या डिमांड था कि आईएनसी का जो लीडर बनेगा वो नरम दल से बनेगा। और फाइनली क्या हुआ था, आईएनसी का लीडर जो रास बिहारी बोस है उसको जो है सूरत अधिवेशन में आईएनसी का लीडर बना दिया गया, जिसकी वजह से गरम दल पार्टी छोड़कर, आईएनसी को छोड़कर चले गए थे। इसलिए इसको सूरत स्प्लिट कहा जाता है, क्योंकि सूरत में यह अधिवेशन हुआ था और गरम दल और नरम दल में दोनों में विभाजन हो गया था टोटली। फर्स्ट है दोनों का लीडर अलग अलग, सेकंड है दोनों का डिमांड अलग अलग, थर्ड है दोनों का तरीका अलग अलग, और फोर्थ में दोनों का लीडर्स भी अलग अलग हो गया था। इसलिए गरम दल जो है अलग हो गया था आईएनसी से, मतलब स्प्लिट हो गया था। दैट्स व्हाई उसको आईएनसी स्प्लिट कहा जाता है और सूरत स्प्लिट भी कहा जाता है। सूरत स्प्लिट इसलिए कहा जाता है क्योंकि ये मीटिंग जो है सूरत में हुआ था। पर ध्यान रखना, पार्टीशन ऑफ बंगाल वो बंगाल का विभाजन हुआ था, ईस्ट बंगाल वेस्ट बंगाल में। यहां पर पार्टीशन ऑफ सूरत और सूरत स्प्लिट, मतलब सूरत का स्प्लिट नहीं हुआ है, यहां पर आईएनसी का स्प्लिट हुआ है गरम दल और नरम दल में। क्लियर है पॉइंट? तो जो पॉइंट मैंने एक्सप्लेन किया है वो पॉइंट सब लिख लो। पहला पॉइंट क्या मैंने बताया था कि फर्स्ट पॉइंट मैंने बताया था कि दोनों के लीडर्स अलग अलग थे। दोनों के पहला पॉइंट में क्या हमने जिक्र किया था कि दोनों के गरम दल और नरम दल दोनों के लीडर्स अलग अलग थे। तो पहला चीज क्या है कि लीडर्स ऑफ, मतलब गरम दल जो थे, मैंने बताया था आप लोगों को, लाल, बाल और पाल। लाल फर लाला लाजपत राय, लाला लाजपत राय। बाल फर बाल गंगाधर तिलक, बाल गंगाधर तिलक। और पाल फर बिपिन चंद्र पाल, बिपिन चंद्र पाल। प्लस उनको साथ दिए थे, उनके साथ लाल बाल पाल को अरविंद घोष, अरविंद घोष। तो ये लीडर को याद रखना जरूरी है, लाल बाल पाल एंड अरविंद घोष। दीज आर द लीडर ऑफ, आप लोग लिख लीजिए, दीज आर द लीडर ऑफ जो है एक्सट्रीमिस्ट। मॉडरेट के जो लीडर थे दादा भाई नारोजी, दादा भाई नारोजी, रास बिहारी बोस, रास बिहारी बोस, मोतीलाल नेहरू, मोतीलाल नेहरू, गोपाल कृष्ण गोखले, गोपाल कृष्ण गोखले। तो ये लीडर थे। पहला चीज है दोनों के लीडर्स अलग अलग, ठीक है, ये लीडर थे दोनों के अलग अलग, ध्यान रखना। तो मॉडरेट लीडर जो है लाल बाल पाल, लाल फर लाला लाजपत राय, बाल फर बाल गंगाधर तिलक और पाल फर बिपिन चंद्र पाल। एक और उनको साथ दिए थे अरविंद घोष, वो थोड़ा सा लड़ाकू थे। और नरम दल के नेता दादा भाई नारोजी, रास बिहारी बोस, मोतीलाल नेहरू एंड गोपाल कृष्ण गोखले। और भी लीडर थे, बट दीज आर द प्रोमिनेंट और दीज आर द मेन लीडर्स, दीज आर द प्रोमिनेंट एंड दीज आर द मेन लीडर्स। क्लियर है पॉइंट? ये तो फर्स्ट पॉइंट की बात कर रहा था मैं। अब जो है मैं दूसरा पॉइंट की बात कर रहा हूं, ठीक है, सेकंड पॉइंट की मैं बात कर रहा हूं, ठीक है। ये तो पहला पॉइंट में लीडर थे। अब दूसरा पॉइंट ये है ठीक है, हो गया, लिखना हो गया लीडर का। अब देखिए दूसरा पॉइंट, फर्स्ट पॉइंट हो गया, अब लिखिए दूसरा पॉइंट। सेकंड पॉइंट में कि मेन डिमांड ऑफ एक्सट्रीमिस्ट क्या था, उनका मेन डिमांड क्या था। उनका मेन डिमांड था एक्सट्रीमिस्ट का कंप्लीट इंडिपेंडेंट, कंप्लीट पूर्ण स्वराज। वो किसी भी हाल में पूर्ण स्वराज के साथ समझौता नहीं करना चाहते थे। दे डजंट वांट टू कंप्रोमाइज विद द पूर्ण स्वराज, किसी भी हाल में पूर्ण स्वराज के साथ कंप्रोमाइज नहीं करना चाहते। कंप्लीट इंडिपेंडेंट वाज देयर मकसद। और उनका मेन डिमांड क्या था? मेन डिमांड था केवल स्वराज और यू कैन से सेल्फ गवर्नमेंट, जो कलकत्ता सेशन का मांग था, सेल्फ गवर्नमेंट। मतलब यहां पर देखो, दे डजंट वांट टू कंप्रोमाइज विद द ब्रिटिशर्स। ये लोग जो है ब्रिटिशर के साथ किसी भी हाल में कॉम्प्रोमाइज करने के लिए तैयार नहीं थे, बट ये लोग थोड़ा सा ब्रिटिशर के साथ कॉम्प्रोमाइज करने के लिए तैयार थे। मतलब ये लोग जो है, उनका मानना था कि अपना आजादी के लिए ब्रिटिशर से हमें भीख नहीं मांगना है, जरूरत पड़ने पर उनसे लड़ना है, उनको भगाना है, उनको खदेड़ना है। उनका मकसद ये था, पूर्ण स्वराज के साथ समझौता नहीं करना है। बट उनका जो है ये समझौता कर रहे थे। उनको लग रहा था कि ब्रिटिशर के साथ हम लोग लड़ाई करेंगे तो शायद वो और भी ज़्यादा हम लोगों के ऊपर रूल करेंगे, और हम लोग, उनको लग रहा था कि सोशली, पॉलिटिकली, कल्चरली, इकोनॉमिकली जो है ब्रिटिशर ज़्यादा पावरफुल है, माइटी है, ज़्यादा है, उनको हम लोग नहीं हरा सकते। इसलिए धीरे धीरे वो ट्रांसफर ऑफ द पावर चाहते थे, क्योंकि उस टाइम पर उनको लग रहा था कि भारत के लोगों में यूनिटी नहीं है, भारत के लोगों में सोशली, पॉलिटिकली, कल्चरली, इकोनॉमिकली ब्रिटिशर ज़्यादा पावरफुल हैं, वो लोग रूल करेंगे। तो ये इसी चक्कर में ये लोग धीरे धीरे ट्रांसफर ऑफ द पावर चाहते थे। थर्ड जो रीजन था कि उनका जो तरीका था वायलेंस मेथड ऑफ स्ट्रगल था, और उनका तरीका था नॉन वायलेंस मेथड ऑफ स्ट्रगल। तो थर्ड में क्या है? दे प्रीफर, एक्सट्रीमिस्ट प्रीफर वायलेंस मेथड ऑफ स्ट्रगल, वायलेंस मेथड ऑफ स्ट्रगल। उनका जो लड़ने का जो तरीका था वो हिंसात्मक था। उनका लड़ने का जो तरीका था वो हिंसात्मक था, वायलेंस मेथड ऑफ स्ट्रगल। मतलब तोड़ फोड़, ब्रिटिशर को भगाना है, खदेड़ना है, उनसे कॉम्प्रोमाइज नहीं करना है। बट उनका जो तरीका था वो वायलेंस है, ये नॉन वायलेंस मेथड ऑफ स्ट्रगल, नॉन वायलेंस मेथड ऑफ स्ट्रगल, वायलेंस, नॉन वायलेंस। एक और चीजों में दोनों में बहसबाजी हुई थी, जो फोर्थ नंबर पॉइंट में बताऊंगा, कि ये लोग चाहते थे कि उन्हीं का लीडर जो है प्रेसिडेंट बने, ठीक है, उन्हीं का लीडर प्रेसिडेंट बने। तो ये लोग चाहते थे जो लाल या फिर बाल, दोनों में से किसी को प्रेसिडेंट बना दिया जाए, चाहे लाला लाजपत राय हो, चाहे बाल गंगाधर तिलक हो, दोनों में से प्रेसिडेंट बनाया जाए, ठीक है। ये जो है फोर्थ नंबर पॉइंट पे है। ये लोग अपना लीडर का प्रेसिडेंट बनाना चाहते थे, और ये लोग जो है अपना लीडर को प्रेसिडेंट बनाना चाहते थे रास बिहारी बोस को प्रेसिडेंट बनाना चाहते थे। एंड फाइनली जो है रास बिहारी बोस को प्रेसिडेंट बनाया गया सूरत सेशन में, जिसकी वजह से ये लोग जो है गरम दल पार्टी छोड़कर चले गए थे, आईएनसी को छोड़ के चले गए थे। क्लियर है? फाइनली रास बिहारी बोस वाज द प्रेसिडेंट ऑफ आईएनसी, दैट्स व्हाई गरम दल जो है पार्टी छोड़कर चले गए, दैट्स व्हाई इट्स नोन एज सूरत स्प्लिट, क्योंकि सूरत में आईएनसी का स्प्लिट हो गया था गरम दल और नरम दल में, इसलिए उसको सूरत स्प्लिट कहा जाता है। क्लियर है? पॉइंट क्लियर है? तो यहां पर याद करने वाला चीज है, सूरत स्प्लिट कब हुआ था? 1907 में। सूरत स्प्लिट इज ऑल्सो नोन एज आईएनसी स्प्लिट। पहला चीज क्या है? उन्हीं का लीडर है लाल बाल पाल अरविंद घोष। उसके बाद उन्हीं का लीडर है दादा भाई नौरोजी, गोपाल कृष्ण गोखले, मोतीलाल नेहरू, रास बिहारी बोस। सेकंड क्या है? कंप्लीट इंडिपेंडेंट। ये क्या है? स्वराज और सेल्फ गवर्नमेंट। ये क्या है? वायलेंस मेथड ऑफ स्ट्रगल। ये क्या है? नॉन वायलेंस है। ये लोग किसको चाहते थे? लाला लाजपत राय या फिर बाल गंगाधर तिलक। और ये लोग किसको चाहते थे? रास बिहारी बोस। फाइनली कौन बने थे? रास बिहारी बोस, जिसकी वजह से गरम दल को लग रहा था कि उनकी बातें का कोई तवज्जो ही नहीं है, इंपोर्टेंस ही नहीं है, ये लोग कुछ मान भी नहीं रहे हैं, तो चलो पार्टी छोड़कर चले जाते हैं। तो यही चीजें हुआ था सूरत स्प्लिट में। क्लियर है पॉइंट? अब देखो, अब चीजें बात करेंगे मॉर्ले मिंटो रिफॉर्म्स की बात करेंगे। अब अगला टॉपिक पे आते हैं। नेक्स्ट टॉपिक है दैट इज मॉर्ले मिंटो रिफॉर्म्स। नेक्स्ट टॉपिक, मूव ऑन द नेक्स्ट टॉपिक दैट इज मॉर्ले मिंटो रिफॉर्म्स, अगला टॉपिक। तो ये था सूरत स्प्लिट, मॉर्ले मिंटो रिफॉर्म, ये हुआ था 1909 में हुआ था। ठीक है, ध्यान रखना, मॉर्ले मिंटो रिफॉर्म जो हुआ था 1909 में हुआ था। अब मॉर्ले मिंटो